general meetings. Okay, so first things, general meeting. What are the two types of general meeting? One is AGM, one is EGM. AGM conducted at least once in a year. Annual general meeting. It is conducted within. What is it? General meetings, people. What are the different types of meetings? One is general meeting, one is board meeting. And next one is called as class meeting. Class meeting is nothing but any meeting conducted for a specific security holder. Imagine it can be for preference alone. It can be for equity alone. It can be for debentures alone. We call it as what people? Class meetings. Whatever is the procedures, whatever the rules applicable for your the general meeting, same thing will apply even for the class meeting as well. And different types of meeting in our syllabus for general meeting we have two. One is called AGM, one is called EGM. Section 96 says a company has to conduct its AGM. The first AGM has to be conducted within 9 months of its closure of its financial year. Any subsequent AGMs has to be conducted within 6 months of the closure of financial year. So first AGM within 9 months, subsequent AGMs has to be conducted within 6 months of the closure financial year. And remember, the gap between two AGMs should not exceed 15 months. The gap between two AGMs should not exceed 15 months. So if you conduct one meeting today, now imagine in the month of April if you have conducted, then the next AGM people you should conduct it within you have to conduct it within 15 months. You have to calculate your 15 months here. Imagine if April 30th was my last meeting, then what will happen? April to May will be my 12 months. Okay. April to March will be my 12 months. April 30th, let us imagine we conducted our meeting. Then what happens? I'll start counting my month from April, May from 1st May to April, it will be 12 months. May to April is 12 months, and April, May, June, July. Now July will be my 15th month. I have to conduct my meeting, the next meeting within July. That is how you need to calculate your 15 months. Extension, if at any given point of time, if I am not able to conduct an AGM, this is not applicable for the first AGM, but for the subsequent AGM, I can always ask for extension. A one-time extension of 3 months will be granted. Where should I conduct my AGM? Remember, 3 questions can come here. 1, if you are a listed company, you need to conduct your AGM in the registered office or within the same city or town or village where your registered office is. If at all you are a unlisted company, you can conduct your AGM anywhere in India, provided it has to be first approved by all the shareholders. The answer is all. If you are a government company, you can conduct your AGM anywhere in India, provided the CG will decide where it is conducted. Remember this, very important exam point of view. You can conduct AGM any day except the national holiday, and you will conduct the AGM between 9 to 6. Once the AGM is done, you will file the report on AGM, what was discussed, what is the resolution passed, how many people voted, everything. You will file it with ROC in the form, according to section 121, to be filed by ROC with the ROC in 30 days of conclusion of the AGM. Remember that. Remember, section 96 is the AGM. The first meeting should be conducted within 9 months. The subsequent meeting should be conducted within 6 months. The time to conduct the AGM should be between 9 to 6. The AGM, the gap between two AGMs should not exceed, should not exceed 15 months. And if at all we are not able to conduct the meeting within 9 months, I can ask for extension of 3 months. Using 9(6), you can literally write the entire section. Remember, mere coincidence. That is section 96. Once 96 is done, the next section is people, section 100. What is section 100? EGM. EGM can be conducted by the company whenever the directors think so, whenever they want, they can conduct. Remember, EGM of a company which is can be held in any place in India. However, if it's a wholly owned subsidiary, it can be conducted even outside India as well. AGM cannot be conducted outside India. If you are a wholly owned subsidiary of a foreign company, you can conduct your EGM outside India, not AGM. Next one, EGM conducted by directors based on the request made by shareholders. How many people have to make a request? If a company has a share capital, then people holding at least 1/10 of the paid up share capital. If it is not having share capital, then 1/10 of the total voting power. So many people have to make a request to conduct a EGM. Hello? Board shall proceed to call the meeting within 21 days of the request. So I made a request today. The board has to start making notices or anything within 21 days. And remember, people, whichever is the EGM conducted by the, okay, I'll tell that to you. Convene a meeting in 45 days from the request. And whoever are the people who made the request, everyone has to sign this EGM, or if everyone is practically not possible to sign, they can authorize one person to sign the EGM notice on everyone's behalf. This is something which is very irritating me. I don't know when. I missed it. Okay. So you need to take steps in calling for the EGM within 21 days, like calling for a meeting and all, sir, and you have to conduct the meeting within 45 days. What if they did not do any of it? Then people, within 3 months from the date of making the request, the shareholders themselves can conduct the EGM. And remember, for the EGM conducted by the shareholders, you need not have to give any explanatory statement. It is okay, it is exempted. And even if one person signs, it is sufficient. Not entire requisionists need not sign. If they authorize one person, that person can sign. That is sufficient. Remember that. And whatever is the EGM conducted by the requisitionist, whoever made the request, the company shall give them all the details of shareholders, because register of members, everything should be given. Expenses shall be reimbursed by the company, which shall be deducted from the director's remuneration. To conduct a meeting, of course, they have to spend some money. That you spend first from your pocket, the shareholders. Later, we will take it from the director's salary and we will give it to you. Next one, if quorum is not present within half an hour, because it is a requisitionist's meeting, people, it will be cancelled. What about other meeting? If a quorum is not present within half an hour, people, the meeting shall be adjourned to the next week, same time, same date, automatically, or such other date as decided by the board. Remember, for the adjourned meeting, again we will give a notice of at least 3 days. We will give at least 3 days notice for the adjourned meeting as well. But if the adjourned meeting is conducted anytime after 30 days, then you have to treat the adjourned meeting like a new meeting only. You have to give fresh notice of 21 days and you have to follow everything. Remember, it should be held at registered office or within city, town or village. Which one? The requisitionist meeting. And remember, if at all requisitionist meeting, if at all we did not give any notice to any person, and if it was accidental, voluntarily we didn't do it, was accidental, it will not invalidate the meeting, it will still be valid. Accidental omission is, it will still keep the meeting as valid only, it will not make the meeting invalid. That is section 96, section 100. What is section 97? If at all the AGM is not conducted, then upon an application, tribunal may tell the company to conduct an AGM. That is section 97. Tribunal conducted AGM. 98. Tribunal conducted EGM. 99. If at all the company does not comply with 96 to 98, then they will be paying a penalty. Remember that. 100. Done na? 101, what is 101 people? 101 is nothing but notice of a general meeting. Agreed? Hello? Okay. Notice of a general meeting. And AGM does the top 100 listed companies based on market capitalization. They need to conduct their AGM within 5 months of the closure of financial year. Remember that. Should OPC conduct AGM? Answer is no. Penalty for not conducting AGM. If any default is made in complying or holding a meeting of the company and every officer of the company who is in default shall be liable with fine, which may extend to 1 lakh rupees, and in case of continuing default with a further fine, which may extend to 5,000 rupees each day, during which such default continues. Okay. Next one, people. Notice of a general meeting, a company shall give how many days notice? It shall give at least 21 days clear notice. If it is a section 8 company, people, it will be read as 14 days clear notice. Can I conduct the meeting in a shorter notice? Possible. It depends upon which type of meeting. If it is a AGM, then the consent has to be given by 95% of the members who are entitled to vote. That means what can I say? Equity. So I have to, in case of AGM, by not less than 95% of the members entitled to vote. In case of any other general meeting holding, if the company has a share capital, then majority in number entitled to vote and who represent not less than 95% of paid up share capital are in value. What do I mean by that, people? If I want to conduct an EGM by shorter notice, then they're telling I need to satisfy people. This is majority number of members. Out of 10 people, I should take an approval from 9.5. Not possible. Imagine I have 100 people. I need to take an approval from 95 people. In the case of EGM, what does the law say? You need to get an approval from majority number. That means, let us imagine if I have 100 people, I need to get an approval from 51 people, and this 51 people should hold 95% of the paid up share capital. I need to satisfy both conditions in the case of EGM. Remember, important. If the company has no share capital, then 95% of total voting power. That is important. Next one. The notice shall have agenda, proxy. You have a right to appoint proxy. Is it optional? Mandatory. Every member has a right to appoint proxy. Persons entitled to receive notice, will give it to every member. That is equity, preference, and their legal representative in the case of death. Assignee in the case of insolvent. We will give it to auditors also. Every director of the company. And in the case a private company which is not a subsidiary of public company may prescribe by its articles to whom the notice should be given. I can even tell it in my notice, in my agenda, in my articles of association, who are eligible to get the notice of the meeting. I can still say that. Where the securities are held singly, I can give it to the nominee of the single holder. Where securities, this is in the case of what? In the case of death. In the case of joint shareholders, we will give it to the surviving joint shareholder. If all the joint shareholder dies, then whoever is the nominee, we will give it to that person. Okay. Okay, next one is people section 102. What is 102? 102 is explanatory statement. It is mandatory only for a special business. Ordinary business is adda. Appointment of auditor, declaration of dividend, and what is that? Appointment of director in the case of retiring director. And next one is adoption of financial statements. So these four cases are adda, ordinary business. This has to be mandatorily conducted in AGM. Anything other than these four can be conducted in AGM or EGM. And remember, whenever you are discussing any matter other than ordinary business, you need to mandatorily give something called as explanatory statement. This is mandatory. So, sir, what do we give in that? You will give what to disclose. Any direct holding or indirect holding. Imagine, if at all a company X is entering into a contract with company Y, and my directors are interested in this. That means, let us imagine, if at all this contract goes through, it will give me some money. I'm earning some money because of that. Then I need to disclose nature of concern or interest of my director, KMP, and relatives of my KMP and director. What is the interest I have? I need to disclose. Next one, if there is any indirect interest. What do I mean by indirect interest? If business relates to any other company where promoter, director, manager, KMP have shareholding not less than 2% of paid up share capital, shall disclose the extent of shareholding interest. That means what? My directors this time are not having any interest directly, but they have shareholding in that other company. How much? If they have at least 2% of meaning, if they have shareholding not less than 2%, they need to clearly disclose. If this contract goes through, the company by I have a shareholding of, say for example, 4%, it will give me an indirect benefit. We need to disclose this in the notice. If we don't disclose this, people, then remember, any gains made by the director, he needs to hold it on behalf of the company and he has to give it back to the company. Hello. Then next one, people, is section 102, 103. Okay. What is 103, sir? 103 stands for people, your quorum of a meeting. What is quorum? Depends upon what type of company. If you're a public company, then the quorum is whatever is given in your articles of association, or if the number of members in your company is up to 1,000, then 5 members has to be personally present. More than 1,000 up to 5,000, 15 members personally present. Above 5,000, 30 members personally present. Now this will be my quorum. So whatever is given in my AOA or this, whichever is higher. Hello? Private company, nothing but 2 members personally present, or whatever is decided by AOA, whichever is higher. What if no quorum is there? I told you, the meeting will be adjourned if the quorum is not present within half an hour. But if it is a requisition to meeting, the meeting will be cancelled. Are preference shareholders counted for the quorum? Answer is no. If they don't have any direct interest, no. Proxy counted for quorum? No. Equity shareholder? Yes. Authorized representative? Yes. Nominee of president or governor? Yes. Authorized representative of nominee or authorized representative of governor or President of India, their authorized representative, yes, counted. And authorized representative of any company, body corporate, yes, they are all counted for the purpose of quorum. Okay. Chairman of the meeting, generally, who will allot? The member, generally, articles of association will allot the chairman. If articles are silent, people, then the members personally present there will elect one amongst themselves to be the chairman of the meeting. The chairman is not present within 15 minutes, people, then what will happen? Or if no director has been so designated, the directors present shall elect one of themselves to be the chairman. What if even the directors are not present within 15 minutes, sir? Then the members present there will elect one amongst themselves to be the chairman of the meeting. So first chairman, we should check. If he is not there, directors will be the next chairman. If he is also not there, then the members present there will elect one amongst them to be the chairperson. The chairperson shall explain the objective and implication of the resolution. And remember, the chairman will have something called as people casting vote. What do I mean by that? Whenever there are 10 votes, imagine 5 say yes, 5 say no. Now, whenever there is equality of votes, whatever the chairman votes, whatever he says, that will be valid. That is only called as second vote, or that is only called as casting vote. Okay. What is this? A chairman cannot participate in any resolution in which he is interested. For that resolution, he needs to walk out, and after that resolution is decided, you can come back. That is what they're telling you. Adjourn meeting we saw 3 days notice. If it is more than 30 days, you need to give 21 days notice. Okay. An adjourn meeting, you can only discuss people whatever is the unfinished business. You cannot take up any new business in the adjourned meeting. Very important, remember that. Resolution passed at adjourned meeting. Now remember, the first meeting was conducted on, let us imagine, 5th August 2026. The adjourned meeting happened on 21st August 2026. We passed the resolution here. So what will be the date of resolution? Is it the first date or is it the actual date? It is always the actual date where the resolution was passed. From there only you need to count the 30 days or as the case may be. Okay, next one. Proxies. A proxy cannot speak in the meeting. Proxy is not counted for the purpose of quorum. And a proxy cannot vote on show of hands. Then what can proxy do? Proxy can demand poll. Proxy can vote also on poll. If at all a person is sending someone else as proxy, he needs to intimate the company at least 48 hours prior to the date of the meeting. Sir, what if the company says, I am entrenching my articles, it is not 48 hours, I want to make it as 72 hours. Remember, it will not be valid. It should be 48 hours only. Next one, sir. Proxy, a person can represent maximum how many people as proxy? The maximum he can represent is 50. And this is number of people. What is the value he can represent? He cannot represent more than 10% to the total share capital. That's the maximum he can represent. Sir, what if I want to represent 15%? Can I do it? Yes, possible. Provided in such case you cannot represent more than one person. Remember that. Okay, next one. Proxy form will be in the form MGT 11. Inspection of proxy. Can I go and check the proxy forms? Imagine, as a shareholder, I am curious who and all are coming and directly attending the meeting, and who and all are attending the meeting through their proxies. I want to know. Can I know it? Yes. How? Every member entitled to vote, that means equity, at a meeting to be more is entitled to inspect the proxies lodged with the company if at least 3 days notice in writing is given to the company. Meaning I need to intimate to the company at least 3 days prior. I need to come and check the proxy forms. I will intimate. Such inspection can be taken during the period beginning 24 hours before the time fixed for commencement of the meeting during the business hours of the company. What do you mean by that? Imagine if the meeting is happening on 12th of August 2026. They're telling you, when will the meeting start? Let us imagine the meeting will start at 9 a.m. on 12th of August. Then the inspection will start on 11th of August 2026 at 9 a.m. And it will end with the date of the meeting. So 12th, let us imagine the meeting ends at 12. At 12, the inspection also will be closed. Remember, when multiple proxies are appointed, the proxy that is appointed later will prevail, not the one prior. Remember, can preference shareholders appoint proxy? Answer is no, in general. Yes, people. The next one is your voting. So in section 106, what does section 106 say? Restriction on voting rights, correct? Now, in restriction on voting rights, section 106, important. What does it say? The articles of a company may provide that a member shall not exercise any voting right. Now, what if articles does not provide? Now, remember people, if your articles is silent, then you cannot restrict the shareholder from casting his vote. That's the point number one. Next one. Now, my articles can provide that if at all a shareholder does not pay his call money, that is your first call, second call, if you don't pay the call money or any other sum, you have taken loan, you have not paid the loan back, any other sum which is not paid by the shareholder, then people, we can say by articles of association, you will not be able to exercise the vote. You will not have a right to vote. Now people, in no other case, if my articles does not provide or if at all in any other case other than calls or sums not paid, you cannot take away the right to vote from a shareholder. That is what, no member can be prohibited from exercising his voting right on any other ground. Very important, remember. Next one, presence of statutory auditor or secretarial auditor. Remember this people, in the AGM, a notice of AGM should also be given to the auditors. If the auditors are unable to attend the meeting, they need to send someone else to attend the meeting, and whoever attends the meeting shall also be qualified to be present and who should be able to solve the questions, and hence they should also be people auditors only, not a random person cannot come. So if a CA wants to come, if a CA is not able to come, he should send someone who is a CA only. If CS is not able to come, he should send someone who is a CS only. Clear? Okay, next one. Voting by show of hands. Always remember, by default every resolution will be conducted by voting by show of hands only, unless and until a poll is demanded or the postal ballot is done or e-voting is done. Whenever a e-voting is carried on, then you need to do it by the poll. If e-voting is not done, people, remember, by default every meeting will be conducted by voting by show of hands only. Next one, sir, is okay, let us do demand for e-voting. What is e-voting? When is it mandatory? Applicability. E-voting comes into picture for all the listed companies and companies having 1,000 or more members. So listed companies also it is mandatory. Companies having 1,000 or more members also it is mandatory. Non-applicability. So even if I have more than 1,000 members, when it is not required. If you're a Nidhi company or if you're any institutional investors, for you this particular provision will not apply. The notice of e-voting can be sent by any of these methods. The contents of the notice. When I send you a notice of a general meeting, in that I should clearly tell you an option for you to available, the option available for you to choose e-voting. Remember, very, very required and mandatory. What is that? People, there was one question saying that whether e-voting is optional or mandatory. Remember, it is the company's mandate for you to provide e-voting facility. Whether you will choose or not is a secondary thing. The company should give you the option to vote electronically if the e-voting is applicable to you. It's not choice, it is mandatory. You need to clearly say login ID, password, time period. What will be the time period? The e-voting should be open for a minimum period of 3 days. It shall close the day before the meeting at 5 p.m. If the day of the meeting is say 24th of August 2027, the e-voting will conclude on 23 August 2027 at 5 p.m. Remember. And sir, what if I have already done my e-voting? Can I still come and attend the meeting? Answer is yes, but you cannot vote twice. Appointment of scrutinizer. Who can be a scrutinizer? It can be a CA, CS, CMA or an advocate. In practice, or it can be anyone else who is not basically in the employment of the company. So technically you can appoint anyone as a scrutinizer. He will get the access to all the details of the company. The scrutinizer's report will be prepared not later than 3 days of the conclusion of the meeting. Result shall be published on the website of the company, and whosoever gave you this e-voting facility, and even on the stock exchange if at all you are a listed company. Remember, proposed resolutions, once it is done through e-voting, you cannot withdraw those resolutions. That is 108. What is 109? Demand for poll. Poll means what, people? Generally people, one person is equal to one vote. That is the meaning of show of hands. But whenever the voting is done by e-voting, poll, postal ballot, in such case people, remember, it is not one person is equal to one vote. It will be one share is equal to one vote. In this method, me and Mukesh Ambani are same. In this method, Mukesh Ambani and me, there is a huge difference. Any day Mukesh Ambani will win because of the voting he has, because of the shares he has. Remember it. Okay. Now, who can demand for a poll? First one, chairman can order for a poll at his own discretion. Next one, by chairman on a demand made by a company. If the company is having a share capital and people request for a poll, then it can be member or even proxy. Proxy can demand a poll holding 1/10 of the total voting power or rupees 5 lakh or more paid up. Remember, there is nothing called whichever is less, whichever is higher. So if you are holding 1/10 of the total voting power or the paid up value is 5 lakh, you can always demand for a poll. Next one, in the case of any other company, then 1/10 of the total voting power. Such people may request. Now, when can I demand for a poll? Remember, you can demand for a poll even before the declaration of results or even after the declaration of results by show of hands. You can demand the poll whenever you want. And remember, people, I made a request for a poll. Can I take it back? Yes, you can take it back. Poll can be withdrawn by the people whoever made it. And remember, you can withdraw it whenever you want. It can be even before the results, even after the results also you can withdraw. Not after the resolutions and all are drafted, not after the minutes are made. Sir, when should I take the poll? You have to take the poll immediately when the poll is for adjourning the meeting and for deciding the chairman. Then in these two cases, you have to take the poll immediately. In any other case, people, you will take the poll within 48 hours. The polling paper will be in the format MGT12. The scrutinizer again will be appointed. He shall submit the scrutinizer's report in the format MGT13. It shall be submitted to the chairman within 7 days of taking the poll. That is your poll. The next one is called, people, postal ballot. What is the difference between postal ballot and e-voting? Don't get confused. Postal ballot is nothing but, people, for a wider participation of shareholders. That means we want everyone to participate. So what do? We say, let us not conduct a physical meeting. There is no physical meeting conducted. Instead of physical meeting, what do? We just conduct a meeting. It can be in electronic form, it can be in the form of postal card, however you want to do it. But there will be no physical meeting conducted. If you want, you can conduct, but it is not mandatory. So everyone will have a right to vote. In the meeting, what happens? Whoever attends the meeting, they will decide what to do. In a postal ballot, what happens? There will be no physical meeting. So everyone will get a right to participate in the resolution. That is called as what, people? Postal ballot. Now, sir, for whom is postal ballot mandatory? Postal ballot is mandatory for any company if they are discussing any business other than ordinary business. Atta people cannot be done on postal ballot. You have to mandatorily conduct a meeting for this. Next one, any business where directors or auditors have a right to be heard. Can I say that removal of directors and auditors, you have a right to be heard? Now those things you cannot conduct it by a postal ballot. Remember, in our next chapter, directors chapter, this will come. Removal of director, I cannot do postal ballot. Technically, people, section 115, special notice. Next one, postal ballot is exempted for who? For OPC, postal ballot is exempted. Any company having up to 200 members, the postal ballot is exempted. Remember, if you are having up to 200 members, I am not telling it is private company, even public company also can have up to 200 members. No. So up to 200 members, postal ballot is not mandatory for any company, whether you are a public, private or any company. Next one, following items should be mandatorily discussed through postal ballot. Go through this list. It has given various things. It can be alteration of object clause, small shareholder director appointment, variation of object clause, alteration of private company, conversion of private into public, public into private, buyback. All these are the examples. Go through that. Issue of DVR, as the case may be. Scrutinizers. You will again appoint scrutinizer not later than 7 days. Results will be declared on website along with the scrutinizer's report. Okay, done. Circulation of members resolution, section 111. What is circulation of members resolution? A company is conducting AGM. They want to discuss 8 matters. The shareholders want another 1 matter to be also discussed along with these 8 matters. Now, what do we say? We ask the company, sir, can you please also take up this 1 matter? We will give this resolution. What will the company do? The company will take up this matter. It will also further send it to all the other shareholders. Now, request will be made by a certain set of people. That is 1/10 of the people will make a request. The 9/10 of the people are not aware of it. So, the company will send this resolution to the 9/10 of the people. Agreed? Okay. Members can propose resolution for consideration which may be circulated to the other members if the company deems fit. Who can propose? Same as EGM, 1/10. Special conditions, such requisition shall be signed by all requisitionists. Sufficient money should be deposited for meeting circulation expenses. They have to deposit, circulation expenses, whatever is required, you have to deposit. Now, what time I have to deposit this resolution, sir? I have to deposit people. Requisition requiring notice of resolution, I have to give it at least 6 weeks before the date of the meeting. Now, when is the AGM? AGM is conducted on, let us imagine, on 30th September 2027. That is the date of the AGM. Now, what will happen? You need to give at least 6 weeks before. I'm just taking an example as say 13th August 2027. I need to give at least by 13th August 27, at least. Yeah. To be given minimum 6 weeks before. When the requisition require notice of resolution, meaning whatever is the request you are making, that request is such a way that requires a notice of resolution. In such case, I need to give 6 weeks prior. I need to give a request. So, what if it is some other thing where I need not have to give a notice of resolution? In such case, I can give it even people 2 weeks before the date of the meeting. That means the date of the meeting is 30th September. Take 2 weeks. I'm just taking an average. Let us imagine 14th of September 27. So I have to give at least before 14th of September 27 if the request I am making does not require a notice of resolution. Hello? Okay. After depositing, what if the AGM is called before? They are telling you, I gave it 6 weeks before. What if they did not conduct the AGM on 30th September? They instead conducted on 10th September. But I gave it on 14th. After you gave an intimation, if they call for a notice, it is still considered as a valid resolution only. That is your section 111. Done. Next one, people. Section 115. We have already done 1112, 1113, 1114. What is this? This is nothing but authorized representative of body, corporate and governor and president of India. 114 is nothing but people, your ordinary resolution and special resolution. Done. 115 is nothing but resolutions requiring special notice. Whenever people you do not want the same director to continue or same auditor to continue, you want to replace them, then you can make a special request to the company, please remove the auditor or please remove the director. How many people should make a request? It should be at least requested by the people who are holding at least 1% of the total voting power, or people holding at least 5 lakh rupees paid up. Again, same thing here. It does not say whichever is earlier, nothing. So if you are holding 1% of the total voting power, or people, if you are holding at least 5 lakh paid up, you guys can make a request. You need to send a notice to the company. You should at least send 3 months before the meeting. Yeah, to be sent at least 14 days before the meeting. What is that, people? Now imagine the date of the meeting is 30th September 2027. I should send it not more than 3 months before the meeting. That is, take September, August, July. 3 months means, people, I should not send it before 1st July 2027. I should not send it before that. And I should at least send before 14 days before the meeting. I'm just taking 14 days as, take 14 days, count it. Let us imagine it comes to somewhere around, say 16. I'm just taking. I will at least give it by 14 September 27. I should not give it after that. So you should give your request, people, within this time. Then now what will the company do? The company will take the request. They will further forward it to the other shareholders. If possible, you will give individual notice. If individual is not possible, people, then you will publish it on newspaper, and you will also publish it on the website of the company. 7 days notice you will give, English and vernacular. That is your 115. Done. Next one is, what is the other thing? 116 your adjournment of meeting is done. Okay, this is important. 117. 116 is nothing but your adjournment of a meeting. We have done. Section 117 provides that certain things should be mandatorily informed to the registrar. What is that, people? Whenever in a company these things are decided, you need to mandatorily inform to the registrar. How? In the form MGT 14. When? Within 30 days. Sir, when should we do that? Whenever a company passes a special resolution, you need to intimate the registrar mandatorily, because we assume that something really important was discussed. So whenever a company passes a special resolution, you need to mandatorily inform to the ROC within 30 days in the form MGT 14. Sir, when else we need to inform ROC? They're telling you the resolution which the law says you need to pass as a special resolution. Imagine if I'm altering my articles of association, I need to pass special resolution. The law said me to pass special resolution, but in my meeting, everyone agreed. So it became a unanimous approval. Still, law asked you to pass it as special. No, everyone might have agreed, but still, it should be passed as special. So even if everyone has agreed, you will still file it with ROC. Next one. Any resolution of the board of a company relating to the appointment, reappointment, renewal of the main person, managing director. So whenever you are appointing, reappointing, or renewal of the appointment, people, of MD, when such person is appointed, you will mandatorily inform ROC. That's why you see MGT 14 being filed when you are doing the KMP chapter. Remember, MGT 14 will come. The reason is this. Resolutions agreed by any class of members, but which if not so agreed to, remember, people, nothing but variation of shareholder rights. So there this will come, no, same thing will come, right? Whenever, if it is agreed by a certain set of preference shareholders, again you will file in the form MGT 14. Resolutions requiring for a company to be wound up. So when you decide to wind up, intimate ROC. Resolution passed according to section 179. What is 179? Powers of the board. Any other resolution or agreement as may be prescribed. So when all of these people are discussed, you will file it in the form MGT 14 with ROC. Next one, people, minutes of the meeting, section 118. Remember, you need to prepare minutes of the meeting for every meeting. You have to maintain a separate register. It can be for board, it can be for general. You have to maintain different minutes. Whenever you are maintaining minutes, remember, you have to also follow SS1 and SS2 for all your meetings of board and general meeting. You have to follow SS1 and SS2 mandatorily. Next one, the minutes of the meeting can be maintained in electronic form provided. You need to have a timestamp, mandatory. The minutes of the meeting shall be consecutively numbered. All the pages has to be consecutively numbered and no page can be left blank. You have to score it off. And remember, the minutes of the meeting cannot be pasted, copied, tampered, altered, nothing can be done. And the minutes can be maintained in three forms. One is electronic form, one is in a book form, one is in a loose leaf form, meaning in a single paper. Whenever you are maintaining in a single paper, you have to periodically bind them. The periodically is at least once in 3 years. You have to bind them. Place of keeping minutes will always be at the registered office of the company. The general contents of the meeting will be people who and all were present, where was the meeting conducted, what time it started, what time it ended, all that will be the general content. What will be the specific content? The quorum, the number of people present, who were present, all of that will be specific matters. Minutes of e-voting and postal ballot, it is nothing but you have to summarize even the minutes of the e-voting as well as postal ballot. It should still form part of your minutes of the meeting, mandatory. Recording of the minutes, very important. Can the chairman delete any content from the minutes? Yes, possible. Which one? If the chairman thinks if anything is defamatory to any person, or if anything is irrelevant, or if anything is immaterial, or if anything is detrimental to the interest of the company, these four things, the chairman has a right to eliminate it from the minutes, but you cannot eliminate any other information. And minutes are always prepared in the language of third person. That is, it is always prepared in the past tense. Entry in the minutes book, remember, within 15 days, the draft of the minutes will be prepared. It will be sent to all the directors present in the meeting once they confirm. It will be signed within 30 days. Who will sign? The chairman of the meeting shall sign. What if the chairman of the meeting is not available? If it's the board minutes, then the chairman of the current meeting or the chairman of the next meeting shall sign the minutes. Whereas if it is a general meeting, people, the chairman of the current meeting, whereas the chairman of the current meeting, if it is not available, then people, the board of directors shall authorize one person amongst themselves to sign the minutes. The minutes of the meeting, every page shall be initialed and the last page shall be signed. The minutes shall be preserved permanently throughout the life of the company. Remember, signing we saw. Manner of signing, every page, 30 days, 15 days. Preserved permanently. The meeting register, same thing at the meeting, during the meeting, virtual. Okay, what is virtual meetings? Same thing, they will keep on saying the same thing. What do you mean by virtual meetings? Virtual meetings is nothing but people doing everything over electronic platform. Advantages and all is given. I hope this is manageable. There is nothing for us to discuss as such, correct? So remember that. The only thing that we might have to discuss is the video conferencing. Whenever you are conducting meeting through electronic form, remember, the roll call by chairperson, meaning the attendance will be called. The presence of quorum has to be done. The person present through electronic means will also be counted for the quorum. The director will have to introduce themselves first, and they should also tell people what. I am present from so and so, my name is so and so, I am present from so and so location, I have received all the agenda notices on time, and I have to clearly tell in the meeting room wherever I am present, there is no one else present in the meeting. The only exception is if at all I am a differently abled person, I have an option to get one more person with me, and he should also declare that he will keep all the information confidential. And we have to always sign the board minutes. Remember, the person attending the meeting through electronic means, for him, a CS shall sign on his behalf. If there is no CS, then chairperson will sign. What if chairperson is also not there? Then any person who is authorized by the board, by any other director in the meeting, they will sign the attendance on behalf of the person attending the meeting electronically. 15 days, 30 days, done.
Yes, people. So let's start our next chapter. Till now we have done around 3 chapters. So what I would always suggest you is, you guys do not watch the entire marathon at a stretch. How you guys have to plan is, have also given you a 12-day planner for company law, how to plan your studies. So watch one chapter of the marathon, read the complete text, whether from whichever material you guys are using, read it and then solve all the questions from that particular chapter. So get a good scanner. That's how you guys have to do it. And that's the most effective way as well. Yeah. Okay. Yes, people. So the biggest chapter is here. Okay. So divided into 5 parts. Let us see how quickly and how deep we can do it. Okay. So share and share capital concepts. Okay. The meaning and definition, the types of capital. There are 5 types of capital. That is authorized capital, the maximum capital. Out of that, how much the company has issued, that is called as issued capital. From that, how much has public purchased is called as subscribed capital. Out of the total face value, how much has the company called to pay is called as called up capital. From that, how much the shareholders have paid is called as paid up capital. That is the 5 types. Types of shares, there are 2 types of shares majorly. One is called as equity, one is called as preference. Equity can further be classified into 2 types. One is equity shares with normal voting rights. Next one is equity shares with differential voting rights. So to issue DVR share, what are the conditions that the company has to satisfy? The company has to satisfy some conditions, right? Now, what is that? If a company has to issue DVR shares, you need to satisfy the rule 4 of companies share capital and debenture rules. Every condition is important. Try to remember word by word. The first one is you should have authorized by AOA. What if we did not authorize by AOA? You have to alter your articles of association, pass a special resolution, file form MGT 14, and only then you can issue DVR shares. Next one is ordinary resolution is sufficient. See, this is where maximum times we will think it is special, but ordinary is sufficient. If you are a listed company, then postal ballot becomes mandatory. Next one, the maximum of DVR. How much DVR shares can we issue at any given point of time? The maximum DVR shares cannot exceed 74% of your total voting power. So if you have total 100% of votes, in that DVRs cannot have more than 74%. The 26% should be normal shares. Yeah. Okay. Next one, the conditions. What is that? You should have not defaulted. Defaulted in what? Defaulted, you can classify that into I can classify that into 1, 2, 3 and 4 defaults. What is that? The first one, you should have not defaulted in filing your financial statements and annual returns in the last 3 years. So your last 3 years has to be clean. If it's clean, you can go for DVR shares. Next one, this is important. See, what do I mean by no subsisting default? Subsisting means when I'm issuing DVR today, on today there should not be default. What if there is a default yesterday? That is okay, but today there should not be any default. Default in what? Default in people, if you have issued any preference shares, debentures, you should have not defaulted in redeeming them, repaying them. Next one, if you have declared any dividends, you should have not defaulted in paying the declared dividends. Next one, repayment of deposits. If you have accepted any deposits, there should not be any default. Next one, you should have again not defaulted. See, here it is no subsisting. Subsisting means yesterday you have done a default. That's okay. Today that should not be there. But here, sir, you should have not made a default. If you have made a default, people, first you have to make good the default. You have to repay that default. And after that, you need to wait for a period of 5 years. There is a cool off period. Now, what is that, sir? Now, if at all you have declared any preference dividend, in that you guys should not have made any default. Next one, you have taken any loans. There should not be any default in repayment of loans. Next one, there should not be any default in repayment of statutory payments like employees, provident funds and things like that. Sir, we have to 7 years IPF. We have made a default there. If such any default happens, then people, there is a 5-year cool off period. 5 years cool off will start from when? Imagine if we have made a default in the year 2014, we did not pay loan. In the year 2016, we repaid loan. You have to leave 2016. Start from 2017. 1st April 2017 to 31st March 2018. Like that. 19, 20, 21, 22. So on 1st April 2022, you guys can issue DVR shares. That's how you calculate. Clear? Okay. Next default is you should have not been penalized under these 4 acts in the last 3 years. You should have not made any default. What are the 4 acts? One is RBI, SEBI, SCRA and FEMA. So under these 4 acts, you should not be penalized, sentenced to any imprisonment, sentenced to pay any penalties. You should have not been penalized. Sir, always remember, you cannot convert the existing shares into DVR, DVR into existing shares. They are entitled to all the other rights. For example, a normal share is entitled for financial statements, entitled for dividends, entitled for copies of annual returns or notice of general meeting. All those rights will stay intact. That will not change. Remember that. Yeah. Just a second. Summer studying in summer is crazy, huh? I don't know how you guys are managing. Keep yourself hydrated. You tend to become more and more dehydrated, and that will have an impact on your studies as well. Okay, that is your types of shares. Okay, now coming back, sir, DVR. Okay, next one is people preference share. Now we know preference share, sir. There are different types of preference share. Does preference share has right to vote? Section 55. Preference shares generally do not have a right to vote. But when will they have a right to vote? Whenever people, if there is anything that is concerning their rights, they have a right to vote. During the winding up of the company, the preference shareholders will have a right to vote. Agreed? Yes, sir. And also in the case of reduction of share capital, they will have a right to vote. In these 3 scenarios, the preference share capital will have a right to vote. Except these 3 scenarios, generally they do not have a right to vote. However, whenever the preference dividend is not paid for a consecutive period of 2 years, then people, the preference shareholders will have a right to vote on every motion that has been placed in front of that particular meeting. So they can vote on everything just like equity shares. However, the law is silent whether how long will they have this right. See, if I don't repay for 2 years, I will have this right, correct. But will it be there for 5 years, 10 years? How long I can keep voting? Now for that people, the law is silent. Now what can we assume that? See, when there is a default, you have a right to vote. When the default is made good, the right to vote will come to an end. Yes, that is a understanding, but it is not written in the law. Okay. Preference shareholders right to vote. Okay, next one, sir. What is the maximum period of preference shares, sir? The maximum we can issue the preference shares for people 20 years. Sir, can we issue more than 20 years? Not everyone, but a few people can issue for more than 20 years. Who are they? They are the companies who are into infrastructure projects. If you are into infrastructure projects, you can issue preference shares for a period of more than 20 years, but not more than 30 years. So those companies who are into infrastructure projects, they can issue the preference shares for more than 20 years, but not more than 30 years. However, with the condition that from the 21st year onwards, you have to start repaying 10% of your total preference shares at the option of the preference shareholder. So minimum 10% you have to start redeeming from the 21st year onwards. Clear? Okay. And the preference shares can be of various types. One is what? Cumulative, non-cumulative, convertible, non-convertible, redeemable, irredeemable. Remember, irredeemable preference shares cannot exist. So it has to be convertible or non-convertible. Convertible which gets converted to equity, non-convertible which will be redeemed. How will you redeem, sir? How will you repay? You will repay people out of your profits which is available for dividends. You will repay it out of the profits of the company, and the premium on redemption can also be used. You can use your securities premium account to repay the preference shares for a premium price. You can use that. Correct? Yes. So preference shares shall be redeemed out of the profits of the company. Premium on redemption, you can use your securities premium as well. Sir, what if I don't have my profits, sir? Remember, you can use issue of equity. You issue equity, new shares, you raise money. That also you can use to repay the preference shares. Proceeds of fresh issue. Clear? Okay. Whenever you are repaying the preference shares from the profits, in such case you will have to create something called as capital redemption reserve account. I hope you guys would have seen this in accounts also. I would have explained this to you in the class as well. Yes, so remember and go. So remember, we have issued preference share with 5 years maturity, but in the 5 years we were not able to repay. Now, can we add another 2 years, sir? Can we please tell our shareholders, people, because of some reasons we are not able to repay the preference shares immediately, can you give us another 2-year time? Can we do this? Answer is yes, you can do it. Now, this process is called as rollover. What do I mean by rollover? Technically, I should have repaid your preference share within 5 years, but I need an additional 2-year time. Now, how to do this? Simple. Call the preference shareholders for a meeting. Take 3/4 of the preference shareholders in value. You have to take their approval and submit your application to the tribunal as well. And if tribunal also gives you a consent, then you can go people and convert whatever your 5 years, you can do it additionally. You can extend it by another 2 years. Clear? Okay. What is the procedure for issue of preference share? It is same like equity only. What is that? You will first call for a general meeting. You will pass a special resolution. Because special resolution, you will file form MGT 14. Within 30 days of allotment, you need to file form PAS 3. See, this is same only, no? Whenever you are allotting shares, people, equity, preference, anything, if you guys are allotting securities, you will have to file PAS 3 within 30 days to ROC, and you will have to give the share certificates within 2 months. During the incorporation, again 2 months. But if you guys are issuing debentures, you will give the debenture certificate within 6 months. And whenever you're transferring the share, A transfers the shares to B. In such case, the B will have to get the new shares. No, that will be given within how many days? Within 30 days. That is within 1 month. Remember that. Whenever we are redeeming the preference share, we will have to file form SH7. SH7, when else you will file, people? You will file it in section 61. You would have seen what is that? Alteration of capital. So you will file SH7 whenever you are doing anything in section 61. The 5 things: alteration of capital, increase of authorized capital, share split, consolidation, conversion of share into stock, or cancellation. When you're doing those, or reduction of preference share, redemption of preference share capital, you will still file form SH7 with ROC within 30 days. Okay. That's all. That's your part A. Like that, people, in your chapter 4, you have 5 parts. Technically, why is because if you don't have these parts, no, you will feel, my God, how much is there in this particular chapter. So it's so vast. So it is there from the scratch. So it is there from the types of capital, and it goes on up to the transfer and transmission. Correct? Okay. Next one, sir. Part B. In part B, what will be seen? We'll be seeing more into prospectus and public offer and things like that. Okay. The next chapter, sir, is part B. The basic terms related to the allotment of securities and as the case may be. The first thing you guys need to know is called as prospectus. Now, what do I mean by prospectus, sir? Prospectus is nothing but whenever a company is going for a public offer, the company will have to mandatorily issue something called as a prospectus to the public. A company can never do a public offer without prospectus. A prospectus, people, can be of various types, but 3 things you guys have to know. One is called as shelf prospectus, one is called as red herring prospectus, the third one is called as abridged prospectus. What do I mean by abridged prospectus? Abridged prospectus means nothing but, generally remember, the prospectus will be very lengthy document. That is, the prospectus itself will be around for 300 pages. And you are expected to read this 300 pages. Of course, you guys won't read. You guys are not reading a deciding factor of your life, your career. That one book only you guys are not reading. Will you guys read all this prospectus and all? You will not read. So to help you, what they have done, the company has to prepare something called as a summary of this prospectus. That summary is only called as abridged prospectus. Abridged is nothing but summary. Clear? Yes, sir. Okay. Is abridged prospectus important? Answer is yes. Is it mandatory? Answer is yes. But exceptions are there. Whenever you're going for underwriting or whenever you're giving it to the existing members, you need not have to give abridged prospectus. In rest of all the cases, abridged prospectus becomes mandatory. Okay. So what do I mean by shelf prospectus? What do I mean by red herring prospectus? What do I mean by red herring prospectus, people? A prospectus in which all the details are mentioned except 2 details. What is that, sir? It does not include all the details, people. It has all the details except the quantity of the shares that you're issuing, or the price of the shares that you're issuing. These 2 details, any of these 2 details will not be mentioned in the prospectus. When will a company issue red herring prospectus? Whenever they do not know the firm price of the share. Should I price my share at 200 or 300? I'm not sure. So what do? We do a process called as book building, like a bidding. We will allow the public only to decide the price. We will give you a band like 200 to 240. In between this, you guys decide. Whichever price you guys vote, the maximum, that will be our price. So to do such type of bidding, the prospectus that we issue, the prospectus we use is called as, people, red herring prospectus. Is clear? All of you? Yeah. Okay, so it is always issued prior to the issue of prospectus. Remember that, and it is filed with the registrar at least 3 days before the opening of the subscription list and the offer. That is, if your IPO opens today, you will file this at least 3 days before to the registrar. And remember, you will start doing the bidding. If people decide 220 is the price, you will do your IPO at 220, and after the entire IPO is done, we will file one document with the final number of shares issued and what was the final price. We will file this document with the ROC and also people with the SEBI. And now this becomes a complete prospectus. The next type of prospectus is called as shelf prospectus. Now, what do I mean by shelf prospectus? A prospectus generally, now imagine there is a company who, imagine like this. I do not want to raise all the money at once. The company needs around 4,000 crores, but I don't need everything today. So what does the company decide? The company will decide to do multiple offers, like 1, 2, 3 offers. Now what happens? Whenever you do a public offer, you need to issue prospectus again. That's a time consuming and also money consuming process. So what do you do? What you can do it as an alternative? What you can do is you can file a prospectus called as shelf prospectus with the SEBI. Now the validity of the shelf prospectus will be 1 year. So if you are doing your first offer today in the month of Jan, now this prospectus will be valid up to the end of this year. The entire complete 1 year, this prospectus will be valid. Now what happens? If you want to do the second, third, fourth offer, you need not have to issue the prospectus again, because once you have issued a prospectus, this prospectus will have a validity period of 1 year. Generally, whenever you buy any product, you generally ask shelf life. That is how many days we can use it. In the same way, people, the shelf life for this is called as 1 year. That's why the name came called as shelf prospectus. How long can you keep this prospectus in the shelf? After you have to dispose it. Correct? So, from the day you do your first offer, you can do any number of offers, 5, 6, 8, 10 in the duration of 1 year. Hello? Clear? Hello? Sir, what if in the month of Jan we issue the prospectus? In the month of August, there are some details that has changed in the company. We have created further charges. We have taken more loans. Now that is not there in the prospectus. Now what to do? Remember, any change in the financial position of the company, any charges created. So if any such changes have happened, only that information you will file it again. Now sir, in which document we will file it, sir? You will file it with ROC in a document called as PAS2. That is called as Information Memorandum. What will be there in Information Memorandum? Information Memorandum shall consist of any new charges created, any change in financial positions of the company will be intimated to ROC in the form PAS2. Clear? Done? Done. That's your shelf prospectus. And remember, if anyone who has given advance money, that is, there is a shareholder who thought I would want the second offer, third offer as well. So he has given entire money at the time of first offer only. After, if the company come up with PAS2, if the shareholder thinks the company is not fit now, you should be given an opportunity to withdraw the advance money. You have to refund. If he is not interested to buy the shares in the second offer, not the first offer money, second offer money, we have to refund. Clear? Yes, sir. Done. Okay. Next one is called as deemed prospectus. What do I mean by deemed prospectus? Generally, what did we say? Whenever a company gives its shares to public, you have to always give a prospectus. Now, what if a company do not give the shares directly to company? directly to the public. Instead, there is one company who will give the shares to another company. Now that will further give it to public. So company A is not giving to the public directly. They are giving to company B. Company B is giving the shares to the public. Now the question is, in this case, should we give a prospectus? So people used to avoid giving prospectus in these cases. That's why they introduced the concept called as deemed prospectus. What do I mean by deemed prospectus? Deemed means what? Assumed. So when company A gives its shares to company B and company B gives the shares to the public, whatever document the company B is using to give the shares to the public, it can be advertisement, it can be some document, it can be newspaper advertisement, whatever document you are giving, that document will be deemed to be prospectus. That's why the name comes as deemed prospectus. I hope this is clear. Clear, Ram? Yes, Ram? Okay. Provided, when will this become a deemed prospectus? For this to become a deemed prospectus, you need to satisfy some condition. What is that? For a document to become a deemed document, remember, when A gave shares to B. Now we have two questions. When did A give shares to B? Sir, A gave shares to B on 1st Jan 2026. What is the value? So the value of the share is 1000 crore. Okay, question number 1. Has company B paid that 1000 crore for company A? If the answer is yes, then you have satisfied one condition. Question number 2. When is company B giving the shares to the public? Sir, the company B is giving the shares to the public on 1st of April 2026. On 1st of Jan only company A gave shares to B and 1st of April company B is giving shares to public. Then people, whatever the document, we will call this document as deemed prospectus. So basically it will become a deemed public offer. Why? Because you are giving the shares further to public within the 6 months of company A giving it to you. Sir, what if I give the shares on 1st August 2026? Jan, Feb, March, April, May, June. Once June is done, forget about August. Even if it is July, this will not become a deemed prospectus because 6 months period is over and full money is also paid. If both the conditions are not satisfied, people, then this will not become a deemed prospectus. If even one condition is not satisfied, that is, if full consideration is not paid, or if within 6 months only, if I am giving it to someone else, it will become a deemed prospectus. In such case, what should we do? Whichever is the deemed prospectus, this company B is there, no? If that B is a company or if it is a partnership. If you are a company, at least 2 directors from your company should also sign this prospectus. Sir, it is not a company, it's a partnership. Then people, half of your partners has to sign this particular prospectus. That is what they are telling you. If it is a firm, half of the partners have to sign. If it's a company, 2 directors have to sign the prospectus. Is this clear, all of you? Okay, done. The next one is called as offer for sale. What do I mean by OFS? Offer for sale. Simple people, when a company is doing a public offer, what does the company do? The company will print new shares and that they will give it to public. But at times what happens, the existing shareholders in a company who are already shareholders, like example is promoters, they will say, hey, why do you print new shares? I will give the shares to you. You can give it to them. Why would you want to again print new shares? We do not need it. So if existing shareholders ka shares, if it is taken and if it is given to public, we call this as offer for sale. Example is in the case of Mamaearth. There was an offer for sale done. Who did it? There was, who is that hero in the yoga and all, she does know. Shilpa Shetty. Shilpa Shetty was one of the investors in Mamaearth. When they went for an IPO, she liquidated her shares. Around 60% of her shares she sold at a price of around 40 crore. Now this is only called as offer for sale. Understood? Yes, hello, pakka, done. Okay. The next one, allotment, section 39. Okay. Now, whenever a company goes for a public offer, you need to allot the shares, right? Sir, when should we allot the shares? Remember, for you to do the allotment, people, the first condition you need to satisfy is in the prospectus, the company has to clearly tell what will be the minimum subscription that the company is looking for. That means if we are selling 100 shares, when will the IPO be considered as complete? You have to mention what is the minimum percentage of shares that the public has to buy. It can be, say for example, in the prospectus you can write at least out of 100 shares, 60 shares has to be purchased. If that is purchased, then the IPO is successful. So that number you have to write in prospectus. But remember, according to company law, you can write whatever is a number the company wants. But as per SEBI people, this is 90%. So out of 100 shares, 90 shares has to be purchased. If not, people, your IPO is unsuccessful. Sir, within how many days it has to be purchased? It has to be purchased, people, whatever is the offer period, within that it has to be purchased. Sir, what if it is not purchased? The received amount shall be refunded if not subscribed within the 30 days. So within the offer period, if they are not buying, people, I need to refund the entire money within 30 days. Sir, what if to be refunded within 15 days from the date of closure? Sir, now what if it is not refunded? If it is not refunded, people, I need to pay interest the rate of 15%. Is this clear? Hello, all of you? Okay. So I have to refund. If it is not subscribed within 30 days, I will get another 15 days to refund. Within this time, if I don't pay it, it will be 15%. Do not get confused between this and private placement. I am writing it hand in hand here only. Here it is 30 days to allot. If not, people, within 15 days I have to refund. If not, people, it is 15% rate of interest. In private placement, it will be 60 days, 15 days to refund, 12% rate of interest in case of default. Remember this. Hello? Hello? Okay. Next one, sir. What is the minimum application money? According to Companies Act, it is 5%. That is, if my face value is 100, at least 5 rupees I have to collect it upfront as an application value. But the Companies Act only say it is 5% or whatever is prescribed by SEBI. SEBI has prescribed it as 25%. In reality, we follow this only. But according to company law, this is 5%. Return of allotment, once you allot the shares, you need to file the form PAS3 to the ROC. Remember, PAS3 will clearly have the list of allottees, what is the value of the price, how did you decide that is the value of the price, that is you need to give something called as valuer certificate as the case may be. Penalty if you do not do it on time. Remember, when you are doing offer for sale, no, these conditions will not apply. What? Minimum subscription, minimum application value, and what are you going to do with the money you have raised? You have to mention that in the prospectus. Here, what will I do? I will give it to the promoters only. No, whoever has given us shares, we will give the money to them. We can't keep it as a company. Statement to be made by board in respect of utilization of money. All of this will not apply to offer for sale. I hope this is clear. That is allotment. Securities to be dealt within stock exchange. This is nothing but whenever you are going for an IPO, remember you have to file an application at least to one of the stock exchange. Hello. Of course, no, that's why you are calling it listed. Okay. And remember, you have to keep the entire money that you have raised and public offer until you get the entire money and until the entire procedure is done, you're not supposed to utilize that money. You have to keep it in a separate bank account. Okay. Sir, what is the maximum commission I can pay? If it depends, people. If you are issuing shares, the maximum commission you can pay shall not exceed, this is for underwriters, the maximum you can pay people for shares shall not exceed 5% or whatever is the percentage prescribed in AOA, whichever is less. If it is debentures, 2.5 or whatever is prescribed in AOA, whichever is less. And remember, whatever shares today, if you guys are doing, if you are a listed company, any issue you do, according to Rule 9 of prospectus and allotment of securities, everything should be in a demat form. As per Rule 9A, any public company, if you guys are doing any issue, even your shares has to be in demat form. As per Rule 9B, within 18 months from 31st of March 2023, all the shares issued even by a private company should also be in demat form. Only exception is people, small company. This is clear? So today listed public and private except small company, everyone today are issuing the shares in demat form only. Hello? Hello? Abridged prospectus, when is it not required? Whenever you are entering into underwriting agreement, next one, in relation to securities which were not offered to public. So if you are not giving to the public, if you are giving the shares to the existing members, abridged prospectus is not required. Remember, this can be important from exam point of view. Offer for sale, Zomato's details we had seen. Duplicate share certificate, do you want a, what is duplicate share certificate? Whenever you're existing, today's date is irrelevant, people, because as I told you, even if listed company, public company and private company, if everyone shares are dematerialized, who is holding physical shares today? So this becomes eventually, people, if you ask me 3 years, 5 years down the line, even small companies will also be said to convert their physical share certificate into demat form only. Then people, this becomes absolutely irrelevant. Correct? When you're converting your physical shares into demat form, then what is the use? Agreed? But yes, what is duplicate share certificate? Whenever my existing share certificates, if I lose it, or if it is torn, if it is defaced, if it is mutilated, any such things happen, upon me submitting it, I'll have to go and give my letter of allotment or the share certificate. The company will pass a board resolution and they will collect some fees, which will generally not be more than 50 days. They will collect some fees and they will allot me a duplicate share certificate. If you are an unlisted company, you have to, once the person gives you a request for duplicate share certificate, you have to give it within 45 days. If you're a listed company, you guys will have to do it within listed company is 45 days. If you're unlisted company, within 3 months. Where is it? Listed company has to do it within 45 days. Unlisted company has to do it within 3 months. And whenever you're issuing duplicate share certificate, all the details you have to maintain it in a register. That register is in the form SH2. Remember, the SH2 is not the format of duplicate share certificate. Duplicate share certificate format is SH1 only. But whenever you are issuing duplicate share certificate, all the details has to be mentioned in a register called as SH2, Register of Duplicate Share Certificate. That is what it is, 50 SH2. What do you mean by share split? If I have 100 shares, if I split it into, like if I have 100 rupees, if I get 50 rupees, 2 notes. In the same way, if I have 100 shares in one certificate, I can split it into 2. That is called as share split. Remember, this duplicate share certificate, all these registers and all has to be maintained for a period of 30 years by the company. That is what they are saying. legal effect of share certificate, there is something called as estoppel as to title, estoppel as to payment. That is, once the company has issued a share certificate, you can never say that the shareholder, whosoever is a shareholder, if their name is written on the share certificate, we generally say on a prima facie evidence, he only is the owner. Estoppel means the company cannot go back. Next one, the company cannot say that he has not paid the money. If on the share certificate it is mentioned, it is 5 rupees paid, 10 rupees paid, tomorrow, next day, the company cannot deny that particular fact. That's your part 2. Let's do part C. Yes, people. So, in the part C, yes, before we start part C, I think we had to do the share certificates, correct? Duplicate we did. SH1, yes, this one, just remember and go. Whenever a company is newly incorporated, within how many days should we issue the share certificates? We'll have to issue it within 2 months from the day of incorporation. Whenever it's a newly incorporated company. So whoever are the initial shareholders, we need to allot them the share certificates within 2 months from the date of incorporation. Okay. And whenever any new allotment happens, like for example, you can take as an IPO, rights issue, private placement, within 2 months from the date of allotment, I need to give them the share certificates. Third one, transfer and transmission. What is this? Nothing but people, if you guys remember our last part, you will be seeing it. SH4, whenever I am transferring my shares, A is transferring his shares from A to B. Now we need to issue a new share certificate to B, right? So that has to be done within 1 month from the date of receipt by the company. Whenever we give this SH4 within 1 month, I need to do that. Next one, any allotment in the case of debentures. Any other security, 2 months. In the case of debenture, 6 months. Remember. Okay, next one, part C. Part C, yes, it has this is nothing but personation of shareholder. What does personation of shareholder mean? Nothing but if someone pretends to be a shareholder, that is, fraudulently, he personate means what, people? Someone acts like a shareholder, even though they are not. They are punishable. It is a criminal offense. You can be even put into jail for that. Remember and go. I'm not going into the imprisonment part that much in detail. Okay, next one, part C, issue and allotment of securities. Of course, it also has a certain parts of your public offer as well. It also has the other issues like rights issue, private placement, preferential issues and things like that. Okay, section 23, the first things first. What does section 23 say? Section 23 says, what are the different ways of raising money by a company? It depends upon what type of company you are. If you are a public company, then you can raise money, people, in many ways. One of it is by a public offer, correct? You can do a public offer. Next one, you can do a private placement, rights issue, bonus issue. If you are a private company, the first one will not come. Now, these three will come in the case of private company. Okay, now remember there is one more new section added, that is section 23 subsection 3, which is not that much in detail, but it just says what? If at all any Indian company wants to go and list its securities directly in the foreign jurisdiction, it can do it now. The central government will prescribe which security you can issue. Is it equity, preference or which security? Central government will prescribe the rules. Next one, which foreign jurisdiction? Can it be anything? Can you go and list it in Pakistan? Yeah, they only need, okay. Next one, can you go and list it in any stock exchange? So which foreign jurisdiction, which stock exchange, which security, everything will be prescribed by central government. Now that is what is section 23 subsection 3. That's the new section, but I wouldn't say like an amendment, but it's been a while that they have added it. Prospectus we have seen, shelf prospectus, red herring prospectus and all of that. Punishment for fraud, important. If there is a place where you guys have to remember the punishment, it will be this 447. Try to remember and go. What do they say? Section 447 is nothing but if someone does anything intentionally, then you will be liable under section 447. How much will be the penalty? The penalty will be, it depends upon what is the amount of fraud you have done. Imagine if the amount involved in fraud is more than 10 lakhs or 1% of the turnover of the company, whichever is less. So imagine the amount of fraud you have done is around, say for example, 30 lakhs. Now try to see 10 lakhs or 1% of the turnover of the company. Let us imagine the turnover of the company is 1 crore. Yeah, how much is 1% of 1 crore is 1 lakh. 10 lakh or 1 lakh, whichever is less. Which is less? 1 lakh is less. So if the amount involved in the fraud is more than 1 lakh, it is definitely more than 1 lakh in our case. Then you will be liable for how much? Punishable with imprisonment. Minimum shall be 6 months. Maximum it can go up to 10 years. And you will also be liable for a fine. How much? Minimum amount involved in the fraud. In our case, it is 30 lakh or 3 times of the amount of fraud, that is 90 lakh. That will be the penalty. And remember, you have caused this thing, no? That is, you have made this fraud, right? Whom did you cheat? Is it your directors? Is it your members? Whom did you cheat? Sir, we cheated public. If public is cheated people, imagine you have issued prospectus. In the prospectus, you have given all fraudulent information. In that case, people, the minimum imprisonment will be at least 3 years. Remember that and go. Sir, what if the amount involved in fraud, here it is more than. What if it is coming for less than? Sir, if it is 10 lakh or 1%, whichever is less. If the amount involved in the fraud is coming for less than that, then people, the punishment will be imprisonment may go up to 5 years. See, this becomes or. Yeah, fine up to 50 lakh rupees or it can be both. This is what is a penalty. 447, remember and go. So OFS we have seen, public offer of securities in demat form I told you, section 29. We can see it as 3 rules, rule 9, rule 9A, rule 9B. This is any listed company, any public company, any private company, except small company. Rule 9A, okay, 39 allotment, 40, we saw that. Okay, we'll do private placement. Okay, important ones, let us see it off. Okay, now how do we do a private placement? First of all, what do we mean by a private placement? Private placement is nothing but whenever we offer our securities to identified group of people. They are not some random person. They are identified individuals or persons. If we are giving the shares to the identified the group of people, we call it as private placement. They are not random. They are the known people. We call it as private placement. Sir, in a year, how many people I can do the private placement? You can do the private placement for 200 people in a year. You can do it for 200 person in a year. So this person 200, is it equity, preference, debentures, everything put together? No, everything is different. So you can do in a year equity shares you can issue to 200 people. You can, in addition to that, you can also issue 200 you can issue to the preference shares also to 200 people. Another 200 debentures also you can issue. Absolutely fine. So it is per security. However, in this 200, certain people are not included. Meaning it's okay. You can give it to how many ever people you want. One is employees. If you are giving it to employees, they do not come in the limit of 200. Next one is people, the qualified institutional buyers, they are not covered in the number of 200. Remember that. Okay. So the offer made to 200, QIB, ESOP, not. Sir, what if we are giving it to 210 people? It becomes people a public offer. What if it becomes a public offer? Then it is no longer a private placement. Because it is public offer, you need to mandatorily issue something called as prospectus. Remember. Okay. Sir, it shall be subscribed by. What is that? Check. You have to give it by check or demand draft or banking channel, and it cannot be by cash. Remember that. So it has to be for money. Money is coming in. That is the important thing. It should not be physical currency. It should be through a banking channel. In case of joint shareholders, the persons appearing first shall pay for the subscription. Whoever is the person named first, they will only get all the rights, as well as money also should be paid by them. Okay. This provisions shall not apply to NBFCs who are registered with RBI and housing finance companies who are registered with National Housing Bank. You need to pass a special resolution for you to do a private placement. And remember, this special resolution, if at all you are issuing the shares to the qualified institutional buyers, the special resolution will be valid for a period of 1 year. Hello. Okay. Next one, sir. The private placement offer letter. The format of the private placement offer letter is Form PAS4. Remember, whenever you do a public offer, you will always give them prospectus, right? In the case of private placement, how will the people know the terms of the issue, the price, all of that? How will they know? They will know it, people. You will give them something called as PPOL, private placement offer letter. The format of this is, people, PAS4. Okay, it has to be serially numbered. It has to be addressed specifically to that investor. This is what I told you. You cannot give it to a random person. Now, for example, I'll take a name. If I'm specifically giving it to a person called as, say, Harsha. So it has to be written in the name of Harsha. The offer letter has to be addressed to him. You can't leave the name blank. Clear? Okay. It should be sent within 30 days of recording the names. So first, what will the company do? The company will open one book. In that book, they will first write down to whom and all we are giving this offer to. Harsha. Say for example, Pradeep. Yeah, we'll write down their names. Once you write down the names in the register, you will have to issue the offer letter to them within 30 days. And this register is called as, people, PAS5. The entire record of your private placement will be in the format PAS5. Now what will happen? If Harsha is interested, Harsha will apply for the shares. Once he gives us money, within 60 days, we need to allot him that particular share. Within 60 days. Sir, what if we are not able to allot within 60 days? You need to refund the money within 15 days, as we saw in our previous topic just now. So within 15 days. But in the case of public offer, it was 30 plus 15. Here it is 60 plus 15. Sir, what if I'm not refunding even within 15 days? Then people, I need to pay a simple rate of interest from the 60th day. Remember that. Okay. Remember, sir, what if even in the 15 days if I don't refund? If you guys remember, our next chapter, that is nothing but this will become, it will be treated as deposits. Agreed? Okay. Next one, return of allotment. Once you are allotting the shares to Harsha, Pradeep and all of that, now registrar should know, you will file a return of allotment to the registrar in the form PAS3. It will have the details of how many shares were allotted, who are the allottees. We need to tell no, Pradeep, Harsha, all their names. That entire details has to be filed with the ROC. It will be filed within 15 days of allotment. And this is very important. Remember, at any given point of time, at the same time, two private placement offers cannot run simultaneously. You have to first start one. You have to complete the allotment. You have to file form PAS3 to the registrar. Once it is complete, people, then only you can initiate another private placement. At the same time, two private placements cannot run. Clear? And until the return of allotment is filed, you cannot even utilize the money. Remember, they can test you in these two cases. They can ask you some questions and all. So until the money is collected, they cannot utilize that particular money. Is this clear, all of you? Yes? Yes. So 60 days, 70 days, 7 days, 15 days, PAS3. This is what we just saw. Hello? Okay. Can we issue the shares at a premium? Is it possible? Section 52 says you can issue shares at a premium. That is only called as securities premium account. Now what can I use this money for, sir? You can use this money for 5 purposes. What is the 5 purpose? The first one is people for issuing the fully paid bonus share. You can utilize the securities premium account to issue it back to the shareholders only as bonus share. Next one, writing of the balance of the preliminary expenses of the company. This is nothing but people pre-incorporation expenses. Whatever money you guys have spent before the incorporation, for that you can set off using the securities premium account. The third one, sir, writing of the commission paid. Imagine underwriting commission. We saw right in the previous part. You can pay up to 5%, 2.5%. That from where can you take? You can take it from the securities premium account, or discount allowed, or the expenses incurred on issue of shares or debentures. So whatever the expenses are, you need to appoint so many people, right? So all the expenses you can pay from securities premium account. Next one, for providing for the premium payable on redemption of any redeemable preference share. I told you when we were doing that preference share concept itself, you can redeem the preference shares at a premium price, and you can take that money from your securities premium account and for the purchase of buyback technically. So for these 5 purposes, you can utilize your securities premium account. Okay. Sir, section 54, can we issue shares at a discount? Is it possible? Remember people, generally you cannot issue shares at a discount. If the company's face value of share is 10 rupees, you cannot issue the shares at 8 rupees. Remember, you can issue shares at a discount on a market value, not on the face value. This is not possible. However, in 2 scenarios, it is still possible. Scenario number 1, whenever a company is issuing sweaty equity shares. Scenario 2, whenever as a part of debt reconstruction, meaning we had taken loan from someone and we were not able to repay that loan, we can give them an option to convert the loan into equity. That is possible. Only these 2 scenarios you can issue the shares at a discounted price, and in no other scenario. This is clear? All of you done. Allotment, we saw PS3, we saw private placement. Okay, section 62, further issue of share capital. Important. Section 62. Under section 62, you can further raise money in 4 ways. What is that, sir? The first one is called as people rights issue. What is rights issue? Whenever you are issuing shares to your existing shareholders. This only will come again in the next chapter, people, called as preemptive right. I am explaining that here only. What do I mean by preemptive right? Preemptive right means, people, before, see, as a shareholder, I have one right. What is that right? Before the company asks the money from any other person, I have a right to first be asked. About what? About investing more money in the company for in return of some equity shares. So before you go and ask an outsider that do you want shares of my company, it is the company's duty to first ask its existing members. Now that right only is called as preemptive. Before you consult or before you ask an outsider, you have to first ask me. That only is called as preemptive right. Hello? Yes? Okay. Now, sir, imagine we have so many shareholders. That is, we have around 100 shareholders. We give everyone an option. You cannot give it selectively. You cannot give it only to 50 people. You have to give it to all 100 people. Now, if they are interested, they will say, I want 50 shares, 100 shares, as the case may be. Sir, what if I am not interested? Then people, you have a right, you can give your option to someone else if you are not interested. Now this option is only called as, people, right to renounce. It's also called as renunciation. What do I mean by renunciation? Renunciation is nothing but I will give my right of applying shares to someone else. Remember that other person need not be a shareholder. He can be an absolute outsider as well. Sir, by default, do we have a right to renunciation, people? Yes, by default, you have a right to renunciation. However, a company can restrict this right. That is, they can tell you cannot give this right to any outsider. They can restrict it. How? They can say in our company, there is no right to renunciation. They can mention it in the articles of association. If it is given in the articles, remember, then you will not have right to renounce. And remember, sir, what if I get the offer letter today? When will the rights issue start? Remember, if you get the offer letter today, it should start only after 3 days. So from the date of receiving the letter and from the date of opening of the offer, there should be at least 3 days gap. Sir, the offer letter should be open for minimum how many days? The offer letter should be open for a minimum of 7 days. Maximum, sir, it will be open for 30 days. Hello, clear? Sir, however, if at all I am a private company, then I do not want to follow this 7 days and all. Can I just keep my offer letter open for say 2 days? Is it possible? The law says, if at all in case of a private company, if 90% of the members of the private company, if you give your consent, people, then you can follow a period lesser than that specified in the act. That means what? If we have 100 members, if 90 members gives us consent to follow a shorter, offer periods and all of that, then you can follow even 1 day as your offer period, provided 90% of your members have to agree. People, remember, very important, it is not in value, it is in number. So if there are 100 shareholders, if 90 of them agree, if that 90 are holding just 5%, that is still okay. But if 90% of the members in number, if they are agreeing, not in value, you can follow a lesser period. Clear? Okay. The next one, sir, is ESOP. What is ESOP, people? An option given for the existing, an option given for your employees of the company, for whosoever you want to retain them, they give an option to subscribe more shares of the company. So what will happen if there is one employee who has been really working hard? We will say, we will give you an option to buy some shares of the company so that you can stay with us, you can grow with us. So that is only called as what, people? ESOP. Now generally what happens in ESOP, in 2026, we identify the employees who are entitled to get these shares. We are identifying in 2026. We do not give them the shares in 2026 only. From the day we identify them, they will have to wait at least for a period of 1 year. So if we are identifying them on 1st Jan 2026, they will wait that entire year, and in 1st Jan 2027, they will get a right to buy the shares on that day. They will have to at least wait for a period of 1 year. Now this is only called as, people, the day when we are giving them an option, this is only called as, when we are identifying them, that is only called as grant of option. When they have to wait for a period of 1 year, we call this 1 year as a vesting period, meaning a waiting period. The day when they have a right to say yes or a no, this is only called as exercise of an option. You have a free choice to say either yes or a no. And remember, until you say yes or a no, you do not enjoy any rights of the shares. That is, you cannot vote, you do not get a right to dividend. No notice will be sent. You cannot participate in the meeting. You don't have any right. You cannot transfer this right to anyone else. No right to renunciation and ESOP. All of that cannot happen. Hello? Is that clear? Yeah. But you can still enjoy. It is possible. You can enjoy the right to, exercise only in 2 scenarios. So you need not wait for 1 year, it seems. Whenever, people, let us imagine on 1st July 2026, an employee who was given an option, that particular employee passed away. So his legal heirs will get a right to buy those shares immediately. They need not have to wait for that entire year. The second scenario is people, whenever a person becomes disabled, permanently disabled. What do I mean by that? Imagine there is an employee who meets with an accident. In such case, he becomes permanently disabled. Let us imagine he lost his arm. He becomes permanently disabled. In such case, people, he gets a right to buy the shares on the same day. He need not have to wait for the entire 1 year. And this option is called as people ESOP. Remember, we maintain all the details of ESOP in the form SHA 6. The register of ESOP is called SHA 6. Is this clear, all of you? Okay. The third one is called as preferential issue. What do I mean by preferential issue? Sir, preferential issue is nothing but people, when you're giving shares to the identified people, we call it as preferential issue. And one more thing in ESOP, employee definition is important, no and go. They can ask you a standalone question in the employee part only. Yeah, for whom and all you are eligible. This is very, very important, no and go. So you can give your shares to permanent employee, whether he is working in India or outside India, you can give it to them. Not only that, you can also give it to your directors, whether you're a whole-time director or not. That means what? You can even give it to your non-executive directors. That is possible. Part-time directors, you can give it. However, you cannot give your ESOPs to the independent director. Remember, sweat equity you can give. That's the difference. Remember that. Okay. Next one. An employee as defined in A or B, that is our permanent employee or a director of a subsidiary company in India or outside India, or a holding company of the company. This is very important. Remember, what is that? There is a company A, you can give your shares to the employee of your holding company. That is, imagine if there is a company called B, you can give the shares to company B. This is possible. Yes? Wait, where did that go? Okay. Next one, you can also give your shares to the subsidiary company of your company. The employees of your subsidiary company, even for them also you can give the shares of company A. They will test you here. Remember, important. Yes, you can give. Associate company and all is not there. You can give it to the company, subsidiary, holding. Possible. Hello? However, you cannot give it to the following people. Who? You cannot give it to the employees if they are promoters or related to the promoter group. For example, Mukesh Ambani is a promoter. If you are related to the promoter group, or if you are only the promoter, Mukesh Ambani will not come in the definition of employee. His relatives do not come in the definition of employee. Next one. A director who either himself or through his relative or through any body corporate directly or indirectly holds more than 10% is okay. More than 10%. I am talking about 10.1. 10% of the outstanding equity shares of the company. Mukesh Ambani holds, let us imagine, 27%. He is holding more than 10%. So you will not be entitled to participate in ESOP. Note, if you are a startup company, then this promoter and this director holding more than 10%, this condition will not apply for a period of 10 years from the date of incorporation. Very important, no and go. Okay, the third one, people, is called as preferential issue. What do I mean by preferential issue? Preferential issue is nothing but you allotting the shares or you issuing the shares to the identified group of people is called as preferential issue. Sir, don't you think that is what is private placement? Yes, similar only. But there are some differences between private placement and preferential issue. I will tell you the main ones. What is that? The first one is, people, private placement can be made only and only, or I'll tell it to you this way. If you want to issue shares to any identified group of people, now which security you are issuing? Sir, let us imagine I am issuing equity share. then you need to follow section 42 and you will follow section 62(1)(c), that is private placement and preferential offer. Sir, I am doing a private placement of debenture. What type of debenture? Convertible debenture or non-convertible? Sir, I am doing non-convertible debenture. Then people, you will follow only 42. You will not follow 62(1)(c). Why? Because preferential offer will get triggered only and only when you are issuing anything related to equity or any instrument which gets converted to equity. If there is no equity at all, then people, section 62(1)(c), that is preferential offer, will not apply at all. The very, very important fundamental difference. That's the point number one. Point number two. You can do private placement. Now imagine people, there is okay, let us imagine this way. Now there is a company, they have set up their company, their operations in one of the building. They have taken it on rent. Now we need to pay rent. Now let us imagine people, instead of rent, we decided to issue them, say for example, equity shares. We will not give them rent, we will give them shares instead. Now whether is he paying anything for us? Answer is no. Now we call such things as people non-cash consideration. Let us imagine if someone has worked very hard for us. Say for example, someone has given us a design. So someone has given us a trademark. We need to pay him fees. Instead of fees, we are giving him shares. Now such things are called as what? Non-cash consideration. Private placement will not come in the case of non-cash consideration. You will follow preferential issue. Because for private placement, remember DD or any banking channel, you cannot do anything other than cash. 62(1)(c) will apply. Hello. These two are the very important details. And of course, there are other details also. Here there is a format. PS3, PS4, PS5. Here only PS3. There is no offer letter. All of that will not come. This is very stringent. It is not stringent. So like that, there are various differences. You have to complete your preferential offer within 1 year. But you have to complete your private placement within 60 days. This can be done within 1 year. So these are the differences. Remember and go, very, very important. Rest of it, yes, is the same. But the main differences are these. Yeah. Securities, private placement includes. Here, offer letter. Here, nothing. Mode, through any banking channel. Here, either for cash or this is 60 days, this is 12 months. Bank account, separate bank account is required. Here, no such a requirement. This is very, very important. Remember and go. Clear? Okay. After this, let us go to, I don't think we did sweat equity, right? Okay, we'll do of sweat equity shares. Now, what do I mean by sweat equity shares, sir? Okay, whenever we are giving our shares to the employees. Now, what is the difference between the words ESOP and sweat equity? ESOP is, remember people, the employee has not contributed anything, but the employee has been with the company for a really long time. It can be say 5 years or say 10 years, as the case may be. What does a company decides to do? The company decides to make him part of their growth. So whenever the value of the company increases, the value of the shares given to him also increase. His life is also taken care. Now, what do I mean by the word sweat equity? Sweat equity, people, is basically where the employee has earned his shares. In ESOP, you need to give money to get your shares. In sweat equity, there will be no money involved at all. That is, you would have given something. Say, for example, I have worked really hard towards some project. or have given you some intellectual property right or a value addition or a know-how, have given you something. So in return, the company decides to give you equity shares. So you have either given your blood, sweat, you have worked really hard, or you have given some asset, or if you have given some, imagine a value addition or a know-how. In such case, what can a company do? Imagine I told you, a person has given us a patent. Imagine now a person gives us a textbook using which the company will make money. That's a copyright. Now, because the person has given us a copyright, the company decides to give him in return something called as shares. So he is giving us an asset, we are giving him a share. Now this is only called as people sweat equity. What is the beauty of sweat equity? He need not even pay 1 rupee in cash. That is absolutely fine. If you want, you take cash, or you need not even get 1 rupee from him. That is only called as what people sweat equity. Is this clear? So it can be given for cash or consideration other than cash. Hello? Okay. So how much sweat equity we can issue, sir? Maximum one time, that is in a year, people. I cannot issue more than 15% of paid up capital in a year, or issue value of rupees 5 crore in a year. So value of 5 crore or 15% of my total paid up equity capital, whichever is higher. So sir, every year can I keep giving 15, 15, 15? No, people. Everything put together, the maximum sweat equity you can issue cannot exceed 25% of your paid up equity capital. However, if you are a startup, then you can give it up to 50% of your paid up capital. Open your eyes here. You can give it up to 50% up to a period of 10 years from the date of incorporation. Is this clear? Hello? Okay. The sweat equity will be locked in for a period of 3 years. This is mandatory. A company cannot prescribe a higher period. It shall be 3 years only. Sir, the price of issue is determined by the registered valuer. The treatment for non-cash consideration, that is, how are you giving sweat equity shares? What did he give? Sir, what if he has given us a copyright? Okay, then we will show the copyright in our balance sheet. Sir, what if he has just worked hard? He has not given us anything else. He has just given his sweat. Where will I show the sweat? I can show it as people are employee expense in my P&L account. I will treat it as my employee expense. He has not given us anything. It's okay, we will treat it as an employee expenditure. Very, very important, remember. If it takes form part of a depreciable or amortizable asset. Depreciable means people tangible asset. Amortizable means intangible. We will carry it to balance sheet. If it is not forming a part of depreciable or amortizable asset, then people we will expense it. And remember, the entire details of sweat equity you will maintain in the form SH3. Done now? That is my sweat equity. Okay. Because these were all connected, I thought of doing it simultaneously. Buyback and all we'll do as a part of part D. Okay. In part C, is there anything else that is important that we haven't covered? Okay, the last one is section 62.4. What is this, sir? Remember people, whenever a company wants to issue any convertible debt, it can be convertible debenture, convertible loan, which in the later point, if it wants to get converted to equity, then the company cannot take such loan or cannot issue such debentures without first taking the shareholders' approval. You need to pass a special resolution. What resolution we will see? There is a section called 181C. You will be seeing it in the chapter 6. We will be doing it. That time I will tell you. Okay. So if you want to first issue a convertible debt or convertible loan, which is later point of time getting converted to equity, then you have to mandatorily pass a special resolution. However, let us imagine there is a company called Company X. Company X has taken loan from a government. Now, government people in the public interest, even though the company has not passed a special resolution, at the public interest people, the government can convert the loan. Let us imagine there is a company X which has taken loan from government. Now, the government people in the public interest, they can decide to convert this loan into equity at its option. If the company is not okay with it, the company can always go and appeal it with the tribunal. Sir, the government is doing unfair things. Can you please help us? The company can go and appeal it with the tribunal. Whatever is the tribunal's order, that will be final. So whether the company has passed the resolution or not while taking loan from the government, that will not have any significance. Is clear? Yes? Okay, done. I hope you guys are able to understand. I'm trying to go as detailed as possible. I think it will be a good lengthy video only. Private placement. Okay, let's start with part D. Yes, people. So let us do the part D. That is, 1 second. So sorry. Okay. Now the next one is people, your alteration, buyback and reduction. Mainly these three things. So let us do the first part, that is alteration. Now what is the alteration of share capital? Whenever any of the 5 things happen, what are the 5 things? First one, if your increase in authorized capital happens, if my authorized capital is currently 10 lakh, if you are increasing it to 15 lakh, you will follow section 61. Next one, consolidation and divide into larger denomination. What do I mean by that? Now take for example, we had 10 shares of 10 rupees each, face value is 100. Now what do? We make this 10 as 5 shares and we increase the face value to 20. The face value will change but not the overall value, that will still remain the same. This is only called as consolidation and division into larger denomination. What if you bring it down to smaller denomination? That is only called as share split. That is, we had 10 shares of 10 rupees each. Now what do? We bring it down to 20 shares of 5 rupees each. This is still same. This is called as share split. And the fourth one is called as conversion of stock into shares, shares into stock. As I told you, I've explained you also in the class, but for this part it is not relevant. So I'm just skipping that part. Do not go there because in India we do not have an instance of a stock getting converted to a share and share getting converted to a stock. So leave it. The fifth one is cancelling those shares which are unsubscribed by the people. That is only called as cancellation. So if you are doing any of these 5 plus redemption of preference share, if you are doing these 6 things, you have to intimate the registrar within 30 days in the form SH7. Is this clear? Hello. Pakka. Done. Okay, done. That is okay. That's your alteration. The next part is people buyback of shares. When I'm doing the buyback people, I need to keep section 68 in mind. What does section 68 say? What are the sources of doing a buyback? It has to be done. Sources are always important. Remember, it can be done using your free reserves, securities, premium account, proceeds of fresh issue. That means I can issue my equity and I can buy back my preference possible. Next one, after my buyback is done, my debt is to equity should not be more than 2:1. If my loan is 2 lakh, my equity should not be less than 1 lakh. Imagine if my loan becomes 3 lakh, if my equity and free reserves are just 1 lakh, it's a very bad company. Third one, all securities should be first fully paid up. Next one, no further buyback shall be made within the next 1 year. That means between two buybacks, people, there should be a cool off of at least 1 year. Sir, today we have purchased equity shares. We have done a buyback. Can I again issue equity shares only in the next month? No, people. It becomes a speculation. That's why there should be at least a time gap of 6 months. If you have purchased it today, you cannot again issue the equity only in the next 6 months. However, there are exceptions. If at all, imagine you want to issue it as a bonus. That's an exception. You can do it. Imagine 5 years back you had issued convertible debentures. That conversion is coming now. You can do it. Imagine if there is sweat equity, you have to give it to your employees. They have performed really well. You can issue it within 6 months only possible. Register of buyback will be in the format SH10. Sweat equity is SH3. SH1 was share certificate, format of share certificate. SH2 was register of duplicate share certificate. SH3 was sweat equity. SH4 will come in the next part, that is your transfer. SH5 is the partly paid, again next part. SH6 is register of ESOP. SH7 is your alteration of capital, which you file it with ROC. And next one, that another important one is SH9, that is declaration of solvency. That is, when you are doing a buyback, you are using your free reserves and all, and you are doing a buyback. So you had money, you are using that to give it back to the shareholders, and you are buying back the shares. And within the next few days, imagine within the next 2 months, 3 months, the company is wound up because of insolvency. They are not able to pay the debt. Now, who is liable for this? The directors are liable. Then why did you first of all go for a buyback? You did not add money then. So the directors have to give something called as a declaration of solvency. That is, you don't worry, we have sufficient money. In the next 1 year, we will never become insolvent. For 1 year, I can't promise for the life. In the next 1 year, I will not become insolvent. It is given in the format SH9, given by the directors. In the next 1 year, we won't become insolvent. If we become insolvent, directors will be liable. As simple as that. Clear? Then, okay, done. Next one, sir. What is the maximum buyback we can do? It depends upon what resolution you pass. If at all you are passing a board resolution, then people, the maximum buyback we can do will not exceed 10% of my paid up equity share capital plus free reserves. If at all I am passing special resolution, then after passing special resolution, if I am buying back my equity shares, then it shall not exceed 25% of my paid up equity share capital. Sir, I am buying back any other security, or the total money I am allowed to invest in buyback shall not exceed more than 25% of paid up share capital plus free reserves. Remember this. Clear? Hello? Pakka? Okay. Declaration of solvency. Return of buyback. Once the entire buyback is done, you need to intimate ROC, right? How many shares you guys purchased back? You will intimate with ROC in the form SH11. Once the buyback is completed, you have to destroy all those shares within 7 days. That's your buyback. Done. And what is the last part left? It is capital reduction. Reduction of share capital. Remember people, 4 approvals are required if you guys have to reduce your capital. What do you mean by reduction? So today my paid up capital is 10 lakh. Now I want to make this 10 lakh as 7 lakh. It can be because of any reason. But I want to reduce. Generally it can happen in 2 scenarios people. Scenario 1. We have extra money. So we will decide to reduce the capital. Because what will he do with extra money? The second one, people, we have incurred losses. That is, we started the business with 10 lakh, but we have lost around 3 lakh rupees in the business. Now the balance sheet looks very bad. You guys only know, no? In your exams, how does your balance sheet look? Left side you will get one number. Right side, pakka will not get LHS equals to RHS. What will you do? Something you will do. Yengenga, that and all you will do. And you will balance it. Correct? No. Remember, the balance sheet which does not tally does not please the creditors. Tomorrow if you go to a bank, you will not get loans. So what do the companies do? The companies will call its shareholders and say, people, this is the scenario. We have lost 3 lakhs. Is it okay even if we reduce our capital from 10 lakh to 7 lakh? Now the shareholders will ask, then what about our 3 lakh? It's gone. That's all. It's done and dusted. It will be removed from our balance sheet. Now what is this called? This is only called as reduction of capital. So how can you reduce the capital? You can reduce the capital in 3 ways. First way, we have say for example 1 lakh shares into 10 rupees each. Total 10 lakh. The shareholders have already paid 7 rupees. 3 rupees they have not yet paid. You can tell, Macha, we have extra money. Do one thing. Let us keep our face value as 7 rupees only. Let us reduce it. 3 rupees don't pay. This is the first way of reducing the capital. When the called up capital is just 7 and 3 rupees is still uncalled capital, you can tell don't pay that and you will reduce the capital to 7 rupees only. The first way. Second way, sir, 1 lakh into 10 rupees each, they have paid the entire 10 rupees. Now what we will do? We will return back the 3 lakhs. They have paid, what else we can do? We will return back the 3 lakh. This is the second way to reduce it. Third way, they have paid but we have lost it. You will reduce it and that is only called as compromise or negotiations. You don't have a choice. That is the third way and that is only called as reduction of capital. Is this clear all of you? Yes. And I told you there are 4 approvals you need to take. One is you need to take the shareholders approval. Of course, you need to pass special resolution. Okay. What is the second approval? The second approval, people, you need to take the approval of NCLT. Tribunal's approval is mandatory. And the next one is people, what is that? Of course, board resolution is of course. Without that, we cannot go to special. And the fourth one, sir, is people, creditors approval. When you are reducing the capital, they should also be okay with it. If they are not okay with it, then people, no, you cannot do it. Sir, what if when we are preparing the list of creditors, what if we have excluded anyone's name? If you have left out anyone's name, people, then your capital reduction will be considered as ineffective. So whatever your previous capital was, that only will be considered as the actual capital. That is your capital reduction. Understood? So you can do it in 3 ways. You will apply with the tribunal. Tribunal will send your application to all the other departments like central government, registrars. If you are listed with SEBI, to everyone we will send. And we will tell them you have 3 months to give your representation. If you don't give your representation within 3 months, we assume it to be a no objection. Now people, tribunal after being satisfied that every creditor is repaid or consent is given, we will allow for a capital reduction. That is your 66. Hello. I hope this is clear. And one more thing, scenarios when the capital reduction is not considered as capital reduction. Important, remember. In the following cases, the diminution of share capital is not to be treated as reduction of share capital. Diminution means people, it is decreasing, but it is not considered as reduction of capital. When you already know 2 scenarios, you already know which one. The first one is people buyback. Second one is people redemption of preference share. In both the cases, the share is going down only, no. The decreasing is happening, no. But still it is not considered as reduction of capital. See, what is that? The first one. First one is redeemable preference shares. Next one is buyback. Easiest. Okay. Third one. This also we have seen. What? Section 61E. What is that, sir? Cancellation of the shares which are not subscribed by the shareholders. Section 61. Cancellation. Yes, sir. And the fourth one, again a easy one. Whenever a shareholder has not paid the call money, what do? We are going to forfeit it. Even the forfeiture is also, the share will go down, but it is still not considered as reduction of capital. The last one, if at all there is any reduction of capital due to the order of tribunal or with the consent of the tribunal, section 230, compromise or arrangement, we will not consider it as reduction. Clear? Next one, reduction of share capital without the sanction of tribunal. Now we saw, to reduce the capital, you need to take board, special, tribunal and creditors approval. In this case, all that is not required at all, it seems. When is that people? The first one is called as people in the case of forfeiture. When he does not pay the call money, we will forfeit. That's all. As simple as that. This one is called, generally doesn't happen at all, people. It's called surrender. What is surrender? Surrender is nothing but, people, it's like Gautam Buddha. What did Gautam Buddha do? Whatever his assets were, he just went and surrendered everything and he just left everything. That is called surrender. You do not transfer, you do not give it to anyone. You just go and give it back to the company itself. He will say, I don't want anything. You will not even take money in return. You will transfer it to the company only. And that is only called as surrender. Generally, rarely, it never happens, but yes. Yes, huh? Okay. The last part, sir, that is part E. Okay. So let us do of part E. Now, what is part E, sir? In part E, section 56 is important. Now, what is 56, sir? It talks about, people, transfer and transmission. First of all, what is transfer? What is transmission? Transfer happens, people. Transfer is a voluntary act. Transmission is, people, happens due to operation of law. Imagine a person becomes insolvent. A person dies. Automatically the legal heirs will get the shares. You are not transferring. You are not signing any document. But the person automatically becomes the owner of it. Now we call that as, people, what, people? We call it as transmission. In transfer, because it is a voluntary act, you guys need to sign SH4. Transmission, no such thing is required. SH4, you need to pay stamp duty, nothing. So these are certain differences, remember. Of course, here it is for consideration, or it may not be also, but here there is no consideration involved, as the case may be. Okay. Now we'll see the procedure of transfer. How do we transfer the shares, sir? First, the transferor transfers the shares to transferee. Using which form? We use a form called as SH4. Once you have signed the agreement, within 60 days, you need to go and submit it to the company. Once you go and give it to the company, imagine we are transferring the shares of, say, for example, XYZ Private Limited. We are transferring the shares. Once you transfer, people, you need to intimate this to XYZ Private Limited. Now they will register the shares from A to B's name within 60 days. Clear? Sir, what if company B does not register the transfer? Then, people, section 58 will come. We will see that. Okay. So we need to submit the share certificate, letter of allotment, all of that. Now imagine, sir, what if this is a partly paid share? Face value is 10 rupees, but the paid up value is just 5 rupees. Another 5 rupees is yet to be paid. It is uncalled. In such case, what will happen? Remember, people, if it is an uncalled capital, then, then you are liable. Now transferor has transferred it to B. With the company, initially A has agreed to pay for it. Now what if B, once the transfer has happened, if a company asks for the rest of the money, now who is a shareholder? B is a shareholder. He will have to pay for it now. But who had initially agreed with us? A has agreed. So that's why, remember, if it's a partly paid share, the company will check with B. Do you know that it's a partly paid share? we will give you a notice, intimation. That intimation will be given in the form SH5. Excuse me. Yeah, it will be given in the form SH5. Now B has to respond to this within 2 weeks. If B does not respond, people, we will assume it to be a deemed approval. Is clear? Hello? Pakka? Okay. Okay. Next one, sir. See, private company refused. We gave. They did not register the transfer. Then what should they do? Within 30 days of we giving the instrument, they have to what? The company shall give a notice to the transferor and transferee within 30 days of receipt of the notice. So we gave them the instrument. They have to reply to us within 30 days. Now imagine they replied. We are rejecting the. We don't want to transfer it. Then what will I do? Within 30 days of them giving me a reply, I will go and appeal it to the tribunal. Sir, you know, we gave a request, they rejected our request, can you please help us? I will go within 30 days. Sir, what if they did not reply at all? If they don't reply at all, then from the day I gave them my instrument, within 60 days, I will directly go because they have 60 days, no? Sir, if they don't reply at all, then what will I do? Within 60 days of the delivery of instrument, people, I will directly go and appeal it to the tribunal. Yes. This is in the case of private company. In the case of public company, we need to consider this as 60 and 90 days. That's the only difference. Clear? Okay, that is your transfer transmission. Can we transfer the shares to a minor? The answer is yes, we can transfer, provided it should be signed by a guardian. And remember, people, it has to be a fully paid share. If it is a partly paid share, people, then in that case, the transferor only will continue to be liable. Can we transfer shares to partners? Remember, a partnership firm can never become a member. Not possible. Can we give it to a body corporate? Yes, possible. Demat mode, it's okay. You can skip it here. Don't give much of the preference. If it's a forged transfer, will it give you a valid title? Answer is no. What is forged? Someone else signed A signature. They transferred it to B. Will it give a valid title? Answer is no. It is never a valid transfer. You can always remember, a forged transfer will never give you a valid title. Remember that. What do I mean by transposition? Transposition means nothing but people. There are joint shareholders. Say for example, A and B. They want to change this order. They want B to come first and A to come second. They can make a request to the company, and this is only called as transposition. Changing the order. Why? Because by default, whosoever name is written first will always enjoy all the rights, like right to vote, dividend, and all of that. And remember, at any given point of time, if they decide, hey, let us not have it as a joint, let us split, they can always write it to the company asking them to split the share in the proportion they are asking. They will issue two different certificates. You have a right as a shareholder to ask for this. Remember, they can ask you this. Okay. Relation between transfer and transferee, we'll see this also in dividends chapter, something called as abeyance. We'll see that. Right of transfer, effect of transfer. Okay, what is the checklist for a company secretary? Make sure that the form is properly filled. SH4, if it's partly paid share, then you will issue SH5. If it's a joint share, then all the shareholders have to sign, and all the other details are properly filled. So all of that you have to keep it in mind. Checklist for company secretary, just go through that. Demat, it's okay, you can leave it because it all comes majorly in your what do you say, CMSL. Here it will not be that important. Yes, so these are the main topics as such in this particular chapter. Yes, people, let's start the next chapter, that is your chapter 9. Okay, so let us directly go to our chapter 9, that is books of accounts. So what and all should be maintained by technically every company, right? There is no exception as such. So you have to maintain your books of accounts, books and paper. What and all is coming under books of accounts? It includes all the amounts which is received as well as expenses, assets and liabilities of the company, sales and purchases of goods and services, items of cost. That is nothing but your last one, cost records, cost audit, we'll be seeing when we are doing 148. You'll also maintain books and paper. Okay, from exam point of view. Financial statements. What and all does financial statement include? It includes balance sheet, P&L account, cash flow statement, statement of changes in equity, and explanatory note. So you will maintain all these particular details if at all you are maintaining it for every company basically. Agreed? Okay. Okay. So yes, people. So financial statements includes balance sheet, P&L, cash flow statement, statement of changes in equity, and explanatory note. Certain companies are exempted from preparing cash flow statement, and who are the people? They are your OPC and small company and dormant companies and startup companies. All these companies are exempted from preparing the cash flow statements while they are preparing the financial statements. Important exam point of view, remember. Okay, general requirement in preparation of books of accounts, it has to always give true and fair view. Okay, it shall be prepared every financial year. Explain the transactions of registered office has to be kept separate, branch office accounts has to be kept separate. Always remember, you have to prepare separate accounts for branch office. Those books will be maintained in branch office. Even those accounts shall also be audited. All three are important. Agreed? Next one, accounts should always be maintained on accrual basis, double entry system. Place of maintenance of books of accounts, where do we maintain it? You generally maintain it at the registered office of the company, or you can maintain it in any other place also. Which place? Any other place in India after passing board resolution. Do not get confused between this point and register of members. Their special resolution, more than 1/10 of the population, all that will come into picture. Here all those conditions will not come. So keep this thing in mind. Okay, so just pass board resolution and you need to intimate the ROC, sir, going forward, my books of accounts will not be here, it will be in this place. You have to maintain it, you have to mention that to the ROC in form AOC 5 within 7 days. Done. Okay. So books of the branch office, whether in India or outside, the books shall be kept at the branch office itself, provided a summarized returns shall be sent to the main office every quarterly once. So on a regular basis, you maintain your books outside India only. But once in a quarter, you summarize it and you send that books to your head office. Inspection by directors. Directors can inspect the books. Yes, possible. Any director can inspect the books during the business hours. Whether non-executive, independent, executive, anyone can inspect. he can inspect the books of subsidiary company only after authorization by the board of directors. So can you check this books of subsidiary company? Yes, possible. But yes, it should be authorized by the board of directors. Next one, the financial information maintained outside India can be requested by the director to the company and it shall be provided within 15 days. Imagine we have a branch office, or if we have any other details of the company that belongs to the company outside India, if we have maintained, any director of the company can say, Sida, if I go, it will be very expensive. Rather, can you send me those books here only? I just want to check it. So you can just make a request. Remember, from the day you make a request, within 15 days, those books has to be given to that concerned director. Remember, those books has to be personally asked by you, and you should not ask it through any agent or any advocate or any attorney. It should always be a personal request. Just a second. These guys will take AC remote. They will make the AC one room heater. Okay. Next one, period of preservation. How long will you maintain the books of accounts? The books of accounts, the vouchers and all the supporting documents shall be preserved for a period of 8 years preceding the financial year. That means if at all you are in the year 26-27, don't count the current financial year. Leaving that from 25-26, you have to go back 8 years. This is 1. 2, like that 8 years. You have to maintain it for a period of 8 years. Is clear? Sir, who are the persons responsible to maintain the books of accounts? Very important, remember. It is a responsibility of the managing director, whole-time director in charge of finance, CFO or any other person authorized by the board. They may ask you a question here. Whose duty is to maintain the books of accounts? It's managing director, whole-time director in charge of finance and CFO or any other person authorized by the board. Tomorrow, if there is any non-compliance with regards to maintenance of the books, who will be under liability? These people will be under the liability. Sir, next one, this books and all, how should we maintain? You can maintain it in physical form or you can even maintain it in electronic form. Remember, from 2023 onwards, people, you have to maintain, you can maintain it in electronic form. Like for example, you can use it SAP, you can use Tally, you can use Zoho books, whatever are the software, you can use all of this. Provided you can use only those softwares which has audit trail feature in it. Now, what do I mean by audit trail, people? Audit trail means nothing but whenever if there is anyone who is changing the entries made, imagine you are editing or you are deleting an entry of some entry of past in the past. You are deleting it, you are changing the things. It should clearly tell if any edit is made, any entry is deleted, who deleted it. That entire option we should be able to capture. Only such softwares you can use. Zoho allows you to do it. Zoho books. So audit trail feature is mandatory. So the manner of books of accounts to be kept in electronic form. The books of accounts and other relevant books and paper shall remain accessible in India. So if you are maintaining it electronic mode, it should not become in a way that you are not able to access it from India. You should be able to access it in India at all times so as to be usable for subsequent use. So not even 1 second. It should not be a case where we are not able to access the books. At any given point of time, you should be able to access the books. The books of accounts and all the relevant papers shall be always maintained in the original format. Okay. Audit trail, which I just said. The information received from branch office shall not be altered. As it is, you have to maintain it in the principal book. The information in the electronic record shall be in the legible form. For example, if you take fuel bills, it will fade away after some point of time, right? So it should be readable. There shall be proper system for storage, how to store the data, retrieval, how to take it whenever you want, display whenever you want to see, print out of the electronic records. So the system, whatever you are using, should be able to support all these things. Provided that the backup of the books of accounts shall always be kept in servers physically located in India on a daily basis. What do I mean by that? Imagine we are using some software, something which is not from India. They're telling you in such case, you have to always keep one backup in such a software which is physically located in India. If you look at Zoho books is from India. So one software should be in such a way that it should always be physically located in India. That is what they're telling you. And the company shall intimate to the registrar on an annual basis at the time of filing of financial statements. So you'll be filing AOC 4, right, every year. In that, you have to clearly mention these details. What are these details? We are maintaining our books of accounts over a software, right? So you have to disclose the details of that software, like the name of the service provider, Zoho, the location of the server, where it is applicable, wherever the location is, mention that. Where the books of accounts and other books and papers are maintained on cloud, such address as provided by the service provider. You will have, right, IP address and all. You maintain all of those address has to be given to the registrar when you are filing AOC 4. Okay, next one. So financial statements. How to maintain financials? Same thing. True and fair view. It shall be in the format that is Schedule 3 of Companies Act. That's the format of your financial statements. Sir, and this is very important thing. The company should always comply with the accounting standards. Sir, what if we do not comply with the accounting standards? Then, if at all, imagine people, law says I need to follow WDV method of depreciation. Instead of WDV, I followed SLM method. I'm just giving you an example. I have to disclose 3 things about that. What is that? Sir, I did not do WDV, I did SLM. Why? Reason. Third one, what is the benefit I gained because of the alternate method I used? What is the financial effect of the deviation? I have to disclose all of this. Clear? Non-applicability of section 129, meaning the schedule 3, all of that will not apply to some company systems. Which one? Insurance companies, banking companies, and companies which are engaged in production and supply of electricity, and any other company for which any other specific format of financial statements are specified. So they need not have to follow this particular section. Okay, board shall lay full documents in AGM. So in the annual general meeting, all the financial statements of the company has to be laid before the AGM. Correct? Adda. In Adda, the first year itself is what? Adoption of the accounts. I have to give it to the members, right? They have to accept whatever our expenses, revenue are in the during the financial year. We have to tell that, right? That is what they're telling you. Next one, we have to file consolidated financial statements of all the subsidiary and associate companies. What do I mean by consolidated financial statements? I have to file it of my subsidiary companies, my associate companies together. We have to present it, people. It has to be prepared as per the accounting standards. Sir, every time we have to prepare consolidated financial statements. Yes, every time you need to prepare. But there is one exception. What is that exception? It is if it is an unlisted company or not in the process of listing, whether in India or outside India, then people CFS will not apply for you. So if you are unlisted companies, for you CFS is not applicable. Next one, it's holding or intermediary holding company files CFS with ROC. What do I mean by that? Imagine there is company X. It has a subsidiary company. It has a subsidiary company. Imagine this is the holding company. This is a subsidiary company. So let us imagine if company X has already prepared the CFS. Why should company Y again prepare? That is what they are telling you. If it's ultimate company or an intermediate company, if they have hold or they have prepared a CFS, again you need not prepare CFS. That's what they are trying to tell. Third one, it is a wholly or a partly owned subsidiary of another company and all its members have given no objection on non-presentment of CFS. What is this, sir? There is a company X. The company X has a subsidiary company. Imagine we are holding 55%. Now company X does not want to prepare CFS. Now company X is okay with it. Not only that, In company Y, whoever are the other shareholders, imagine people, whoever is holding the rest of the 45%, even they will also have to give a no objection. Sir, we have no problem if you don't prepare CFS. It's totally fine. If you satisfy these conditions, people, CFS is exempted. Next one, exemption by CG. That is, this section can be exempted on any company if there is a special request made by the company and CG is convinced, or CG on its own thinks that in the interest of public, this company need not have to follow all the sections. CG can exempt you from following any of these provisions. Clear? Okay. All other sections related to financial statements, let us finish it off. Who shall sign the financial statements, people? The financial statements shall be signed by chairperson if authorized by the board. So what if chairperson is not authorized? Then two directors have to sign. In that two directors, one shall be a managing director. If there is no managing director, then only two directors will sign. And CEO, CFO, CS if appointed. Very, very important. Remember, imagine if your company has a CEO, your company has CFO and CS. Then remember, people, all three people have to sign, not only any one. All three people will have to sign. Yeah, so it will be one chairman or two directors and CEO, CFO, CS. Sir, what if it's a case of OPCA? Then people, only one director is sufficient. You need not have to get it signed by all the rest of the people. Clear? Okay. And one more connected. All connected sections will do it together. Okay. Periodical financial results. What does that mean? See, every year, people, a company has to prepare its financial statements, yearly ones. It has to be audited yearly ones, and it has to be filed with the registrar also yearly ones. However, if central government thinks that in the interest of the public or because of any reason, central government can direct any company to prepare the financial statements at such intervals, get it audited at such intervals, file it with the government at such intervals as may be prescribed by central government. I can prescribe whatever is the time. That is this periodical financial results. Clear? So prepare financial on such periodical basis. Limited review of periodical financials, that is audit as may be prescribed. File it with the registrar within 30 days of completion of the relevant period. Which relevant period? As may be prescribed. I can tell you to do any of these three things. Clear? Okay, done. And rights of members to copies of audited financial statements. Should we send it to the members? Of course we have to send. By when should we send? We have to send it, people, along with the notice of general meeting only you will send. So of course you will send it 21 days prior. So technically you will send it along with the notice of general meeting itself. Clear? Okay. Whom shall we send it to, sir? We will send it to every member and every debenture trustee, if at all there is any, and to all other persons who are entitled. Remember, every member includes equity as well as preference. We will send it to both. Timeline 21 days. Sir, what if general meeting is conducted in a shorter notice? If you guys remember that 95% condition and all. When that condition comes, I'll tell you the same thing will apply here also. So if it's conducted on a shorter notice, then you can give it even in a shorter period as well. That is absolutely fine. Sir, if it is a listed company, then what are they telling you? According to the listed entity shall give prior intimation to the stock exchange about the meeting of the board regarding the financial results wherever it is conducted. Meaning, in whichever board meeting you are going to conduct or you are going to discuss about the financial results, you need to disclose about such meeting to the stock exchange well in advance. Intimation shall be given at least 5 days in advance. Yeah, now it is made 2 days as per SEBI provisions. Yeah. A listed company, this first it was 5 days, now it is 2 days. But unfortunately in our books and all, it is not yet amended. A listed company shall also place its financial statements, including CFS if any, and all other documents required to be attached on its website. I'll also have to maintain all these documents on the website of the company. Provided also that every listed company having a subsidiary or subsidiaries shall place separate audited accounts in respect of each of subsidiary on its website. Now, what do I mean by that, sir? Imagine if I'm a listed company. If I have a subsidiary company, they are telling you I have to publish my company financial statements on website. I'll also publish CFS on the website. If I have subsidiary company, their standalone financial statements also shall be published on the company's website. Which company? The holding company's website. Hello? Sir, whether this should be audited or the subsidiary company accounts, should it be audited or it's unaudited? It has to be audited, of course. Sir, what if, imagine my subsidiary company is not from India, it is from imagine some country outside India. So in that country the audit is not required. Remember people, if in such country if the audit is not required, then it is okay just to come and present the unaudited financials only with the declaration that I come from a country where audit is not mandatory. Sir, what if it's not in English language? You have to also get a certified translated copy which is in English language. Okay, the 21 days, whatever we saw, it has to be sent 21 days prior to the date of the meeting. Okay, next one. So we are saying that we have to send the financial statements to the members, right? How do I send it? Simple people, if you are a listed company, today's date this limits and all makes irrelevant, but yes, still they say, if at all you are a listed company, and all the public companies which have net worth of 1 crore and turnover of more than 10 crore, then people, they will send all their financial statements and all the supporting documents by electronic mode. If a person's shares are in demat form. So if your shares are in demat form, we will send you all the details by electronic mode. Sir, what if my shares are in physical form? We will ask you, is it okay if we send it in electronic mode? If you agree people, then we will send it in the electronic mode. Sir, what if I don't agree for electronic mode? Then for such people, we will have to give it in a physical copy. But remember, the company is free to charge you for the physical copy. Clear? Yes. Sir, copy of financial statements to be filed with the registrar. Now, what is this, sir? Once the company's okay, company, once it's adopting the financial statements, now what do? The company will have to file the financial statements with ROC. Now, what is the format of the financial statements, sir? The format people will be, if it's a normal company, it is form AOC 4. Sir, if I have to prepare the consolidated financial statements, CFS, how do I prepare? It will be in AOC 4 CFS. Sir, for some companies, XBRL will apply. How do they file? They will file in AOC 4 XBRL. Hello? Clear? And remember, which financials we will file? You will always file the financials people which are adopted in the annual general meeting. Sir, what if the financial statements are not adopted in the annual general meeting? Then we will file something called as unadopted financials only. The ROC will consider such unadopted financials as provisional, temporary. And once you guys again conduct the AGM, and if the shareholders adopt your financial statements, you have to file such adopted financial statements again with the registrar. Sir, what if subsequently we were not able to adopt the financials? It's okay. You will file that unadopted financials only, and imagine you were not able to adopt because you did not conduct a AGM at all. In such case, you have to file unadopted financials with the reasons for not conducting AGM. That is what is given in the whole paragraph. Done now? Done. When do we file the financials, sir? You will file it within 30 days of AGM or the due date of AGM. If it's a case of OPC, of course there is no AGM. Then they will file it within 180 days of the closure of financial year. Remember this and go. XBRL is mandatory for whom, sir? Very important. It is mandatory for companies which are listed with stock exchanges in India and their Indian subsidiaries. So Indian listed companies and their Indian subsidiaries, whether you are listed or not, for all of you people, this becomes mandatory. Next one. Companies having paid up capital of rupees 5 crore or more. Companies having paid up capital of rupees 5 crore or more. Companies having turnover of 100 crore or more. Or all companies which are required to prepare financial statements in accordance with Companies Ind AS rules. So whichever companies come under this brackets, for them XBRL format is mandatory. XBRL is nothing but people, it's just a format. Financial statements is still the same. You're reporting financial statements only. But how you are reporting is changing, that's all. What you are reporting does not change. How you are reporting alone changes. Is clear? All of you? Pakka? Okay. Okay, fair enough. The next one, sir, is your reopening of accounts. We'll do that. There are two types of reopening of accounts. One is mandatory, next one is voluntary. Mandatory people, what is reopening of accounts? Let us imagine we are in the year 26-27. In the year 22-23, we have done some fraud. We have tried to cover some, fraudulent numbers. That is, we have inflated the financial statements or we have done some fraud. We are trying to cover it up now. Now imagine IT authority, when they were doing an inspection, they got to know that this company has mismanaged their statements. Or SEBI, in the case of Harshad Mehta, Satyam scam, SEBI got to know that this company has done all fraud. Now what will SEBI do? SEBI will file an application, people, to the tribunal and say, sir, we don't know whether whatever financials that the company has filed in 2022, 23, 24, 25, whichever is a year, we doubt on their genuinity. We think that they have done some fraud. Can you please allow us to go back to that year, open all the books of accounts, recheck it, reconfirm whether whatever the numbers they have mentioned, is it right, is it fair or not? Now what will the SEBI do? SEBI will file an application to the tribunal. What will tribunal do? Tribunal will forward this application to all the other authorities like central government, like ROC, like income tax authorities, any other authorities. The tribunal is going to forward the application to all these people waiting for their objections. Now if anyone has an objection, people, it will go to hearing. Sir, what if there is no objection? Then people, it is assumed that it is deemed approval. We don't have a problem. Clear? All of you? Sir, when do we generally do this? If we think that the accounts or whatever the books of accounts that were prepared by the company, it was in a fraudulent manner, or the affairs of the company was mismanaged, meaning that the director is not a good fellow. He has mismanaged the the money of the funds, the money of the company a lot of times. In such cases, you are allowed to go and reopen your financial statements mandatorily because of the court's order. Is this clear? Sir, what if they did not tell? We only realize that it's not fraud, but whatever we have reported is wrong. Then what can we do? In such case, people, you will go to the next section, that is section 131, voluntary revision. Whenever a company thinks that we have not properly complied with section 129 and section 134, that is board's report and financial statements, we only think we have done some mistake. In such case, what will happen, people? We will file an application to the registrar, to the tribunal. The tribunal will again forward the application to all the other authorities. If the authorities have any problem, they will give a objection. If they have no problem, people, then you can go ahead with your voluntary revision. Simple. Sir, mandatory revision can happen for the last 8 years. But voluntary revision you cannot do for a period beyond 3 years. Remember, that's the difference. Clear, Ram? Yes, Ram? Okay, the last sections are technically not that important also. This is NAFRA. For us, it is not that important. What is NAFRA? NAFRA is nothing but, people, National Financial Reporting Authority. It was formed to recommend and pass accounting and auditing standards. So for our domain, it is not that relevant. So NAFRA also makes sure it oversees the work of the professionals, whether they are doing right or wrong. If at all any professional does work which is not up to the mark, it will advise on what are the changes. And if anyone has done a fraudulent action, NAFRA can even penalize such person. And NAFRA is again a body corporate which is established by the central government, and hence the NAFRA books of accounts are also audited by CAG. CAG also prepares an annual report which will be submitted under both the houses of parliament for the members' approval. So remember this much and go from NAFRA. NAFRA is more than sufficient. They will not go any much in detail. What is the penalty prescribed by NAFRA? Why is NAFRA formed, people? Imagine there is a CA. A CA is appointed to audit one company. What if the CA only has not audited this company properly? So NAFRA will oversee how this professional has done his work. That is only the job of NAFRA, oversee the work of the professionals. So what is the penalty? If tomorrow if I get to know you have done something, then I can impose a penalty. If at all you are an individual, I can impose a penalty of 1 lakh which can extend up to 5 times of the fee you have taken. If you are a firm, the minimum will be, people, 5 lakh which can go up to 10 times of the fees you have taken. That's all, sir. You can also be debarred for how many days, sir? Minimum 6 months. That's all. It can go up to maximum 10 years. You cannot take up any audit, nothing. Hello? That's all? Yes, that's your NAFRA. Accounting standards, that's okay. Okay, let us do the appointment of audit and auditors. So as I generally say, this chapter has 2 parts. One is accounts, one is audit. So this is your part A. Now let us start our part B. So what is there in part B? Yes, people. So in the auditors, appointment of auditors. So as you all know, I can write the types of auditors as 4. Which is the 4th one, sir? The first one is, people, the statutory auditors. The statutory auditors, that is only CA. Next one is, people, secretarial auditors. This is only CS. Next one is, people, the cost auditors. This is only your CMA. Sir, this we know, which is the 4th one. The 4th one is called as internal audit. That is what is there in our syllabus. All 4. Yeah. one thing you guys have to remember, easy tip that I can give you. The statutory auditor, only the first auditor is appointed by the board. Rest of all the statutory auditors are appointed by the shareholders in the AGM. Who appoints them? Shareholders appoints them, except the first auditor. The first auditor is appointed by the directors only. Sir, apart from that, these three people, it is appointed, remunerated, everything people, the appointment is done by board of directors only. They are appointed by shareholders. Remember this, very, very important. Clear? Same thing applies even to the KMP also. Who appoints the KMP? It is the directors who appoint the KMP. Clear, all of you? Okay. So, sir, appointment of auditors. The first auditor, sir, depends upon the type of company. If it's a government company, then who appoints? Within 60 days of incorporation, the Comptroller and Auditor General of India will appoint the first auditors in a government company. Example I can give you is ONGC. All the government companies or the government entities, statutory companies, all their audit is done by people, the CAG only. Who is CAG? Comptroller and Audit General of India. They will appoint the auditor. He will report to them. So within 60 days they will appoint. What if CAG is too busy? They are not able to appoint. Then people, within next 30 days, the directors will appoint the first auditor. Sir, what if even the directors also fails to appoint within 30 days? Then people, within next 60 days, the shareholders will appoint. Now I know your question. What if even shareholders also does not appoint? Then die. Then how long we can keep on going like this? Yes. So next one, what if I'm any other company? Any other company means not a government company. It can be private, public and all. In that case, people, within 30 days of incorporation, the first auditor will be appointed by the directors. Sir, what if the directors fails to appoint, sir? Then it will be shareholders within 90 days. Remember, this is the first auditor. Sir, what about the subsequent auditor? Remember, whosoever is the first auditor appointed by the directors, their validity will be only 1 year. Meaning the company is incorporated today. The company will conclude its first financial year and they will conduct their first AGM. In the first AGM, now they are going to appoint anyone else, or the same fellow can also be appointed, or you can appoint someone else in their position. That is also fine. But in the first AGM, the current auditor, whoever is appointed by the directors, now that person will have to retire in the first AGM. Clear? Yes. Now whosoever is an auditor appointed in the first AGM by the shareholders, he shall hold office for a period of 5 years. Clear? All of you? Yes. Okay, done. Easy breezy. Next one, tenure or rotation of auditors. First of all, is this rotation of auditors applicable for everyone? Answer is no. Why did rotation even come into picture? It all started because of the scam that happened in Satyam. What happened? There was so much of scam that happened in Satyam for years, but the world never got to know about it. So the authorities said, if at all you guys had done that particular thing properly, if you had, alerted the people that there is some fraud, then all of this wouldn't have happened at all. By that time, the internal auditors were PwC. So what did the authorities say? It is all happening because they are getting used to the environment. You have been an auditor for 5 years, 10 years, 15 years. So what happens? You become a friend of them. So you will not be able to achieve your objective. You will not be able to perform your duties to the best of your abilities. So what do? You tend to miss out. You may be little more lenient. You may become biased. So they say nothing doing. After 5 years, it is your duty to leave the company and next auditor will come and take over your position if you are an individual. Sir, what if I am a firm? Then you can be there on the board for 2 terms of 5 years. After that, there will be a cool off of 5 years. So someone else has to come and take up the appointment. Sir, this condition is applicable to every company. No, it is only applicable to listed companies. Unlisted public company having paid up capital of 10 crore or more. Private company having a paid up capital of 50 crore or more. All companies having borrowing from financial institutions, banks, public deposits of 50 crore or more. For these companies, rotation of auditors will apply. If it is applicable, then an individual can be an auditor maximum for a period of 1 term. After that, there is a cool off period of 5 years. If you are a firm, 2 terms of 5 years and 1 cool off period of 5 years will be there. So 10 years, 5 years cool off period. Okay, next one. Yes, one more thing is you can never appoint the firm which has a common partners. What do I mean by that? Let us imagine we had appointed A, B, C and Co as our auditors. Now their 10 years is done. Now we need to appoint one more auditors. The next auditors is called as people C, D, E and Co. So here and here there is a person called C who is a common partner. If there is a common partner, you cannot appoint such a audit firm as the next auditors. Purpose not served, no. Next one, casual vacancy of auditors. What do I mean by casual vacancy? If at all they leave, then what is going to happen? In case of company whose audit is done by CAG, then if at all there is any casual vacancy, within 30 days people, CAG shall fill that vacancy. Within 30 days, if CAG does not do it, then people, the board shall fill the vacancy. Sir, in the case of other companies, within 30 days, board will fill the vacancy. But just like your debenture trustee, if at all the vacancy is due to resignation, then remember people, the board only will fill the casual vacancy. However, within the 3 months of the board appointing the auditor, it should be approved by the shareholders as well. You have to call for a general meeting. You need to take the approval of shareholders. This person will hold the office up to the conclusion of one AGM. That AGM, once the AGM is completed, again in the AGM you will appoint one more person for a period of 5 years. Hello. Okay. Next one, reappointment of retiring auditor. A retiring auditor may be reappointed at an AGM. So technically what happens, imagine if rotation provisions are not applicable to me. Then what happens? The same auditor can be reappointed for 5, 10, 15, 20, 30, 80. How many years you want? You appoint. Why? Because if rotation is not applicable, then you can have the same auditor, no? So they are telling you the same auditor can be reappointed provided he is not disqualified. He has not given his unwillingness. He has said, no, I don't want to continue. Or the company has passed a special resolution. We don't want this fellow. No auditor is appointed or reappointed. The existing auditor only can continue. Provided if he is not disqualified and no other fresh person has been appointed, then the existing auditor only will be automatically reappointed. Next one, sir, section 115. What is this? Resignation removal. Means section 140 read with 115. Nothing but people special notice. In management and administration chapter, this will come. Special notice. What is that? A few shareholders, they are unhappy with the way auditor is performing his duties. So we will request the company, sir, please can you remove this auditor, or please do not reappoint this person, please reappoint someone else in his position, or remove him from the job. Now this is only called as what people special notice. How do we do? Imagine a shareholder gives a request of removal of an auditor. He will give a request to the company. What will the company do? The company will forward that request to the auditor. The auditor will give his reply. Now all of this will be circulated to the other shareholders as well. But if someone thinks this auditor is doing all of this for needless publicity, you can stop that auditor's comments being circulated to other members. You can stop it by filing an application to the tribunal. You can say that, sir, this person is doing all of this for needless publicity, and you can stop the circulation of the comments passed by the auditor. Hello, sir, and always remember, if you want to remove a secretarial auditor, cost auditor, internal auditor, you can remove it just by directors. If they want, they can remove. If you want to remove a statutory auditor, then remember, the approval of central government and shareholders both are required. So first, what will you do? You will first pass a board resolution. Within 30 days of board resolution, you need to apply for central government's approval. Sir, we want to remove him. Is it okay? You have to prove it. Why you want to remove? You will apply it in the form ADT 2. Once the central government gives you a reply, you need to now call for a shareholders meeting and you need to pass a special resolution. See, all these conditions you need to satisfy to remove an auditor. Clear? Okay, next one, resignation by auditor. You can resign. Of course, it is your choice. You can resign it by writing in the format ADT3. You will inform to the company. You will inform to the registrar. And if you are listed, you will also inform to the stock exchanges and SEBI. And if you are a government company, you need to also inform to CAG. Remember. Hello. That's all. That's your section 140. Section 141, sir, which speaks about what? Qualification, disqualification of auditors. Okay, who can be an auditor? Of course, you need to be a chartered accountant, or you can even appoint a firm as a auditor, provided the majority of the partners has to be qualified to be a chartered accountant. So disqualifications, who cannot be an auditor? First one is a body corporate, meaning a company cannot be an auditor. LLP can be, but a company cannot be. Next one, an officer or employee of the company. So you cannot appoint your own employees or officers as your auditor. Of course, they'll be biased. Next one, a person who is a partner or who is in the employment of an officer or employee of the company. What do I mean by that, sir? We cannot appoint, let us imagine, we are planning to appoint a person in a company. Let us imagine we are planning to appoint a person in Reliance. Now in Reliance, there is an officer. Who is this officer? Let us take, for example, the managing director. Who is he? Let us imagine Mukesh Ambani. Mukesh Ambani has one partnership firm. In this firm, there is one more partner with him, called as, let us imagine, Mr. Yash, who is also a partner in the partnership firm where Mukesh Ambani is also a partner. They are telling you, Mr. Yash cannot be appointed as an auditor of Reliance company. Next one, Mukesh Ambani has one other company. Let us imagine Jio. In that, there is one more employee who is working in Jio. Let us imagine that is Mr. Shah Rukh Khan. Shah Rukh Khan also cannot be appointed as auditor of Reliance Industries. That is what they are telling you. An officer, the partner of the officer or the employee of the officer cannot be appointed as a auditor of the company where the officer is working. You cannot have the same person. You cannot have this person as a auditor because you will be biased. Clear? Okay. Next one, a person who is or his relative or partner holding any security in the cash, that means company, associate, subsidiary or holding, or a subsidiary of such holding company, provided that relative may hold security face value not exceeding 1 lakh rupees. What do I mean by that? We are planning to appoint a person in Reliance Industries as an auditor But if this person is holding any shares in Reliance Industries, he is disqualified. Sir, what if I'm just holding one share? Even then you're disqualified. Either sell it off. If you hold it, you are disqualified. Sir, we are in a partnership firm, ABC. Then none of your partners should hold any shares in the Reliance Industries. Sir, what if Mukesh Ambani's wife, let us imagine Neeta Ambani is a shareholder. I'm just giving you a generic scenario. Let us imagine he is not a managing director or anyone. We want, okay, let us imagine not Mukesh Ambani at all. We want to appoint a person called as Mr. A as an auditor in Reliance Industries. Now imagine Mr. A's wife is holding shares worth 50,000 rupees in that particular company. Now the question is Mr. A qualified to be appointed as an auditor? Answer is yes. Relative can hold up to 1 lakh. Sir, is it like wife 50,000, father 50,000, son 50,000, brother 50,000, sister 60,000, mother 50,000? They are telling you people, it is not written specifically. So we always take it as a consolidated. All the relatives put together cannot exceed 1 lakh. And 1 lakh is not market price, it is face value. Very important, remember. Okay, done. Next one. A person who is indebted to cash, that means company, associate, subsidiary, holding company. A person who is indebted, that means what? I have taken loan. How much? In excess of rupees 5 lakh. Up to 5 lakh is okay. But if you have taken a loan in excess of 5 lakh rupees, you are disqualified. A person who has given a guarantee or provided any security in connection with indebtedness of money exceeding 1 lakh rupees. That means I did not take loan, sir. My friend took it, but the auditor has given the guarantee. Then people, if he doesn't pay, you will have to pay. No, then you will be biased. You cannot be a auditor. Next one. A person or a firm who whether directly or indirectly has business relationship with cash, subsidiary, holding, associate company, the business relationship is considered a commercial purpose, except commercial nature of professional service and the ordinary course of business. What is this people? Hey people, simple da. Imagine there is a company called as Swiggy. Now Swiggy will appoint a person as an auditor. Now he has come to the company to work. One day he was feeling hungry, so he opened his Swiggy app. He selected whatever he wants. The Swiggy person came and delivered the food. Now if you look at it, this person had a business transaction with the company in which he is an auditor. That is what they are telling you, no. A person or a firm, whether directly or indirectly, has a business relationship with the company, associate, subsidiary or holding. It's a business relationship. Now you tell me, is the auditor disqualified? They are telling you, no, he is not disqualified. Why? Because this is entered in the ordinary course of business. Now the only important thing we need to check here is, at what price did this fellow get this food? Did he had any special coupon called as auditor? If answer is yes, he is disqualified. Arm's length price means how much ever you and me are paying. If he is also paying the same amount, then people, there is no restriction. He can be appointed as an auditor. Clear? Next one, a person whose relative is a director or is in the employment of the company as a director or KMP. What do I mean by that, sir? Let us imagine there is a person in Reliance Industries. There is Mukesh Ambani who is a director. Mukesh Ambani's relative, let us imagine anyone. Now if imagine, say for example his wife, if we want to appoint his wife as a CA, they are telling you it is not possible because her relative is a director. Her relative is a KMP and hence even she is also disqualified. Hello. Sir, what if Mukesh Ambani is not a MD? He is just a software engineer there. Then that's absolutely fine. This restriction applies only and only for a director or a KMP. If he is any other employee, then the relative is not disqualified. If such person or partner is 20, what is this, sir? Remember, people, the maximum number of audits that an auditor can undertake will not exceed 20. So one auditor can be an auditor of maximum 20 companies. However, in this 20, certain companies are not counted. Which is that company? Dormant, not counted. OPC, small company. And private companies having a paid up share capital less than 100 crores. These companies are not counted in the limit of 20. So you can be an auditor of, imagine if there is a small company, you can be an auditor of even 200 small companies also. Absolutely fine. Because it is not counted in the limit. Hello? Okay. That's your auditor. What are the powers of auditor? Basically to ask for any information, get all the information, check all the records. He has a right to access all the documents, whether that company's branch, subsidiary companies to prepare CFS. I can check everything. That's my right. Duties, I have to make sure all the accounts are prepared true and fair. The personal expenses are not recorded in business. So all those things I need to make sure. The main thing, go to audit of a government company. So remember, whenever an auditor submits his audit report to the Comptroller and Audit General of India, CAG, CAG can do three things. The first thing, if I think this person has done the audit properly or not, I'm not sure, I want to check. How will I check? I can conduct something called as test audit. What do I mean by test audit? That means I can randomly check it. Whatever you have done, you have already audited, no? That only I will randomly check it. Next one, I can also do something called as supplementary audit. That means I'm not happy with the audit you have done. I can appoint one more person. I can get the entire audit redone. That is called supplementary audit. And the third one, I can even pass comments. CAG can pass comments on whatever are the audits that it has done. It can pass its comment on it. That is the third thing that the CAG can do. Hello. Clear? Okay. Next one, reporting of fraud. Whenever an auditor is doing his job, he comes across a fraud. How will he report the fraud? The auditor will report the fraud in this way. If the fraud involved is rupees 1 crore or more, whatever is the amount of fraud, if it's 1 crore or more, within the 2 days of the auditor getting to know the fraud, he needs to immediately write a notice to the audit committee. If there is no audit committee, then to the company's directors, saying that people, I came across a fraud. This is what I was able to know. This is what I was able to make a note of. What is your opinion on this? The company has to reply within 45 days to the auditor. Now, once they reply within 15 days, the auditor will forward to the central government. The auditor's notice plus the reply given by the directors, both I will forward it to the central government. Sir, which central government? I'll forward it to the Secretary of Ministry of Corporate Affairs. That, sir, we sense that there is some fraud that has taken place. And we report all of this in the format ADT4. Hello. Clear? Sir, what if the amount involved in the fraud is less than 1 crore? In such case, people, same thing, within 2 days, will report it. Now, what will the company do? In the report, people, I will clearly say what is the nature of fraud, who are the parties involved, what is the amount of fraud. I will clearly mention. Now, the reply for this, the company will give it in the director's report. They will clearly say what is the nature of fraud, what is the amount involved in the fraud, what are the parties involved in the fraud, and what was the remedial action taken, meaning what is the action taken by the company for whatever we have pointed out. So they have to reply this 3 plus 4 in their board's report. Clear? Hello? Okay. So the last part, sir, is your cost audit. Now, when is cost audit applicable, sir? Applicability. It is mandatory for companies engaged in the production or supply of goods and services like telecommunication, electricity, pharmaceuticals, fertilizers, steel, all these cases. Sir, every company, Allah, all these companies having overall turnover of rupees 35 crore or more in the preceding financial year, they shall include cost records in their books of accounts. You remember books of accounts definition? So these industries having this turnover will also have to maintain an additional books of account that is only called as cost records. Now, sir, what will I mention in the cost records? The format of cost records is CRA1. I will maintain the details of cost of operation, production, profits, sales as the case may be. Exception, all of this is not required for micro and small enterprises. The cost auditor, applicability, it is applicable to the companies covered in Rule 3 and 4. Which are the companies? Basically, there are two lists. One is called as regulated sector, one is called as non-regulated sector. Regulated and non-regulated sector. Regulated sector means people, you have some, I would say, you have a, regulator. Example is telecom. Non-regulated sector, I can give you is, best example is steel, arms and ammunition. All of that, who is a regulator? So they will come here. So sir, when is cost audit applicable? Cost audit to be applicable, people, the overall turnover of the company of all the products and services put together should be 50 crore or more. Because a company can have multiple products, right? And aggregate turnover of individual products or services should be 25 crore or more. Now what do I mean by that? For example, let us imagine there is a pharmaceutical company. All the products and services put together, they have so many things, right? Pharmaceutical, there are operations, there are scannings, there are blood tests, they will have pharmacy, they have everything, right? So I'm telling you, everything put together should be 50 crore and aggregate turnover of individual product or service. Let us imagine only pharmaceutical, the medicines. That should be at least 25 crore. If both the conditions are satisfied, then yes, people, for you cost audit becomes applicable. Sir, what if I am a non-regulated sector? Same thing. Overall turnover of 100 crore, individual is 35 crore or more. Exception, the cost audit shall not apply to a company which is having revenue from exports in foreign exchange which exceeds 75% of its total revenue. Imagine there is a company who is just exporting and we earn 100 crore as revenue. In that, people, 75 crore we are earning from exports only. Then people, cost audit not required. Next one, a company which is operating from SEZ, Special Economic Zone. The third one, a company engaged in generation of electricity for captive consumption. That means what? Generally, a company which is involved in generation of electricity, for you cost audit becomes mandatory. But there are a few companies who generate electricity, but they do not make money out of it, but they use it for their own purpose. That is only called as captive consumption. So if anyone is generating electricity just for their internal purpose, they are not covered under this rule. Simple. Okay, next one is cost audit report. How do we do it? A cost auditor will submit a cost audit report in the format CRA3 when within 180 days of the closure of financial year. We submit it to the board of directors. They will forward it to the in the format CRA4XBRL to the central government. When do we appoint the cost auditor? We appoint the cost auditor within 30 days of the board meeting or within 180 days of commencement to the financial year, whichever is earlier. And whenever you appoint a cost auditor, you need to intimate it to the central government in the form CRA2. And remember, the cost auditor is always appointed by the directors. The remuneration can be ratified by the shareholders. The tenure of the cost auditor till expiry of 180 days from the closure of financial year or till he submits the cost audit report. Removal, see who can remove. Directors only can remove. That's what I told you. That's your cost audit. The last person, sir, secretarial audit. To check and report, what is the job people who does secretarial audit? Basically, a practicing company secretary conducts a secretarial audit. Your main scope is to make sure you check every applicability of the law, alert the company whenever there are any non-compliances, and yes, try to safeguard the company from any penalties, violations, as the case may be. When is the secretarial audit mandatory? If you are a listed company and if you are a public company having a paid up capital of 50 crore or more, public company having a turnover of 250 crore or more, or every company having outstanding loans, borrowings, or from any financial institutions of rupees 100 crore or more. Such companies have to mandatorily get their records audited by secretarial auditor. Secretarial audit is prepared in the format MR3. It is always addressed to the shareholders. Correct? There is some amendments there. What is that? The class only we would have done. Nothing new has come this time. Okay, what is the amendment, people? Amendment is, now whatever we saw is as per Companies Act. Now as per SEBI LODR, what is the condition? As per SEBI LODR, the secretarial audit is to be made compulsory for all listed companies. This is as per Companies Act. And not only that, people, the secretarial auditor should also be extended to all the material unlisted Indian subsidiaries. This is as per SEBI LODR. What do you mean by that? If at all there is a listed company and if they have the list of subsidiary companies, so for those subsidiary companies, in that whichever is the important subsidiary companies, that's why we are calling it as material subsidiary. We need to get even that company's records also secretarial audit done. Sir, what is a material subsidiary? It shall mean a subsidiary whose turnover or net worth exceeds 10% of the consolidated turnover or net worth respectively. What do I mean by that? Let us imagine, take a company A. Imagine company A has two subsidiaries, company B and company C. If I take all these three company ka turnover, imagine it is coming to 1000 crores. In that, there is one company called as company B. The company B is contributing people around, let us imagine 300 crores. Now we call company B as a material subsidiary. Why? Because if you take the overall turnover is 1000 crore, in that, people, 30% is generated by one of your subsidiary companies. That means it's very, very important. Look at the money coming and you logically try to think, people. We have given money to company A. Company F has given further money to company B. What if any frauds happen there? That is also important for us. That's why we are telling you need to get even those records also secretarial audit done. Is clear, sir? Is this the amendment? Hey, this was already there, da? Okay. Next one, secretarial compliance report. What is secretarial audit report? What is secretarial compliance report? Secretarial audit is, people, nothing but you will check whether a company has followed all the applicable laws or not. You will check. That is called as secretarial audit report. Secretarial compliance report is nothing but you will check whether the company has followed all the SEBI laws or not. Now, there are so many SEBI laws, right? So many acts, so many regulations. SEBI keeps issuing so many circulars, so many notifications. You will check whether the company has followed all of this or not in a year. That is only called as secretarial compliance report. Even that is also done by practicing company secretary only. Remember. Sir, when is this submitted? Secretarial compliance report is submitted within 60 days from the end of financial year. Sir, is that the amendment? No, that was also there. The only thing is that people, they have got it one condition. That condition is now, see, as per SEBI LODR, it says every listed entity and its material unlisted subsidiary incorporated in India shall undertake secretarial audit by a secretarial auditor who shall be a peer-reviewed company secretary. What do I mean by peer-reviewed company secretary? Peer review is nothing but people. Let us imagine now there are a group of company secretaries. Let us imagine there is a person, a different person. A, there is another company secretary. B, there is another company secretary. C. Imagine A is some 10-year experienced company secretary. B is also, let us imagine, some 11-year, 10 to 11-year company secretary. Now C is, say for example, 4-year experienced company secretary. Now what do I mean by peer reviewed? Peer reviewed means what, people? Remember, you as a professional, when will you grow big? You will grow big when whatever are the works you have done, it should always be free from defects. You need to know what you're exactly doing, right? So who will come and help you? Your fellow company secretary, that is in your industry only, someone who is equally experienced as you are. He will come and check your work and say, sir, based upon me checking your 2-year, 3 years works, these are the best practices you are doing and these are the areas which needs improvement. So what happens? You as a professional, you will grow. And even in the industry, you will have a very good, priority, preference. Why? Because remember, one of your competitor has told that you have done a great job. And remember, here no one will do it for sake of it, namesake. No one will do. They will give you a proper review. If not, they will challenge it. So if your firm is peer reviewed, you will get more clients also, big clients also you will get. Earlier this was optional, now they have made it mandatory. So for you to issue a secretarial audit report, you guys have to get it done only from the peer reviewed company secretary. Let us imagine Mr. C has not got his firm peer reviewed. No one has checked his work. He cannot take up secretarial audit of a listed company. Not possible. Is this clear? Okay, this is the amendment number 1. Amendment number 2 is that, people, earlier we did not had any restriction on our tenure. You could have appointed secretarial auditor for 5, 10, 15, 20 years also. Now there is a restriction. Whatever we saw for auditor, the same one term of 5 years for individual, and if you are a firm, then 2 terms of 5 years with a cool off of 5 years is applicable as it is. Hello, clear? Yes, sir. I hope you understood that. So going forward, this is not applicable for an unlisted company because LODR, no? So it is only for listed companies. So what is a summary, sir? Remember, if at all you need to get a secretarial audit report or even secretarial compliance report going forward, you can only get it from a company secretary who is peer reviewed. Both audit report as well as compliance report. It is applicable for both of them. Remember. Clear? Yes, sir. Done. The last one, sir, is internal audit. What is internal audit, people? Nothing but whenever an audit is done on a regular basis to avoid any bigger financial frauds, We check, we audit, we rectify the mistakes on a day-to-day basis. That is only called as internal audit. Sir, is internal audit mandatory? It is mandatory only for listed companies. Sir, what about other type of companies? If you are a public company, if you are having a, remember Deepika Padukone likes to work for L&T. Deepika stands for deposits, 25 crore. P, paid up capital, 50 crore. L stands for loan, 100 crore. T stands for turnover, 200 crore. 25 into 50, 25 into 250, 50 into 200, 100 into 2, 200. Try to remember this in the same order. And here there is one specific point. See here, outstanding deposit 25 crore or more, paid up capital 50 crore or more, turnover 200 crore or more, but look at loan exceeding 100 crore. That means what? Exactly 100. The internal audit will not apply. It will apply only in the case of 101. Clear? So this is in the case of public company. What if it's a private company? So in private company, what happens, people? Only your L&T conditions are there. So Deepika Padukone does not work for private company. So D and P are not there for private company. Rest of it is there. So 200, 100 as it is. Hello. Clear? Pakka? Okay. Sir, now here they have given us some stars. What is this star, sir? In exams, we'll see stars, if these conditions come. Remember here, this is a maximum they can ask in exam, people. They'll not ask anything else in exam. What is that? Whenever there is 1 star, that means what? You will check it as on the end of the financial year. So let us imagine if I'm seeing if 26, 27 is internal audit applicable, I will just check for 25, 26 year end. That is 31st March 26. On that day, I will check paid up capital. Wherever there is a single star. But whenever there is a 2 star, you will check at any point of time during the preceding financial year. What do I mean by any point of time? Now check where the 2 stars are there. Let us imagine that 2 stars are there in the case of loans. There is 100 crore. Now let us imagine in the month in 25-26, in the month of 1st May 2025, our loans were 130 crore, which on 1st November 2025, we repaid 40 crore. So we have repaid 40 crore. So as on the end of the financial year, when we prepare the accounts, our total outstanding loan is 90 crore, which is less than 100 crore. Now the question is, should we appoint an internal auditor? Is internal audit applicable for us? Answer is yes, it is applicable for us, because what does the condition say? If these limits are touched any point of time during the preceding financial year, even for 1 day, then people, internal audit is applicable to you. That's the the power of 2 stars. Clear? Yes. Okay, next one. Who can be an internal auditor? It can be a CA. It can be a cost accountant. Can a CS be an internal auditor? According to the theory, yes. Practically, no, because it is not our subject, or it is not our area of expertise. But theoretically, you can. But practically, not really. So such other professional as may be decided by the board to conduct internal audit of the functions and activities of the company. Clear? Okay. And remember, internal auditor can be a firm, it can be a body corporate, it can be an employee, it can be a consultant. You can appoint internal auditor however you want. Past your questions, blah, 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 blah. That's all your accounts and auditors. I hope that was a really in-depth revision. We have tried to cover every point in our book, and yep, let's do the next. Okay, easy breezy. Let us try to quickly complete it. Okay, first of all, what is the charge, people? A charge means an interest or a lien created on the property or assets of a company or any of its undertaking or both as security and includes a mortgage. That is called as a charge. So technically, whenever you are taking a loan from, let us imagine, any financial institution, and if you have given your property as a collateral, it is your duty to intimate about this to the registrar. Sir, on this particular property, we have taken a loan and we have given this property as a collateral. Now, why are we giving this? Because earlier what used to happen, there were people who used to borrow loan on the same property again and again. So on the date of repayment, what will happen? There will be a conflict. Now 2-3 financial institutions will fight saying that that property belongs to me, that property belongs to me. To avoid such scenarios, what did they do? They started filing the details. Once you take a loan and if you have given a collateral once, they started following on a scenario where they will intimate about this to ROC and you will register the charge. So when you took the loan, you have created a charge. And once you intimate this to ROC, you have registered the charge. So that tomorrow, if any other lender is trying to give you the loan on the same property, he is always secured. He is always, I am saying, safeguarded. He will know that there is already a charge created on this property. Is this clear, all of you? Okay. So, what are the parties in a charge? There are two parties in a charge. That is, one is called as charge holder and one is called as the creator of a charge. Creator of a charge is always a debtor. The charge holder is the creditor. Why charge? To basically to ensure all the encumbrances made by the company on its assets are made public and to protect the interest of the lenders. Correct? What are the different types of charge? There are two types. One is called fixed, one is called as floating. A fixed charge is basically created on the assets of the company. And remember, you cannot sell these assets. Imagine if I have created a fixed charge on my plant and machinery. I cannot sell this without asking the lender. Whereas, what do you mean by floating charge? Floating charge is nothing but something you create on your things like stock, debtors. Now I can sell this even without asking my lender. Every day I can sell my stock because the old stock goes, the new stock comes. Old goes, new comes. So a floating charge is basically a charge where you can keep on selling it without asking the lender's approval. But this can continue. You can keep on selling it until when? Until a point where the floating charge gets crystallized. When will the floating charge gets fixed? Crystallized means the floating charge gets fixed. After the floating becomes fixed, you cannot sell it without the approval of the lender. Remember that. Example of fixed charge can be on your plant and machinery. It can be building, land, etc. Whereas on the other hand, floating charges, it can be stock in trade, it can be debtors, it can be raw material. All these things can be examples of floating charge. When does the floating charge gets crystallized? The floating charge gets crystallized when company goes into liquidation. That means technically company is coming to an end. Next one, when company ceases to carry on the business, that means company has, now there is no stock, new stock coming into picture. That means if I sell the old stock, then I don't have anything going forward. So whatever is there in the godown, that becomes mine. The creditors or debenture holders take steps to enforce the security. That means they appoint a receiver. You guys will be seeing it, right? You file a form called CHG6 whenever you appoint a receiver. That is this. Next one, on happening of any event specified in the deed. Example is, imagine non-payment of interest for 2 consecutive terms. Then the fixed charge can become, the floating charge can become fixed charge. So this is left to you guys in the agreement. Whatever it happens, upon that people, the floating charge will get fixed charge. What are the consequences of non-registration of a charge? Void against liquidator, void against creditor. What do I mean by that? When, imagine if the company goes for winding up the liquidator will treat you as a unsecured creditor. He will tell you to please come in the line in the last. After paying all the secured creditors, I will repay you. Void against creditor. What do I mean by that? Meanwhile, imagine if the company goes and takes loan on the same property with some other person, and if that person registers this particular charge before us, he will enjoy the priority and not us. So he will be given first preference and then the preference will be with us. That's the problem if you guys do not register the charge. Remember that. And remember people, just because you do not register the charge, the loan will not become invalid. Loan will be valid only. Of course, the priority will change. That's all. That's the only difference. Yes. Okay. And sir, what is that? What is the next one? Postponement of floating charge. What do you mean by postponement of floating charge? Let us imagine there is a lender called A. He has given loan to a company called as Kingfisher. Kingfisher has created a floating charge on this person. So tomorrow if anything happens to the Kingfisher, I will get the priority. I can sell the stock and I can recover my money. Agreed? Yes sir, that's called as floating charge. Now however, remember in some scenarios, even though my charge is registered and created, I will be given a second preference when compared to someone else. So the money will be first given to that person, not me, even though I have a charge. And this process or concept is called as people postponement of a charge. So first he will be given preference, next is me. Sir, who is this person, sir, that he will be given preference over me? When will this happen? The first one, people, in the case of a landlord who distrains for rent. What do I mean by that? Let us imagine Kingfisher is in a place. It's in a building. That building belongs to him. That is Mr. C. If at all the rent is not paid, this fellow will tell you to vacate the business immediately. Then the business itself cannot continue. So the law says, remember, now repaying the rent becomes a priority for the survival of the company. So if at all the charge is there also, the priority will be first given, that money will be first given to C to repay the C's debt. If at all C is a landlord. Okay, next one. A creditor who obtains a garnishee order. What do I mean by that? Let us imagine the Kingfisher has to pay some money to this person called C. Yeah. So now Kingfisher has not paid. So Kingfisher has created a floating charge in the favor of Mr. A. On what have they done? Let us imagine they have created a floating charge on debtors. What do I mean by debtors? Debtors means they have to pay money to me. They have taken some credit sale. They have to pay money to me. So on that we have created a charge. Tomorrow if anything happens, if Kingfisher does not repay money to A, then the debtor should have repaid to him because we have created a charge on it. Now remember people, if C goes to court, if at all the court orders garnishee order in the favor of C, that means whoever has to pay money to Kingfisher, they will have to pay money to this particular person. You need not have to pay to C. So the debtors ideally would have paid money to A, but because C got the garnishee order, now all the money will be paid to Mr. C and not A. Now this is only called as a concept of garnishee order. So court tells, hey, don't give money to anyone. I am telling pay to him. You will have to pay to him. Even though you have a charge, he gets a priority. Next one. The judgment creditor who attaches goods to the company and gets them sold. Now what is this? Judgment creditor is nothing but people. Imagine there is this goods, right? There is a fight, conflict going on. So we go to the court and the court orders that particular stock in my favor. They say I am the rightful owner. In such case, people, the goods itself is won by me. The case is won by me. They are saying that that goods belongs to me. In such case, C will get the priority, not A. Next one, the employees of the company. Simple people. Remember, Kingfisher did not pay the salaries of its employees for almost up to 2 years. In such case, even though there is someone who has a floating charge, our first preference will be to repay the employees of the company, because if they do not work, then we will have to shut down the company immediately. So they enjoy a preferential right. Next one, sir, the supplier of the goods to the company under a hire purchase agreement. What do I mean by that? First of all, it is not a valid charge at all. What is a hire purchase, people? Someone has given us goods, but the ownership is not yet transferred. And this fellow has further created a charge on this hire purchased, machine or car or anything. Remember, ownership is never with us. So if at all you do not repay the loan, or if you do not repay all the installments, they will come back and take back the car. Why will they give it to you? Because you have to pay all the installments. So any product purchased under hire purchase, whoever is the owner, he will only get the property, even though I have created a charge on this particular car, hire purchase. Remember, these are the scenarios where the floating charge will be postponed. Okay. Next one, sir. How do we create a charge? Duty to register a charge. Yes, first one, left side, it's okay, leave it, because we were following that before 2019. It's been 7 years now. So focus on the right side part. If at all the charge is created on or after 2nd November 2018, then what is the duty? How do we have to register the charge? Along with this, I am also telling the steps also. Again, towards then, let us not do the checklist and procedure. First, I need to file the charge in the form CHG1. If it is debentures, then it will be CHG9. I need to register the charge within 30 days of us creating the charge. Correct? So I will file in the form CHG9. Sir, what if I am not able to file it within 30 days? Then people, they will give you an additional time of another 30 days. However, for this people, you need to pay certain additional fees. Sir, what if I was not able to register even in the additional 30 days? They will give you one time, the last one more extension of another 60 days. For this, you need to pay additional fees, plus you need to pay ad valorem fees. Ad valorem means, people, nothing but like a penalty. So maximum time now you enjoy is, people, 120 days, not beyond that. And that too, how, people, if you do it within 30 days, you will be filing form CHG1, you will be paying normal fees. If not, within 30 days, additional fees. Sir, if not, additional fees plus ad valorem fees, like a penalty. Yes, sir, if at all the details you have given, if it is correct, then the registrar will reply to you in the form CHG2. That is only called as, people, the registration of your charge. Clear? Yes, sir. Okay. Sir, what if the creator of charge, if the company does not file the charge, if within 30 days, if the company does not file, people, then the lender, that is the financial institution, that the bank will be there, no, they can only file the charge. Yeah, now what will the lender do? Let us imagine SBI bank has given loan. SBI only will file it with ROC that we have given loan to this company called as Kingfisher. So now ROC will check with the Kingfisher. We got an application creating a charge on your assets. Is it true? Now Kingfisher has to reply to the ROC within a period of 14 days. You need to reply, yes, whatever SBI said is true or false. If you do not reply, it will be considered as a deemed approval. Now SBI can recover all the cost from Kingfisher. What all cost? I can recover the cost of the normal fees, plus if there is any additional fees, I can recover that as well from the Kingfisher, because it is your duty to register the charge and not mine. Is this clear? Okay. And remember, sir, all the documents that are filed with registrar, everything sits in the public domain. So if anyone is entering into a contract with the company, you are deemed to have the knowledge about the charge. You cannot say that they did not inform me. If you are entering into a contract with the company, because all of this is considered as constructive notice, it is deemed to be a public document, because remember, the ROC maintains the details of all these charges that you have filed. Hello, remember, the charges will be maintained in two places. One, with the company itself in the form CHG7. It is available for inspection. The members, the creditors, they can come and inspect these registers whenever they want. In addition to that, the registrar will also maintain one copy of all the registers. So you can inspect in either ways. That's why the charges are always considered as public domain documents. Hello, done. Next one, sir, registration of satisfaction of charge. What do you mean by that? Sir, Kingfisher has repaid the loan to SBI. Now what will I do? The Kingfisher will file an application to ROC. Sir, I have repaid the loan. Now ROC will check with SBI. Hey, Kingfisher is telling that they have repaid the loan. Is it true? Now RBI has people 14 days time to reply. If RBI does not reply, it is considered as deemed approval. Sir, what if within how many days should I intimate to ROC? You need to intimate ROC within 30 days of you satisfying the charge, meaning repayment of the charge. Sir, what if we are not able to do it within 30 days? If you don't do it within 30 days, people, you will get 300 days from the date of payment. You will get an addition, you will get a total time of another 300 days. Same thing, normal fees plus additional fees. Hello. Clear? Okay. Now, sir, what if we are not able to file it within 30 or within 300 days? Now, what to do? From section 82, you will go to the next section, that is section 87. What is the next section? Rectification by central government. Go and tell central government, sir, because of these reasons, we were not able to intimate the satisfaction. Can you please help us? If central government is convinced, people, central government will allow you to file your satisfaction of a charge even after 300 days. Remember, for satisfaction of a charge, there is no upper limit at all. But that is not the case with registration of a charge. If 120 days, if you guys are not doing it, you can never register a charge. It is gone. But satisfaction 30, 300, if not also CG approval, you can any time do it. This is only called as condonation of delay. You have to pay additional fees. That's the only thing. Clear? Sir, what if in any of the documents we have filed, it can be CHG 1, 2, 3 and something. In those documents, there are some mistakes. Can we correct it? Answer is yes. How? Again, the same section 87 will apply. You need to file to the central government in the form CHG8. Sir, there are some mistakes in this form. Can we please correct it? And you can correct your whatever is the forms that you have filed. Clear? And next one is, and remember what all charges has to be registered. Whether the charge is created in India or outside India. Movable, immovable, tangible, intangible, everything has to be registered with ROC. Remember, that is very, very important, mandatory. Sir, who should sign the charge documents? Again, important. If the property is situated outside India, the charge documents shall be authenticated by common seal or 2 directors or a company secretary or the authorized officer of the charge holder. That means nothing but I'm talking about the bank lender. So one is my directors, or I can take it the company secretary of my company, or I can take the signature of the any authorized officer from the bank, or some other person other than the company who is interested in the mortgage. That means what, sir? We are taking from any other person. For example, A has taken loan from SBI. And the guarantee for this is given by company B. Now they can also authenticate this particular document. Hello. Sir, what if the property situated in India, the third condition will not come. It should be either common seal or director or CS or any other person authorized by the charge holder. Okay, next one, sir. What else? Acquisition of property subject to charge and modification of charge. What is this, sir? Let us imagine, people, there is company A. Company A has taken loan from SBI on a particular property. Imagine they have a land. On this they have taken a loan. Now company A has sold this land to company B. Now has company A repaid the loan? Answer is no. Now company B has purchased this particular land. Now going forward, you need to repay this loan to SBI bank, no? So it is your duty, the company B will have to file form CHG1 again to register a charge. Who will file? The acquirer, the company B will file within 30 days. Hello? Now going forward, SBI will say, okay, company A's name will be discharged and company B's name will be entered. This is one place where you will file. This is called modification only. Second place, company A only has taken loan. Imagine they want to change the tenure. From 5 years, they want to make it 8 years. If there is any change in the documents that you have already filed, you can file certificate of modification of charge. Again, you will file it in CHG1 only within 30 days of modification. ROC will give you something called as certificate of modification of a charge in the form CHG3. You will file CHG1 only. They will reply to you in CHG3. What is CHG4? Is nothing but satisfaction of charge that you file. CHG5 is memorandum of satisfaction of a charge, meaning ROC gives you an acknowledgement. Okay, I have noted your charge is discharged. CHG6, whenever the company does not repay the loan, what will the SBI do? SBI will appoint a receiver to go and take charge over that property. Now, whenever we appoint a person, now that person's appointment has to be communicated to the company, that is Kingfisher, as well as to the registrar, ROC, in form CHG6. Sir, once the purpose is done, served, now his appointment will come to an end. That also has to be communicated to the ROC in the form CHG6. And next one is register of charge will be in the format CHG7. Register of charge shall be maintained permanently. Remember, instrument creating the charge will be maintained for a period of 8 years from the date of repayment. However, the instrument creating the charge is 8 years, the register of charge will be maintained permanently for the life of the company. CHG8 is nothing but central government, condonation of delay or errors. CHG9, registration of charge in the case of debentures. Remember, whenever in this case only, section 79, any person acquires a property which is subject to a charge. Imagine B. Now B has intimated to the ROC, sir, I have taken it over today. Now going forward, I will repay the loan. Please register the charge in your records. Now for the ROC, neither company A informed, neither SBI informed. Company B is informing. It's okay. ROC will reply to A and SBI that your charge in between you both is discharged. So he will issue satisfaction of a charge. Now a new charge will be replaced in the B's name. Remember that. Hello. Hello. Power of registrar to make entries. I can make an entry whether you intimate or not. Now B has intimated. It's okay. I will enter it and I will give it to A and SBI. Appointment of receiver or manager. Company's register of charges CAG7 permanently. Instrument 8 years. Okay. Inspection of charges. Any member creditor without fees. Any other person you need to pay fees. charge forms, procedure for registration. I already told you what is the procedure. Yes, sir. That's all. Yes, people. So let's start our next chapter. That is chapter 8, distribution of profits. Nothing but dividends. So first things first, what is that? There are two types of dividend. One is final dividend. What is interim dividend? What is the difference between the final and interim dividend, people? See, always remember the final dividend is always recommended by the board, declared by the shareholders. So the directors tell you, they fix. Imagine whenever you can think like this. Once the year is done, the directors will prepare something called as board of directors or directors report. In that they will say during the year, this is the net profit we made, this is the tax, this is the depreciation, everything. After everything, your net profit after tax, what is the final amount? From that amount, we are going to say, imagine if that money is coming to 1 crore. In that we will tell, in this 20 lakh will be transferred to free reserves and 80 lakh will be used to declare as a dividend. At the rate of, let us imagine, say 100% is what we have decided. And always remember, dividend is declared on face value, not on market value. So we have declared dividend on 100% and that amount is coming to 80 lakh. Now this recommendation is made by the board. Now what will happen? After the notice is given, after 21 days, people will come for an AGM. In the AGM, the shareholders will say whether they are okay with this or not. So they will approve this. The shareholders also have a right to say, no, let us put that money back to the business only. Don't distribute it as a dividend. The shareholders can say yes or a no. It is their choice. Now such type of dividend is called as what, people? Final dividend. Whereas, what do you mean by interim dividend? Interim dividend is nothing but a dividend which is declared between an AGM. So, it is always recommended by the board and declared also by the board only. And always remember the interim dividend. To declare interim dividend, you need to give the power to the directors in the articles of association. And you can declare any number of interim dividends in a year. There is no limit. In a year, you can declare any number of interim dividends. So that's the difference between final dividend and interim dividend. Final dividend is always recommended by the board and declared by the shareholders. Whereas interim dividend recommended by the board and declared also by the board only. That's the interim dividend. Is this clear, all of you? Okay. The next one, sir, section 123. Let's start that. What is that? Declaration of dividend. The source of dividend. From where will we declare dividend? The first one, people, you can declare dividend out of the current financial year, whatever your current profits are. You can also declare it out of the previous financial year, that is free reserves. Also, you can declare it out of the credit balance of P&L account. Using all of this, you are free to declare a dividend. And not only that, from any money provided by central government or state government, you can use that also to declare dividend. Next one, before declaration of any dividend, the following should be first deducted or set off. That is nothing but depreciation and previous year losses. Transfer of money, as I told you, remember in the director's report we will tell that we have decided to transfer so much of money to reserves. There is no mandate. You can even declare the entire 1 crore as dividend. There is no mandate. You have to transfer 10%, 50%, nothing. Only thing, if you guys have any debenture redemption reserves or deposit repayment reserves, if such things are there, then yes, it is your duty to transfer money for that. But apart from that, you need not have to transfer any money to free reserves. You can use the entire profits to declare as dividend. Remember, whenever you have adequate profits, sufficient profits, there is no limit on declaring dividend. You can use the entire profits to declare dividend. Remember that. Whenever you have inadequate or there is no sufficient profits in your company, and if you want to declare dividends, then in such case, yes, the rule 3 will apply. That is that what is the maximum you can borrow? You cannot exceed the average of 3 years. That and all will come into picture. We'll see. Is this clear? Okay. What is that? Rule 3. Declaration of dividend out of the profits of previous year, or when there is inadequacy of profits or absence of profit. In such case, there are 3 conditions. What is that? Condition number 1. What is the maximum rate? It shall not exceed the average of 3 years. Remember, sir, what if in my last 3 years, I have not declared at all? Then this condition itself will not apply. And very, very important. So remember, in my year 1, we have declared, say for example, 15%. In my year 2, we have declared 6%. In my year 3, we have not declared anything. Now, how do I take an average? You still do it in the same way. Divided by 3. It will still be 21 divided by 3. That is 7%. Remember, this is very important. Even if there is 0 in a year in between, you still take it while you are taking an average. You will not do it divided by 2. You will do it divided by 3 only. Because it is average of 3 years is what is the condition. Next one, maximum amount that we can draw from the reserves. What is the maximum amount we can draw? The maximum amount we can take from reserves, people, shall not exceed 1/10 of the paid up capital plus free reserves. If in my free reserves, if there is 1 crore, what is the maximum I can draw? They're telling you, I can draw maximum is basically 1/10, 10% of your paid up capital plus free reserves. Take your paid up capital, take your free reserves. From that 10% you can withdraw. Hello, and remember, from whatever is the money you have withdrawn, from that first you need to set off your current year losses, if any. First you need to set off that, and whatever is the remaining money, only that money you can use to declare as dividend. And remember, after the money is withdrawn, whatever is the money that is left in the balance, that left as a balance in the reserve, it should not be less than this number. What is that? After such withdrawal, the balance should not fall below 15% of your paid up capital. So whatever is the money left behind in my free reserves, it should be at least 15% of your paid up capital. How much ever that value is coming to, you need to maintain at least that much of amount. Now let us imagine if the total amount that we have drawn here is 40 lakh. In that we have used, in the current year there was a loss of say 20 lakh. Let us imagine, current year there was a loss of 10 lakh. So 30 lakh we can use to declare as dividend, because 10 lakh you cannot, you have to first set off the current year losses. Now balance in reserve after withdrawing shall not fall below the 15% of paid up capital. No, sir, should we take 40 here or 30 here? You will take as 30 only for the purpose of calculation as the amount drawn here. Whatever you have withdrawn, for that you need to take the calculation as 30, not as 40. Again, this is one thing where they will generally feel confused. Okay, and remember, in our book there will be other things also. What is that? If at all a company has preference shares, people remember, preference share is just the share which gets a right, or you can say it gets a priority for repaying the dividend when compared to a equity shareholder. We always give a preference first, priority first to the preference shareholder. Agreed? No? Remember, preference should not be misunderstood for mandatory dividend. Unless and until, see, preference dividend is nothing but, it is always with regards to your terms of issue. If at all while issuing you said we will declare dividend every year, you have to declare every year. Example is cumulative. If I do not declare dividend this year, in the next year I have to add it. Next year I have to add it. Hello? Sir, what if it is non-cumulative? I said if I have profits during the year, I will pay. If I don't have, remember people, don't get confused. If I don't have, you are not liable to pay dividends and all. Preference share should not be confused with, mandatory dividend. Preference here is not giving you any right for dividend. It is just giving priority over the dividend if the company is declaring dividend. If company does not declare dividend, the company is not liable to pay you. So it all depends upon the terms of issue. Remember that. That is very, very important. Clear? Okay. Next one, sir, payment of dividend. It shall be paid only to the registered shareholder or any of his order. Meaning if I tell don't pay to me, pay to that person, will pay to that person. Or to the banker, generally digital payments. Dividend can only be paid by cash. Basically, when I say cash, it's not a physical cash. I'm talking about electronic mode and not in kind. So you can pay by check, by dividend warrants. You can give it by electronic mode also, like NEFT, RTGS. Okay. Next one, dividend shall not be paid if company has not complied with Section 73, Section 74, Section 8. You are not, first of all, you are prohibited. You cannot declare dividend at all. And when else you cannot declare dividend? The company cannot declare dividend if it has defaulted in redemption of debentures, interest, creation of DRR. Any default, no dividend. Same thing, redemption of preference shares, creation of capital redemption reserve, CRR. Next one, payment of any dividends declared. Meaning if you have already declared any dividends and if you have not paid that, it's again you cannot declare any new dividend. Repayment of any term loan or its interest. We have taken loan, we have not repaid the principal or interest. If you have made such default, you cannot declare dividends. Remember that. Okay. Next one, interim dividend. What is the maximum interim dividend you can pay and how can we pay? Sources very important. Interim dividend can be paid out of surplus in P&L account. Next one, profits of the current financial year. What is the surplus in P&L account, people? Imagine if we are in the year, now this is, let us imagine 26-27. In the year 25-26, we completed the year. So your P&L account is done. You got your net profit. From net profit, what you are going to do? You are going to do something called as appropriation. How much of it goes to reserve? How much of it is declared as dividend? You are going to do the appropriation. So how are you going to utilize these profits? Once the entire appropriation is done, imagine your net profits was say 1 crore. You have appropriated around 80 lakhs. Rest of the 20 lakhs, you don't know what to do. So what do? You keep it in the P&L account only. You have not yet appropriated it. And that is only called as surplus in P&L account. So the last year's profit is still left there only. We have not yet utilized it or we have not yet reserved it for any purpose. Such things are called as what, people? Surplus in P&L account. So you can utilize that money to declare interim dividend, because to utilize that money we need not have to ask shareholders. It comes in the directors power only. They can only declare, they can only use anything. That is absolutely fine. Next one, profits of the current financial year. You can use the current financial year profits. Or sir, what if the year is not yet completed? In such case, profits generated in the financial year till the quarter preceding the date of declaration. That means what? Sir, Q1 profits, Q2 profits. In Q3, our Q1, Q2 is in profits. No, quarter 1, quarter 2. I can utilize that only to declare the dividends in the quarter 3. Okay. Restriction during the loss of current financial year up to the end of immediately preceding quarter. That means what? Sir, in Q1 also loss, Q2 also loss. In Q3, we want to declare dividend. Can we? Yes. How? You still have the surplus in P&L account, no, from the previous year. Utilize that. Provided in such scenario, when you are declaring dividend, remember the rate of dividend cannot be more than average of your last 3 financial years ka dividend. Only that one condition will apply. The rule 3 first condition, only that will apply, not the rest of the 2. Clear? And remember, you cannot declare interim dividend out of free reserves. Remember that. Okay. Okay. Declare dividend to be deposited in a separate scheduled bank account. That's a procedure, right? Okay. Next one is section 124. What does 124 say? When to give the dividend. Once the dividend is declared, now what do I have to do? within the next within the next 5 days, you need to deposit the dividend into a separate scheduled bank account. I have to first separate it. So from my main account, I have to separate it into a different account. Now within 30 days from the date of declaration, that is from the date of meeting there, within 30 days I need to make the payment. Sir, what if I am using dividend warrants or checks? Remember, the payment can happen even after 30 days, but you need to post it within 30 days. Okay. Sir, within the 7 days after 30 days, imagine, sir, for a few people we were not able to pay. What to do? Whomsoever you are not able to pay, within 7 days, after the 30 days is done, do one thing. Within 7 days, open another account, name that account as unpaid dividend account, and transfer all the funds to that unpaid dividend account. Hello, within 7 days. Amount unpaid transfer to UDA. Failure to transfer to UDA, you need to pay interest at the rate of 12% per annum. Sir, even there also, once you transfer to UDA, within 90 days of you transferring to UDA, you need to display on your website of the company whose dividend it is, what is their last known address, what is their last known address, and the amount of unpaid dividend. What is the amount? We need to disclose all of this on the website within 90 days of we transferring the money to unpaid dividend account. And the money is going to stay there for a period of 7 years. And in the 7 years, if no one is coming to collect that dividend, then what are we going to do? We are going to transfer that entire dividend to a account called as IEPF. Sir, only dividend, not only dividend people, the shares on which the dividend you guys earned, that shares also we are going to transfer. And not only that, for that 7 years we would have earned interest upon that money, right? Your money, that interest also we are going to transfer. Unpaid dividend account, section 124. Next, section 125, IEPF. What and all are the different money that is credited to this account? The fund is credited with the grants by central government, any money sent by central or state government, general revenue account of central government, amount in IEPF under Companies Act 1956. So before this, under Companies Act 1956, we had IEPF. So once Companies Act 2013 came, that money was transferred to this account. That one. Interest or income received from investments made out of the fund. So this fund, we are going to interest in government securities. We are going to earn money. That will be credited only, no? Next one, disgorgement order money. What is disgorgement? If at all anyone has made illegal gains, we are going to take away that money. Now, for example, in the case of Harshad Mehta, he made so much of illegal assets, right? So government will take away all that illegal assets. And what will they do? If at all anyone has suffered loss, we will take money and we will use that money to repay to those people who have suffered losses because of you. Next one, security application money. We saw in deposits. If someone has applied and if we don't allot them, within 15 days we have to refund. If we are not able to refund, it will be treated as deposit. But for how long? For 7 years it will be with you. After that you will transfer it to IEPF. Mature deposits, 3 years is done, no one came to collect the money. Debentures, no one came. Preference shares, no one came. And interest accrued on all of this, no one came. SBO, the person did not disclose the details within 1 year, section 90. We are going to transfer all the particular shares to IEPF. Hello? Hello? Okay. Sir, and what are we going to use this money for? We are going to use this money for, first one is if they are coming and asking, you will refund them. Promoting of awareness amongst the investors education. Like there are, investments are subject to market risk. Please read the offer document carefully. Don't share the OTPs, things like that. Educating investors, protecting the interest of the investors, distribution of disgorgement amount. I told you, we took it here and we are going to give it to the people who suffered the money. So distribution, who suffered the loss. Next one, reimbursement of legal expenses. What is this? Now imagine if at all some 100, 200 people, now in the case of Harshad Mehta, Around, he has created a loss for more than 10,000, 50,000 people. So everyone wants to file a case on him. Now imagine if the courts take up a case, they have to hear 50,000 cases. Rather, what will they do? They will combine all these cases into one case and they will make this as a class action suit. Meaning, one person will come on behalf of everyone and that particular case will be conducted, and such type of things is called as class action suit. Not everyone need to come to that particular court. Only one case will be heard. That expenses will be given by IPF because so many people suffered loss. So it is the interest of the government that we need to protect you, and they try to protect you. Simple. Okay. Next one, dividends to be held in abeyance. What is this, people? Whenever imagine there is a transfer of shares, we sign SH4. We have given this SH4 to the company to register the transfer. The company has time, right, to register the transfer. The company can register the transfer within 30 days. They have time. But you have given people, immediately company took your SH4, but the company has declared the dividend. And hence in the register of members, still A's name only is reflecting. B's name is not yet reflecting because we have not yet made the entry. But technically, as per the contract, I have received the money, I have given everything, I have signed. B should receive it. Actually, if you ask me who is the owner, he should get it. But according to the rule, your name is reflecting, hence you will only get it. So what does the rule say? It is A's duty to take it and it is A's duty to give it to B because there has been a contract. But all of this will be like a conflict only. If such things happen, then what do we do? What will the company do? The company will keep aside the dividend until the rightful owner is decided. We don't know who the owner is. Until the owner is decided, we are going to keep the dividend, aside with the company only. And that is only called as abeyance. Abeyance means, people, nothing but kept aside until the owner is decided. Clear? All of you? Okay. 126. Last one is 127. Punishment for failure to distribute dividend within 30 days. So see, always remember, it is your duty to pay the dividend within 30 days. If at all I don't pay, and it is not because of the company's fault, it's okay. If you don't pay and it is because of company's fault, you are liable. To what? Your liability will be, you will pay interest at the rate of 18% to the shareholder, and the directors can be imprisoned up to the maximum of 2 years, and fine can go up to ₹1,000 per day of default. That will be the penalty. Sir, in which scenarios the company will not be liable? For the company, these are the scenarios where company will not be liable. First one, we were not able to pay the dividend to the shareholder due to the operation of law. Meaning, imagine the shareholder became alien enemy. He is a foreigner and we declare that country as an alien enemy. We are not able to do contract with them. Next, when shareholders' direction of payment could not be complied and same has been communicated. The shareholder said, I have 3 bank accounts, in that please transfer the money to this bank account. And he has given all the details wrong. The account number is mentioned wrong. We tried and it is not reflecting right. So whenever there has been a clear instruction and if that instruction was not able to be followed, then people, remember, we have to clearly tell the shareholder, sir, your instruction we were not able to follow. You have to communicate. If you don't communicate, then it is considered as non-compliance. That is important, remember. Third one, you should have paid us some call money. For the call money, we adjusted it. It's absolutely fine. Next one, dispute in right to receive the dividend. Abeyance, 126. We are fighting. They are saying this is mine, it belongs to me, it belongs to me. Non-payment is not due to the default of company. So it can be any other reason, but it should not be the company's fault. In such case, people, yes, you can file. You will not be liable for any of the penalties. And next one is what? Okay, dividend distribution policy, regulation 43 of SEBI LODR. What does it say? The top 1000 listed companies have to come up and they have to frame something called as dividend distribution policy. What do I mean by dividend distribution policy? See, what happens as a shareholder is you always anticipate when are you going to get dividend. You always anticipate that. Yes. So whenever you are going to get dividend, it is always unfair for you to keep asking, keep expecting, will I get dividend this year? So rather, what did the SEBI Act do, SEBI LODR? They said, why don't you guys form a policy called as dividend distribution policy? This is applicable for the top 1000 listed companies. What does the policy say? Very simple. What are the scenarios under which the company's shareholders, when can they expect dividend from the company? You give probable scenarios. Now what happens? They will only do the calculation. Okay, profits has to be this much. Our reserves have to be this much. Our future prospect of growth is this much. And we will do the calculation. We will know whether to expect dividend every year or not. And this is only called as dividend distribution policy. See here. It shall include the following parameters. The circumstances under which the shareholders may expect the dividend or may not. If the financial parameters that shall be considered while declaring the dividend. What are the financial parameters? Profits has to be this much. It has to be this much. Internal and external factors that shall be considered for declaration of dividend. So internal is company related. External is political or global related. Policy as to how the retained earnings shall be utilized. Imagine if we are not declaring dividend or we have free reserves, right? How are we going to utilize that money? Next one, parameters that shall be adopted with regards to various classes of shares. So it can be DVR, it can be preference. For all of them, how are we going to see it? So that is only called as dividend distribution policy. The listed entities other than those specified may disclose their dividend distribution policy even on a voluntary basis. For these people, it's mandatory. Anyone else, you can do it voluntary as well. Declaration of dividend should be unconditional. What do I mean by unconditional? You cannot say that subject to the central government's approval, subject to the tribunal's approval, we will give you dividend. All such things cannot happen. It should be always unconditional. Subject to the bank's approval, subject to my creditor's approval, that and all is not a valid dividend. It should always be unconditional. Okay, we have that IEPF procedure, no? You want it, IEPF, you want me to do? Want? Okay. I've tried to summarize that. Okay. So the transfer of unpaid or unclaimed dividend to IEPF, 7 years done, no one came. Now what do we do? The company, first step is identification. Companies must identify the dividends which has been unclaimed for a period of 7 consecutive years. It is to be done within 60 days of AGM or its due date. The last 7th year is done, the AGM is done. So from that, within 60 days, I need to do this. Okay, now what do I do? Amount must be transferred online to the IEPF account within 30 days of becoming due. So what do you mean by that? 7 years done. Within 30 days, I have to transfer all the amount to the IEPF account. And I need to file a form that is called IEPF1. In that I have to clearly tell, I'm giving you the dividends and this is the amount for so many shareholders for so many years. I'll give everything. Mode of payment, it will be under MCA. Miscellaneous fees, it will be called as. You need to go under MCA and make the payment. Post-transfer compliance, authority enters data in the register and reconciles monthly with the banks. The bank provides monthly abstract within 7 days after the month end. Company maintains full records of the filing. What is this, people? Reconciliation. The company has filed all the details to IEPF. IEPF's bank has received some money. So what will IEPF do? IEPF will reconcile with whatever the data the company has sent and whatever is the data the banks have received. They They will reconcile and they will check whether we have received the correct amount or not. Disclosure IEPF2. What is this? Uploaded every year on the company's website and IEPF authority website. What will be given in IEPF2? We will give the details of the shareholders. Last name and last known address of the claimant, amount and nature and value, due date for transfer, other essential information. We'll give all the details in IEPF2. IEPF1 money, IEPF2 the details of the shares. Next one, transfer of shares to IEPF. Here we have transferred money. We are transferring shares also here. Same thing, 7 years. We have to intimate the shareholders first before we transfer the shares. So notify the shareholders 3 months in advance. Give it individual. Give it a newspaper. Also mention it on the website of the company. Exemptions: shares shall not be transferred if a court or a tribunal's order is there, or the shares are pledged, or any dividend has been claimed in this 7 years, then we will not transfer the shares. Remember, after all of this, you need to file form IEPF4 to disclose all the details about the shares and all the other part. How will we transfer the shares? If the shares are in demat form, we will clearly transfer the shares from our demat account to IEPF demat account. If the shares are in physical form, then what will we do? The company will nominate its company secretary or any authorized person. They will apply for a duplicate share certificate because the shares are in physical form now. We will convert this duplicate share certificate into demat form and then we will transfer it to IEPF account demat form. So first we will take a duplicate share certificate, convert it into demat form, and that will be transferred to IEPF demat. Next one, if anyone wants to take back the money, now imagine after 10 years, someone was in coma, he woke up, now he wants the shares back. Can he get it? Yes. How? You need to file form IEPF 5. You will file it with the IEPF authorities. IEPF will forward your application to the company and they will ask him to make a proper research and tell whether is it rightful owner or not. We have received a request. The company will do the research. The company will present its report and accordingly the IEPF will process the transfer. And who will do the complete research and all in the company? We call that person as a nodal officer. Generally it is company secretary. Approval and refund. IEPF. Then that's all. Remember these, it's more than sufficient. Clear? Dividend distribution. And the last one, people, one thing, yes, remember there is something called as SS3. SS1 is on your board, SS2 is on your general meeting, SS3 is on your dividends, which is voluntary in nature from the 2018. It's not yet mandatory. So if you guys want, you guys can follow secretarial standards on a voluntary basis. It is not mandatory. Clear? Yes, I hope I have covered most of it, IEPF as well as all the sections here. Yeah, procedure also, as I told you, you remember that timeline is important, and if it is final dividend, it is always declared in AGM. If it is interim dividend, directors only will declare it. So it will be board meeting. If it's final dividend, it will be AGM. And timeline will come into picture within 5 days, 30 days, 7 days, 7 years, 90 days, UDA account, all that is as it is. Yes, hello? Secretarial standards on dividend. There is something called as a deemed dividend, right? Let us see that. There is deemed dividend, right? What do you mean by deemed dividend, people? The concept of deemed dividend is embedded in Income Tax Act, not here, where a closely held company extends a loan or advance to any of its shareholders who has more than 10% of voting power in the company. Closely held company means, people, imagine there are 3 people who are, say, friends or family, whatever you call, All of them are holding 30%, imagine 40 and 30 in a company called XYZ. Now this is called closely held company, and one of the shareholder, let us imagine any of the shareholder who has more than 10% of the voting power, he has, in our case everyone has 30, 40. So now what happens? If at all this XYZ company is giving a loan to this person, we consider this loan also as a dividend only in the hands of Mr. C. Even though it is a loan, if you remember people, Dinsha Managerial case, similar to that only is this. That is only called as a deemed dividend. When else it will be a deemed dividend? To any concern in which such shareholder is substantially interested. That means what? Sir, let us imagine there is XYZ. In XYZ, okay, let us imagine this way. Again, same thing. Okay, take the extension of this only. There is this A, B, C. Sir, C is a shareholder of one more company called as ABC Private Limited. And XYZ gave loan to this ABC Private Limited. Now, this is also called as a deemed dividend. Because we have common shareholder, a common controlling person. Even that is also called as deemed dividend. Next one, for the individual benefit of such shareholder, meaning direct benefit if I make anything on behalf of such shareholder to the extent the company has accumulated profit, such payment would be deemed as dividend. Meaning, sir, imagine Mr. C had to pay some money to an outsider called D. We give that money. Again, it is considered as deemed dividend. That is the concept of deemed dividend. Remember and go. That is, it will be taxed as a dividend in the hands of Mr. C. Yes, sir. That's all. Dividend distribution was IAPF. Okay.
Let's start the next chapter, that is Dormant Company. Easiest now, you guys have to literally by heart letter by letter in Dormant Company. You should not even leave one letter go from this particular chapter. Yeah. Okay. Section 455 says what? What is the definition of dormant company? A dormant company generally means what, people? An inactive company. A company currently which has no business operations, but in the future it will have some business operations. Such type of company we generally term it as dormant company. Definition: they say a company where a company is formed and registered for a future project. Currently, as on today, we don't have any object. We are not carrying on any business today. We are as on today inactive. But after 1 year, we may get some business order. Currently, we don't have anything. So what to do? Let us at least enjoy some exemptions given under the law. So apply for dormant status and just sit. Or a company which is formed to hold an asset or intellectual property. So you have it, you apply for it and you just hold it. You don't do anything else. So you imagine you apply for a trademark and you have the trademark and you keep it. You wait for the right moment to start the business. And the company should not have any significant accounting transaction. What do I mean by significant accounting transaction? It means a transaction other than these four. These four are not considered as significant accounting transaction. Anything other than these four are considered as significant accounting transaction. What are these transactions? Any payment made to ROC as the filing fees. So imagine if at all you are filing any form PAS3, if you are filing form DIR12, all of this is considered as what? All of this, I need to pay some filing fees to ROC. That is okay. It is not considered as a significant accounting transaction. If you are spending for anything else, imagine payments made for your employees, payments made to acquire some plant and machinery today. Now all this will make it a significant accounting transaction. Other than these are significant, these are not significant. Next one. Payment made by company to fulfill requirement of this act or any other law. Imagine people, if you are making any payment for any licenses, permits, trademark act, you need to make some payment. It is not considered as significant accounting transaction. For example, I need to file form PAS3. I don't know how to file it. I have asked for the, I have asked for the services of any professional. I need to pay him, right? Now I can't say that as a significant accounting transaction. It's not a significant accounting transaction. Next one, allotment of shares to fulfill requirement of this act. Remember people, if you are allotting any shares, it is not considered a significant accounting transaction. Remember, even though you are a dormant company, you still have to file form PAS3 and appointment of directors. You can still make these two and you still have to file the consent forms. It is still required. Any payments made, not SAT. Maintenance of office and records like rent, electricity bills, these are allowed. It is not considered as significant accounting transaction. So which other company is considered as dormant? Third one is called as inactive company. What do I mean by inactive company? It is a status of a company because of not carrying on any business or operation. So I'm not carrying on any business or not made any significant accounting transaction in the last 2 previous years. So we have incorporated, we don't have business. In the last 2 years, we have not made any big transactions or I have not filed my financial statements or annual returns for a period of 2 financial years. I think there is something missed. So I have not filed my financial statements or annual returns for 2 financial years. Now, sir, such companies are called as what people? Inactive companies. Now, they can also apply for dormant status. Definition important, remember and go. Next one, compliances to be followed by dormant company. Even though you are a dormant company, there are some compliances you still have to follow. What is that? It shall have minimum number of directors as per the law. That is, if you are a private company 2, public company 3, OPC 1, these things you need to still continue to follow. The public company, private company, OPC can still file DSC, the dormant status, that is absolutely fine. Return of dormant company to be filed annually in the form MSC3 indicating financial position duly audited by a chartered accountant. What do I mean by that? Now imagine this year, in the year 26-27, we have applied for dormant status. Now what is the guarantee that the next year also you are still dormant? What if you have started doing business, you have started earning money, or if you have spent some money, then you are not dormant because you have done a significant accounting transaction. If you have made a significant accounting transaction, then how can you be a dormant status? You cannot be a dormant status. That's why every year you need to file within 30 days of the end of the financial year, you need to file something called as a return of dormant status in the form MSC3. This has to be certified by a chartered accountant because someone has to say no that yes, there were no transactions. I still have to do that. Next one, I need to conduct at least one board meeting in each half of the calendar year in such a way that the gap between 2 meetings should not be less than 90 days. So if you conduct one meeting in say for example June, the next meeting cannot be in July. So the gap should not be less than 30 days. Minimum gap should be 90 days. The company shall file return to ROC in case of change in directors, allotment of securities. As I told you, DIR 12 and PAS3 both are still to be, you guys still have to file it. It is mandatory. Remember. Application for dormant status, how do we get it? You can get it one by on its own when you apply for it. Next one, when ROC itself allots you. When will ROC allot you? If company has not filed financial statements or annual returns for 2 consecutive financial years, the ROC will give you a notice, and if it is convinced, then ROC may enter your name into register of dormant companies. It's may people, not mandatory. ROC may. Next one, voluntary. When company itself wants, it can apply for dormant status. When is that? How is that? First is, the company will conduct a board meeting and approve the resolution, and it will call for a general meeting. Pass a board resolution, call for a general meeting. Obtain statement of affairs from a chartered accountant because you need a nil balance sheet. If you have any transactions, you cannot apply for dormant. conduct a general meeting and you need to pass a special resolution. Next one, because you have passed a special resolution, you have to file form MGT 14. Within 30 days of filing MGT 14, I need to file something called as MSC 1. That is the form which is filed for applying dormant status. Along with MSC 1, I need to attach something called as copy of special resolution, copy of statement of affairs, declaration by directors, other necessary documents. Next one, so I need to file all of that. On ROC being satisfied, the ROC will grant you something called as dormant status. Inform MSC 2, that's the reply given by ROC. What are the grounds considered by ROC to consider a company as dormant? What are the grounds considered? The first ground, there should not be any inspection, inquiry, investigation pending against the company. Prosecution is pending against the company. What do I mean by that? There is some case going on, there is some hearing going on. You cannot apply for a dormant status. If you have taken any public deposits and if those deposits are outstanding, section 76, you cannot apply for dormant. Or if you have made any default in repayment, you cannot apply for dormant. Next one, if there is any loan that you have taken, you cannot apply for dormant. Can apply for getting an NOC. Now, what is this outstanding loan? There is one point that we need to know here. What is that? With regards to the loan, the loan can be of two types. One is secured and one is unsecured. With regards to there are outstanding loans, whether secured or unsecured, we cannot apply for dormant status. However, if company has any outstanding unsecured loan, then the company may apply for the status of dormant only after obtaining NOC from the lender. That means what? If you have secured loan people, then it is not possible at all. So if you have a secured loan, not possible. What if you have a unsecured loan? Unsecured loan, you have to apply with the creditor for the approval. If creditor gives you an NOC people, then yes, you can do it. Remember this. Yeah. Next one, there should be no dispute in the management today. Now you need not have to attach to all of this in MSC when this is not required. No dispute in management or ownership supported by certificate. You should not have any disputes. A listed company cannot be given a dormant status. Default in paying workman dues, statutory payments or your PFs as the case may be. Outstanding taxes, duties to state government or central government. Any you need to pay any fees, any electricity bills, tax, GST, IGST and all? No. A company can remain dormant for maximum 5 years. After that, if you don't convert yourself, the maximum a company can remain dormant is 5 years. You cannot sleep forever, Noda. There is always a difference between rest for peace and rest in peace. You can rest for peace for some time. You cannot rest for peace forever. That time it will become rest in peace. That's what they are also trying to tell you. If at all you are applying for dormant status, the maximum you can be dormant for is only 5 years. Beyond that, people, you have to convert yourself into active. If you don't convert, then it is one of the ground for strike off. Failure to apply for active status, it will be struck off from the ROC. Remember. Next one, company seeking status of active company. A dormant company can voluntarily, they need to convert. No, they can convert. How? You can file form MSC 4. Along with that, you also have to file form MSC 3, return of dormant company. I'll file it with ROC. Now, ROC shall change the status of active company and he will issue a certificate of active status in form MSC 5. What are the mandatory active status? If company has violated conditions mentioned in the grounds, directors should within 7 days seek active status. On inquiry by ROC, it believes company has been active, the company shall be converted to active. What is this, people? Imagine when you filed dormant status, that time you said no inquiry, investigation or there is no prosecution. But what if after applying for dormant status, if something starts? You have to seek active status within 7 days. That is what they're telling you. Kiera, hello. Yes, that's your dormant status. Hello, people. Let's start our next chapter. That is chapter 14. Now, what does chapter 14 speak about? It speaks about the directors. Now, the first part let us do with regards to the DIN. Now, what does the law say? Every individual intending to appoint as a director shall mandatorily have a DIN. Now, how to obtain a DIN, people? It depends upon if it's a new company or if it's already a. Just a second. Hello? ನಿನಗೆ ಟೈಮ್ ಇದ್ರೆ ಒಂದು ಯಾವ್ದಾನ ಒಂದು ಎರಡು ಹುಡುಕ್ತೀಯಾ? Every individual intending to be appointed as a director shall mandatorily have DIN. How to obtain? Now, if it's a new company, people, then I need to apply it through my spice form, as simple as that. So, through my spice form, I'll be able to get it up to maximum of 3 people. Beyond that, sir, I need to go through people DIR 3. So applying through DIR 3, you will be able to get DIN. Now, who can apply DIN? It can be an Indian or it can be foreigner. Remember, for Indian, PAN is mandatory. For foreigner, PAN is not required. Then for foreigner, passport becomes mandatory. And not only that, the documents of the foreigner, it should be mandatorily certified by, basically you need to get it notarized and apostilled. What do I mean by apostille? Apostille is nothing but you need to get it certified by the Indian embassy there or your foreign diplomat office there. Now they need to certify the document. Yeah. For Indians, sir, it should be PAN, ID proof, residence, board resolution, and this is important. What is that? Your DIN has to be mandatorily signed by DIR 3 has to be mandatorily signed by whoever is the proposed director and anyone from the company where you are proposed as a director, from that company someone has to sign. It can be CS in employment or a managing director, CEO, CFO of the existing company. Wherever I'm proposed as a director, now that person has to sign. Remember that. Next one, sir. Directors, KYC. Oh, sorry, where is that? Change in details. Sir, my name changed, my address changed. I need to intimate all these changes, people, in the form called as DIR 6. I need to intimate to the ROC within 30 days of change. Remember, next one, cancellation of DIN. Can I cancel my DIN? Yes, possible. How? I can write to the central government or RD in the case of if I have two DINs by mistake, I can retain one, I can give up another. If at all I have obtained the DIN fraudulently, I can give up one. In the case of death, in the case of a person becoming unsound mind, in the case of a person becoming insolvent, I can cancel my DIN. Next one is called as surrender of your DIN. Can I surrender the DIN? Yes, possible, provided you can surrender the DIN only and only if you are not appointed as a director in any company and you should have not signed the document, any document you should have not signed using your DIN. If you have filed any document using your DIN, remember surrendering of DIN is not possible. So you should have not been appointed as a director in any company. Second thing is you should have not signed any document. How do I surrender the DIN? You will surrender the DIN in the form DIR 5. Sir, and once in a year, always remember every director should say to the central government that I am alive. How? You will have to file something called as DIR3 KYC web. It is nothing but confirming your phone number and email ID. A OTP will come to your phone number, a OTP will come to your email ID. You will say that none of my details are still changed and yes, I'm still in the same country. I'll give all my details. So, no, one second, what is this? So we will file this and we will give it to the ROC. So we will file this. So DR3 KYC web. Now, whenever there is any change in my number, Whenever there is any change in my email ID, then I need to file a form called DIR3 KYC. Yes, so DIR3 KYC is filed if at all there is any change in my number or my email ID. And for the first time, you will file DIR3 KYC. Going forward, people, you will file DIR3 KYC web. Now imagine in the month of April, it has to be filed by September 30th every year. Now imagine my number changed during the year. I can get it done. I can file DR3 KYC in the month of May. Sir, I filed it. Again, my number changed. I want to intimate this in the month of December. Can I still do it? You can still do it. You will file DR3 KYC only. But people, you need to pay a fees of 5,000 rupees for the change. Meaning you need to pay an additional fees to, make the change. You can still file. Okay. Failure to file, deactivation of a DIN. If you are failing to file this DR3 KYC, your DIN will be disqualified. Next one, sir, types of director. There are various directors. Let us take the important ones. Resident director. Who is a resident director, people? The person who has stayed in India at least for a period of 182 days during the financial year. We will call such person as a resident director. So one person should have stayed at least for a period of 182 days during the financial year. Remember, if it's a newly incorporated company, then it shall be taken proportionately. What do I mean by that? In general, for 365 days, I should have stayed in India for 182 days. What if I have incorporated my company in the month of 1st November 2026? My financial year will be 31st March 2027. Now, how many days are there? Let us imagine everything put together is coming to 150 days. I'm just taking an average. Now, I should have stayed in India for 365 days. I should have stayed for 182 days. Then for 150 days, how many days I should stay? I should do cross multiplication. That is the meaning of the note here. Done. Women director. Every listed company should have at least one women director, and every public company having a paid up capital of 100 crore or more and or turnover of 300 crore or more should mandatorily appoint one women director on the company. Remember, recently, as per your SEBI LODR, the top 1,000 listed companies shall mandatorily appoint one independent women director on their board. Every company, every top 1,000 listed companies should have one independent women director on their board. Remember that. Next one is small shareholder director. What do I mean by small shareholder director? Small shareholder director, every listed company may, upon notice, basically upon a request made by at least 1,000 small shareholders or 1/10 of the total number of such shareholders, whichever is less, appoint a person as small shareholder director. So minimum 1,000 small shareholders or 1/10 of such shareholders, whichever is less. So minimum 1,000 or minimum 1/10 of such shareholders, whichever is less. If a request is made by them, then people, I will appoint such person as a small shareholder director. So is appointment of small shareholder director mandatory on the company? Remember people, the words used are people, a listed company may. So it's not mandatory, it's optional. Now, sir, what do I mean by small shareholder? Small shareholder means a shareholder holding shares of nominal value of not more than 20,000. Remember, it's not market value, it's nominal value. Tenure, the maximum tenure of the small shareholder director people is 3 consecutive years. And he is not eligible for reappointment. Remember, he can be a small shareholder in not more than 2 companies, and that too, the second company should not be in a direct competition to us. He should not be associated with company in any other capacity for the 3 years from the date of cessation. Meaning, once you stop to be a small shareholder director, once you leave the company, you should not be associated with the company in any capacity for the 3 years. Additional point, he is counted in the total number of directors. I told you total he cannot be more than 2 directors. Such director may or may not be a shareholder, not liable to retire by rotation. Such notice seeking appointment shall be given at least 14 days before the meeting. Now this may or may not be, for this there is one point. Now what is that, sir? For small shareholder, we say, when will the small shareholder, when will his position come to an end? When he incurs any disqualification which is given under section 164. If he incurs any disqualification, he will have to step down as a small shareholder director. The office of director becomes vacant as per section 167. Technically, we'll be seeing both in our next chapters. He ceases to meet the criteria of independent. Remember, small shareholder director can also be treated as an independent director provided you satisfy the limits of independence. You satisfy the independence criteria. Next one, he ceases to be a small shareholder on and from the date of cessation. Meaning what? If at all my total value is going beyond 20,000, I become a shareholder of 30,000 value, I cannot continue as a small shareholder director. All these are the grounds for vacating my small shareholder directorship. Remember that. Okay, next one, appointment of other directors. First one is additional director. Remember, all these people are appointed by the board. That's why people, to appoint them, the power has to be given to the board by your articles of association. There should be the, what do you say, the power given to them in the articles of association. So what do you mean by additional director? Uh, Articles of association, if it is authorized, then the board of directors, the company itself may appoint any other person as a additional director. When will this happen? Imagine people, we need some, our minimum number of directors have gone below the minimum requirement, or there is some seasonal capacity. We want one expertise for one particular season. Now, for all of this, I need not wait for a general meeting. The directors itself has a power. For a temporary basis, we can always appoint. The tenure of such additional director will be up to the next AGM, one year. Whenever the AGM comes, people, your appointment will come to an end. But remember, the person who is being appointed as an additional director, he should not be a person who has been recommended in a general meeting, but the shareholders have rejected his recommendation. He should not be such a director. Clear? Alternate director, when will this happen? Whenever there is already what is a director, if the director is absent from the, the company for the last 3 months, he is not present because of any reason, in his capacity another director can be appointed. We call such director as an alternate director. Remember, who will appoint the alternate director? The board will appoint, not the director who is absent. So the board has a right to appoint the alternate director. Okay. He should not already be a director in the company, and he should not already be an alternate director in the company also. So you should be a outsider. You should be a random person. Uh, He is appointed in the position of director absent and original director returns, alternate director appointment shall come to an end. When the original director comes, people, of course, the alternate director's appointment will come to an end. Next one, people, is nominee director. When will nominee director come, people? Whenever financial institutions or the banks, creditors, when they give loans, they would want to safeguard their interest by, we would want to know what is happening on the board. So what will they tell? They will tell, one amongst no many directors, one person should belong to us. If they come with such condition, people, we call such people as nominee directors. So articles of association should authorize the company which secures financial assistance from banks may appoint a nominee director, and remember, they can't be removed by the company, and neither they will be proportional representation. All these things will not apply to this nominee directors. Next one, people, is casual vacancy. What is casual vacancy? Whenever a director is, resigning in between. Now, what will happen? the directors can appoint someone else in that capacity. Now, for example, the shareholders have appointed one director. Now, this person resigns in between the year. So the rest of the directors can appoint someone else in his position. We call such director appointed as casual vacancy. Remember, whenever you're appointing a casual vacancy, such a appointment should be ratified by the shareholders. It has to be approved by the shareholders in the next general meeting. Whichever is the next immediate general meeting that is happening, in that people, his appointment has to be ratified. Now, what will be the tenure of this person? His tenure will be as per the tenure of the original director. If another 3 years is pending, even he will be also appointed for another 3 years. This is people casual vacancy. Clear? Okay. Next one. Okay. Independent director. With regards to independent director, the only thing I want you guys to do is, what is an independent director? Instead of me just reading it out, I have already uploaded a full video on what is an independent director. I would recommend you guys to please watch it. The complete provision of independent director I have uploaded on YouTube, the CS channel of ArivuPro. The entire independent director provisions are there. Please watch that one thing. The rest of it I'll do it here. Clear? Okay. So, sir, independent director, sir, when, how, what? Independent director, first one, people, as per Companies Act, as per SEBI LODR. How many independent directors has to be there? First one, people, as per Companies Act. Companies Act says every listed company should have at least 1/3 of its board as independent directors. Unlisted public companies who is having paid up capital of 10 crore or more, or turnover of 100 crore or more, and aggregate of outstanding deposits, debentures, loans exceeding 50 crore. Remember that. This is 10 crore or more, 100 crore or more. This is exceeding 50. That means 50.1 should be there. Such unlisted public companies should have at least two directors as independent director. This is as per Companies Act. What is as per SEBI LODR? As per SEBI LODR, it depends upon your chairman. If the chairman of the board is a non-executive director, then people remember, the board of directors 1/3 shall be independent. If at all the chairman of the board is a executive director, then people, half of the board shall be independent. So if the chairman is non-executive, then people 1/3 shall be independent. If chairman is executive, if the chairperson is executive, then half of the board shall be independent. What if the chairperson is non-executive director but related to the promoter group? If that is the case, then also people, half of the board shall be independent. Remember that. Clear? This is as per SEBI LODR. Tenure of independent director, people, he will be appointed for a period of 5 years. Can we reappoint the person? Yes. How? By passing a special resolution. Correct? Yes. Remember, can I again appoint him for one more term? No. Once the 2 terms are done, people, you need to have a cool off of people 3 years. Until 3 years, you cannot appoint the same person again as a independent director. Now, recently there is a change. What is that? Whenever we are appointing, sir, one more thing, people, whenever there is a casual vacancy, we need to fill the casual vacancy within the 3 months from the date of vacancy, or not later than immediate next board meeting, whichever is later. 3 months time or board meeting, whichever is later, we need to fill the vacancy of the independent director as per this particular scenario. Next one, sir. This is important. What is that? Remember, today's date, whether you want to appoint as per SEBI LODR, reappoint or remove an independent director, then it should be subject to the approval of shareholders by a special resolution. So according to LODR, it is very simple. If I want to appoint, reappoint, or remove an independent director, I have to mandatorily pass a special resolution. However, they have passed one amendment. What is that? Provided that where a special resolution for appointment of an independent director fails to get the requisite majority of the votes, that means we did not get 75%. So can we appoint such person as an independent director? Answer is technically no. But still we can appoint the same person as an independent director itself. When? How is that possible? To appoint the same person as an independent director, sir, for that the following condition has to be satisfied. What is that? The votes cast in the favor of the resolution exceeds the votes cast against. That means we wanted to appoint Mr. X as an independent director. We got 55% of the votes in favor and we got 45% of the votes against. Now what to do? Now there is a second condition. What? And the votes cast by the public shareholders in favor of the resolution exceeds the votes cast against the resolution. What do I mean by that? Sir, in this 45%, let us imagine 10% of the public said no. Then people in the votes cast for the people, that is favor of resolution, should be at least 11%. So public shareholder saying no, public shareholding saying yes, it should be more. So if both the conditions are satisfied people, then I can appoint such person as an independent director even if I do not get a special resolution possible. Done. Next one, sir. Same thing applies people when I want to remove the independent director as well. So first try to pass special resolution. If special resolution is unsuccessful, then what do? You guys can pass majority and public majority will be considered. Done. Next one, sir. What else? Declaration of independence. Always remember, an independent director, whenever he is appointed, he needs to give a declaration that he is an independent director. He satisfies the section 149 subsection 6. Whenever he is appointed. Next one, every first meeting of the year, I need to again give a declaration that I am an independent director. Next one, whenever there is a change, as soon as a change is done, meaning I lose my independence, I need to immediately give a declaration. So the declaration of independence has to be given in these three scenarios. Done. Remuneration of an independent director, remember, he is not entitled to any stock options, but you are entitled for remuneration. You are also entitled for sitting fees. You will not be paid anything more than 1 lakh rupees. You can be paid salary as a commission also on profits. It is allowed. Appointment of an independent director of unlisted material subsidiary company. What is it, sir? As per regulation 24 people, at least one independent director on the board of a listed company shall be a director on the board of an unlisted material subsidiary company, whether incorporated in India or not. Explanation: material subsidiary shall mean whose income or net worth exceeds 20% of the consolidated income or net worth of the listed company and its subsidiaries. What do I mean by that, sir? Let us imagine, people, there is a company called Tata Motors. Now, this has a subsidiary company called Jaguar. Along with that, it has another subsidiary company called X, another subsidiary company called Y. Now, if I take the total example I'm taking, let us imagine if I take the total income of Jaguar, X company, Y company, Tata Motors, everything put together, the total income is coming to 1000 crores. In this 1000 crores, Jaguar alone's income, people, is around 250 crores. That is, it is exceeding 20% of the total overall income of all our companies put together. In such case, what is happening, people? We call this company as a unlisted material subsidiary company, Jaguar. Whether you are in India or outside India. Now what happens? Tata Motors is a listed company. One independent director of Tata Motors should be a director, whole-time director in Jaguar. Remember, that is what is condition. Exam point of view, important. Next one, sir. What is that? Okay. Data bank people. Now today, remember, for you to become an independent director people, you need to clear the exam. Only the people who are able to clear the online proficiency self-assessment test. If you're able to clear this, only then you can become an independent director. How is that? Whoever are the current independent directors, they are given 13 months time to clear the exam. Whoever wants to become an independent director going forward, then people, once your name is entered in the in the data bank maintained by IICA, Indian Institute of Corporate Affairs, you need to clear the exam within 2 years of your name being entered in that IICA records. So once you need to register yourself under IICA, once your name is registered, within 2 years you need to clear your exam. If not, people, you will not be able to become an independent director. Is this clear, all of you? Done. Next one, sir. What is the maximum number of directorships, people? A person can become a director maximum of 20 companies. In that 20 people, 10 can be public companies, the rest of it can be other type of companies. And remember, if I'm a director of listed companies, I cannot be a director of more than 7 listed companies. And I can be an independent director also on 7 listed companies. But remember, if I am a whole time director or a managing director in any listed company, then people, the maximum number of companies on which I can be an independent director cannot exceed 3 listed companies. So if for example Mukesh Ambani is a managing director of Reliance, he cannot be more than independent director in more than any other 3 listed companies. Remember, when you are calculating the directorships in Section 8 company, dormant company shall not be included. Hello? Done. Independent director, done. Appointment of directors. How do we appoint the directors, people? First of all, the whoever is a proposed director, they need to give us a consent. That is only called as DIR2. And whenever a director is appointed, people, I need to file form DIR 12. And director shall be appointed by shareholders in a general meeting. Exception is section 161, alternative additional casual vacancy. Whenever a director resigns, also people, you need to file form DIR 12 only. So appointment of a director and removal, cessation of a director, also you need to file form DIR 12 only. Next one, retirement of director by rotation. What do I mean by retirement of director by rotation, people? In case of public company, generally what happens, if you are appointing any person as a director, they will not, vacate their office only. They will sit in that office forever. Can they sit in the office forever, people? Like every employee will have deliverables. If you don't deliver, you will be removed. In the same way, even a director also should be removed if at all he is not delivering whatever he has promised to do. Yes or no? So people, that is only called as people retirement by rotation. By default, if a public company does not say all my directors are liable to retire by rotation, if the public company does not say so, then out of your total directors, always remember 2/3 of your directors are always liable to retire by rotation. In this 2/3 people, 1/3 of the directors shall retire by rotation every year. That means if I have total 9 directors, out of 9, 6 directors every year people shall be liable to retire by rotation. Out of 6 people, 1/3 shall retire. That is people, 2 directors shall retire every year. If you really like them, if you think they are fit, you can reappoint them. But at least let them retire, no? They know that they can retire. If they are not performing good, then don't reappoint them. Yeah? And always remember, a single resolution to appoint 2 or more directors cannot be passed. Appointment of director should always happen through individual resolutions. Sir, what if I want to appoint 2 or more directors in a single resolution? Then first you need to pass a resolution asking for the shareholders approval. People, I want to appoint all the directors in one resolution. Is it okay? If the shareholders first agree for that, then you need to first unanimously take that approval, and then you need to take the approval. And then you need to pass the resolution to appoint the two or more directors. So first you need to pass a resolution asking their approval to do or to appoint the directors in a single resolution. First you need to pass a resolution for that. Next one, sir. Right of person other than retiring director to stand for directorship. What is the section 160, sir? Remember, people, now can I nominate anyone as a director to stand for Infosys directors, election? Imagine I want this fellow to become a director. Can I do it? Is it possible? They're telling you yes, possible. Why not? Now that is what they're telling you. Right of person other than retiring director, you can stand for directorship. How? Any person or member intending to propose him as a director, whoever want, they can propose. 14 days before the general meeting, people, I need to give my notice. I am proposing Mr. A to be appointed as a director. I need to give his candidature along with his consent, that is DIR2. He should also hold it in. I need to give this notice 14 days before the meeting, along with the security deposit of people 1 lakh rupees to the company. So what will the company do? The company will take it, it will circulate to all the other members 7 days before the meeting. How? By notice, if individual notice is possible, and they will also publish it on the website of the company. And also remember, they can also publish it if individual notice is not possible. You can publish it on people, what is that? On the website of the company. That is on the in the newspaper. The newspaper can be English and vernacular. Remember, in the case of Nidhi Company, this will be not 10 lakh, 10,000 rupees in the case of Nidhi Company. Sir, this 1 lakh rupees, whatever I'm depositing, this 1 lakh rupees, will I get it back, sir? To get it back, people, either you need to win that directorship or you need to at least get 25% of your total valid votes. If yes, you will get back your money, whatever you have deposited. That's all. Done? Done. Next one, sir. Vacation of office of a director, 167 and 164. Both are important, remember. Sir, if at all a director, if any of these things happens, people, that is a disqualification. You need to leave the company. When, sir? First one, if you absent yourself from all the board meetings that is conducted in the last 12 months, that is one of the disqualification, you need to leave. A disqualification order is passed by any court or tribunal, leave. Incurs any disqualification specified under section 164. What is 164? We will see. You will have to leave. Hello? Okay. Next one, we will see in 164 there is one more catch. Convicted of any offense, imprisoned for a minimum period of 6 months. What if convicted for less than 6 months? Imprisoned for less than 6 months. Less than 6 months, people not disqualified. 6 months or more is disqualified. Remember that, important. You have been removed as per the act, disqualified. Ceases to hold office in that company. What is that? You saw just now. Independent director of a listed company shall be a director in the unlisted material subsidiary. Now, if I cease to become an independent director in a listed company, I will also cease to become a director in the unlisted material subsidiary company. Correct, Tom? So that is what they are telling you here. Next one, sir, disqualified under 164. In that 164 also, people, there are two types of defaults. One is 164.1, 164.2. What does 164.1 say? That is, director only gets disqualified. Example, unsound mind, insolvent, or you have filed your insolvent application, it is not yet approved, but you have filed. You have been convicted of an offense and you have been imprisoned for a minimum 6 months. And there is a cool off period, people, 5 years. If you are imprisoned for minimum 6 months, people, you cannot be appointed as a director for the next 5 years. And remember, people, if at all you are imprisoned for more than 7 years, then you are permanently debarred from being appointed as a director. Remember that. Next one, who else is disqualified? If at all you have not paid the call money, you are disqualified. Call money, first call, second call, you're paid up. Convicted with offenses related with related party transactions, disqualified. Does not possess DIN, of course disqualified. Holding more directorships than allowed, 20, 10, 7, 3, disqualified. Disqualifying order passed by court or tribunal, which we already saw. You have to vacate. Now this is a personal incapacity that the director is happening. Next one, people, director did not do anything, but he is part of a company which has disqualified. Like disqualification if he or has been a director of a company which has committed default of what? Company has not filed the financial statements or annual returns for a period of 3 continuous financial years. Disqualified. Deposits or interest thereupon, debentures or interest upon, or if you have declared a dividend but you have not paid it. In such case, people, and if that failure continues for 1 year, again, people, you are disqualified. But remember, people, whenever you're disqualified, I need to vacate the office, yes or no? But there is one thing here that you need to remember. What is that? Whenever 164 subsection 2, if I am disqualified, in such case, people, I need to vacate from all the other offices where I am a director except the place where the disqualification happened. Example, I am a director of company X and Y. The disqualification happened in the company X. I can continue in the company X until my tenure. But in company Y, I will be disqualified, and hence my appointment will come to an end. I'll have to vacate the office. And once I vacate the office, remember, I cannot be appointed in any other new company as a director. There is a cool off period, 5 years. I cannot be appointed in any other company. Sir, can I be appointed again in the same company where disqualification happens? No, once your tenure is done, you will have to leave the company. You cannot be reappointed again in the same company as well. Remember. Clear? Okay, next one, resignation of a director, section 168. Can a director resign? Yes, people, same thing. You resign. You intimate the company. The company will intimate the ROC within 30 days in the form DIR 12. Sir, what if the company does not intimate? Then macha, you also can intimate, but it's an option. In a form called DIR 11, you can intimate within 30 days of resignation. You can only intimate to ROC. Sir, what will be the effective date of resignation? If you have mentioned any date in your notice, as this is the date I want to resign, that will be the date. If nothing is mentioned, people, then whenever the company receives the notice, that will be the effective date of resignation. Is this clear? Hello? Done. Next one, sir. Loan to directors. Now, what is this loan to directors? Important. What is that? Can I give loan to the directors or can I give loan to those people in which the director is interested? Is it possible? That is what they're telling you. See, company shall not give directly or indirectly loan, book debt, guarantee, comma, security. We cannot give any of these things, it seems. What is that? To whom? It is not allowed. I cannot give any loan, book debt. What do you mean by book debt? For example, we are the company who is into manufacturing and selling of TVs. We give our TV to the director on EMI, or we tell him it's okay, don't pay, or pay later. It becomes a book debt. You're not supposed to give any of it to the Sims. If you're treating him like any other customer, that's okay, but you cannot give any special preferences. So director of a company or a director of a holding company, I cannot give any debt. Next one, I cannot give any debt to a partner or a relative of a director. So let us imagine the case of Reliance. Who is my director? Mukesh Ambani. Mukesh Ambani ka relatives, children and all, wife, I cannot give. If Mukesh Ambani has a partnership firm, in that partnership firm there is a partner. To them also I cannot give. Sir, okay, you will not give it to a partner. Can I give it to the partnership firm? Of course, I cannot give it to the partnership firm also. So I can neither give it to the firm, neither can I give it to the partner. Next one. Some cases it is allowed itself. You can give a debt when the company may provide to person in whom director of the company is interested, not the director. Wherever my director is interested, I can give a debt itself. When the person in whom the director of the company is interested means it should be a private company in which the director is a director or a member. That means XYZ Limited wants to give a loan to XYZ, or let us imagine ABC Private Limited. Now, why is ABC Limited? Why ABC Private Limited? Why are we able to give? They're telling you, whoever is my director in XYZ Limited, he is a director in ABC Private Limited or a member in ABC Private Limited. Then people, I can give loan to this ABC Private Limited. Next condition, body corporate in which 25% of total voting power is held by a director or two or more directors. That means our XYZ Limited can give loan to a body corporate. Let's imagine LLP, where my director or my two or more directors, they are holding at least 25% of the total voting power in that body corporate. Next one, body corporate whose directors or managers are accustomed to act in accordance with the director of the lending company. What do I mean by that? There is XYZ. In this, we have a director. There is ABC. Say, for example, ABC Private Limited. In this, there is a director. His name is B. B listens to whatever our director says. I tell him to do, he does. I tell him not to do, he will not do. Now, people, whenever we are giving any loan to such person, they're telling you this is also okay. This is considered as a company where the director is interested. Sir, we can give it to all these three people, provided what is the procedure? Procedure is, people, you need to pass a special resolution, and whoever is the borrowing company, it should utilize the money for its principal purpose. That is, people, your object clause, you should utilize for that purpose only. You should not utilize that money for any other purpose. If that is the case, people, it is allowed. If not, people, it is not allowed. Next one, sir, non-applicability. This section 1 and 2 does not apply to who? This is very, very important. Any loan given to the managing director or whole-time director, no other person, as a part of condition of service extended to all its employees. What do I mean by that? Being an employee in a company, everyone will have an option to take salary loan. Like that only we are giving an option for the MD also, but there is no discrimination. Or, sir, no, there is no such condition. We can take special resolution, shareholders agreed, and only then we are giving the loan to managing director, it is allowed. Next one, company giving loan guarantee security in ordinary course of business given for due repayment of any loan, and interest charged on such loan is not less than prevailing yield of government securities closest to the tenure. What do I mean by that, sir? Now, banking company gave loan, people. That's the ordinary course of the business of the company. That's why they give. Then what else I can do? I can give a loan, people. It's absolutely fine. Yeah. However, the interest charged on such loan is not less than the prevailing yield of government securities. Meaning what? Now remember, government securities is giving at least the interest of 7%. So you should at least charge from the director at least 7%. Next one, any loan guarantee security made by holding company to wholly owned subsidiary. You can give, a holding company can give it to wholly owned subsidiary. Guarantee or security provided by holding company in respect of the loan made by subsidiary company. You can only give loan, or if the subsidiary company is borrowing loan from someone, the guarantee can be given by the holding company. It is allowed, provided the money received by the subsidiary company, they have to use it for compulsorily their principal business activity, for no other purpose. Last one, sir, this entire section shall not apply to a private company which is whose share capital nobody should have invested money. Basically, what do you mean by this, people? No body corporate should have invested money. See, my God, Shantam Papam. in whose share capital no body corporate should have invested money. That means, let us take for example, there is XYZ Private Limited. Who is the shareholder of XYZ Private Limited? Sorry, everyone are individuals only. There is no company who is a shareholder. If a company is a shareholder in XYZ Private Limited, they cannot claim an exemption of 185. Second one, borrowing is less than twice of its paid up share capital or 50 crore, whichever is less. Sir, XYZ paid company has a paid up capital of 10 crore. What is the twice of it? Twice of it is 20 crore. What is the total loan in the XYZ Private Limited? Total loan is, sir, somewhere around 30 crore. Sir, if the borrowing is less than twice of its paid up share capital or 50 crore, whichever is lower. Now you tell me, people, 20 crore or 50 crore, what is lower? 20 crore is lower. And how much is your borrowing? Borrowing is 30 crore. Then people, you are not qualified. You are not exempted from this particular condition. Next one, no default in repayment of any borrowings. Next one, Nidhi loan given to director in the capacity of a member. In a case of Nidhi company, that's their objective. It is allowed, it is absolutely fine. There is no restriction. Yes, sir. So the most important topics, whatever is there, I've tried to cover everything in this particular section. Yeah. So let's take up the next chapter. What is the next chapter? Let's go to chapter. Let's start with the next chapter. Chapter 15, board composition and power of board. Okay, directly let's go. Composition of the listed entity, which we have already seen in the previous chapter. Again, I'm not going in detail there. The next thing is people section 180, which speaks about the restriction of power of board. What is restriction of power of board? Which speaks about what is the things which the board cannot do on their own. If it is coming under section 180, they can do it, people, only after passing a special resolution. Without passing a special resolution, they cannot do this. Now, what is that? First one, people, is to sell, lease, dispose whole or substantially the whole of the company's undertaking. Now, what is that? Now, what do I mean by this undertaking, substantially the whole of undertaking? It is nothing but an undertaking can be defined as, it shall mean an undertaking in which the investment of the company exceeds 20% of its net worth, or an undertaking which generates 20% of the total income of the company during the previous financial year. Now, for example, let us imagine Arivu, we have 5 branches. In 5 branches, if there is any one branch where our investment is, they're telling, exceeding 20% of our total our net worth is there, or exceeding 20% of our total income is coming from this one branch, then we call that as an undertaking. What do I mean by substantially the whole of the undertaking? In any financial year shall mean 20% or more of the undertaking as per the audited balance sheet. That is nothing but, people, substantially the whole means more than 20%. Technically, this is the meaning. I getting the point now? So, the expression substantially the whole of undertaking in any financial year shall mean 20% or more of the value of the undertaking as per the audited balance sheet. Now, what is undertaking? We got to know. 20% of the undertaking, if at all you are selling, you are leasing, you are disposing. So, one branch we are selling away, we are leasing it away. So, if there is any undertaking which is generating 20% of the income, and if that particular branch, if we are leasing it out or selling that branch out, then we can do it only after passing the special resolution. Next one, where is that? Okay, to invest in securities, the amount of compensation received from a merger or amalgamation otherwise than in securities. What is this, sir? To invest otherwise in trust securities, the amount of compensation received by it as a result of any merger or amalgamation. That means what, people? To invest otherwise in trust securities means what, people? Trust securities is okay. If you are investing otherwise than in trust securities, you need to invest only after passing a special resolution. Now, what is this? Let us imagine, people, Vodafone Idea came together. If they are entering into a merger, now, the new company will give purchase consideration to the previous shareholders, right? money will be settled, or shares will be settled, debentures will be settled, something will be settled. They are telling you whenever a company, if it is getting purchase consideration, the money, before it settles it to the shareholders, if this money is being invested into any other place, if you are investing it in the trust securities, that is okay. But if you are investing it in any other place, people, you can do it only after passing a special resolution. Okay, done. Next one, to borrow money, old plus new, something which is already done, plus whatever is the new money you are going to borrow, new loans you are going to borrow. If it is exceeding your paid up capital, free reserves, plus securities premium, if it is exceeding the aggregate of this, then people remember you can only borrow that money after passing a special resolution. Are you getting the point? Only after passing a special resolution you can do so. Okay, done. Now, it does not include temporary loans. What do I mean by that, sir? Whenever I'm borrowing these loans, imagine in this old plus new, I need not have to take any short-term loans borrowed. What do you mean by short-term loans borrowed? Short-term loans means, people, any debt which has to be repaid on demand or within 6 months, we call it as short-term loans. You need not have to add short-term loans in this. So old plus new, if it is exceeding aggregate of your paid up share capital, free reserve, securities premium, such loans cannot be borrowed without passing a special resolution. Okay, next one, to remit or give time. This you will be seeing when we are doing section 197. I will tell you when we are doing KMP chapter. Next one, contribution by board. Can we contribute? Yes. Charitable funds. What is the maximum we can contribute? The maximum we can contribute, these people, the board of directors can contribute 5% of my 3 years average net profits I can contribute. If at all I want to contribute more, then I need to take prior approval in the general meeting. Next one, political contribution. Can I do political contribution? Is it allowed? They're telling you political contribution can be made. Any limit? This is the irony. Without any limit, it seems. No limit at all. Yes, but certain companies cannot make political contribution. Which one? Government company. Of course, whoever is a ruling party, they are going to contribute to them only. Then where is the purpose served? Second one, any company who is recently incorporated, you are in existence for less than 3 years. Now these two companies cannot make political contribution. Third point, whatever is a contribution you are making, remember it has to be made in a legitimate form. That means it can be used, it can be made by check, or it can be by electronic clearing system. That is nothing but NEFT, IMPS, as the case may be. So not in cash, that's the meaning. And remember, whatever is the payments you guys have made, you need to disclose that in your P&L account of whatever is the expenses you have given. National Defense Fund, people, same thing, you have to disclose in the P&L account. And board is authorized to contribute such amount as it thinks fit. So there is no limit. So these are the contribution. 180 is restriction on power of board. 181 is charitable, 182 political, 183 is your defense fund. Okay, next important thing in this particular chapter, people, is committees. Directly go to committees. Now, what are the different committees, sir? The first committee that we have, people. Now, do not concentrate on LODR when you are doing Companies Act. When you guys are doing CMSL, do not do not concentrate on Companies Act when you are doing CMSL. Okay, now the first thing, sir, is audit committee. Audit committee, which is given under section 177. If LODR, that means it is regulation 18 of LODR. Applicability, same as independent director. What do I mean by that? Audit committee is applicable for every listed company, all public companies who is having a paid up capital of 10 crore or more, all public companies having turnover of 100 crore or more, all public companies having outstanding loans, debentures, deposits exceeding 50 crore. 50.1 should be there. Remember, important. The following classes of unlisted public company shall not be covered for the above purpose. That means, if you are a joint venture, wholly owned subsidiary and a dormant company, even though your limits are coming as per this, these companies still need not have to form the audit committees. Okay. Next one, who will be the members of audit committee? The audit committee shall consist of minimum 3 directors. 3 directors. In that people, independent directors will be forming the majority. Okay. Financial literacy, very important. Remember, the majority of the members of audit committee, including the chairperson, shall be financially literate. What do I mean by financially literate? The people who are able to read and understand the financial statements, we call them as financially literate. Remember, in the case of LODR, you will have financial expert. That will not come for Companies Act. I am not touching LODR now. Next one, sir. Chairperson of Companies Act. I mean, as per Companies Act, who will be the chairperson of the committee? Chairperson is not prescribed anything here. Yes, sir. Next one, role of audit committee. We will see. Basically, omnibus approval and all of that. Next one, evaluation of internal financial controls and risk management and all of that. Role only, no. Okay, power and all we'll be seeing when we are doing the audit committee only. I mean the omnibus. What is the frequency of the meeting? Articles does not provide. I mean your Companies Act does not provide. Quorum people, remember the Companies Act does not provide anything. But if Companies Act does not provide anything, then what do? You have to follow your Articles of Association. According to Articles of Association, if you have prescribed whatever is your quorum, that will be my quorum. Sir, what if my Articles of Association is silent? Remember people, if your Articles of Association is silent, in such case people, all the board of directors should be present to constitute a valid quorum. Now where is that given? That is given under Secretarial Standards 1. Remember, very, very important from the exam point of view. That's all done. Next one is people vigil mechanism. What do I mean by vigil mechanism? Vigil mechanism can also be called as people whistleblower policy. In your company, you need to have a mandatory mechanism where if at all your employees, directors, officers, if they come across any discrepancies, non-compliances, violations, fraud, they should be able to address it. They should be able to go and inform about it in some place. Now, sir, every listed company and companies which have accepted only deposits from public, I'm talking about section 76, and the companies which have borrowed money from banks and public financial institutions in excess of 50 crore, you need to mandatorily have a vigil mechanism. Why? Vigil mechanisms will help. If an employee is coming and sharing his thoughts, or if he is sharing the non-compliances, remember, the vigil mechanism shall provide for adequate safeguard against victimization of employees and directors. You cannot harass them. And remember people, if needed, we can also give you a direct access to the chairperson of the audit committee. And remember, secretary of audit committee will always be a CS. Okay. Omnibus approval will come back. Nomination and remuneration committee people, what is that? Section 178, regulation 19. Same as your independent director. What is that? 10 crore, 100 crore, exceeding 50 crore. Joint venture company, wholly owned subsidiary company and dormant company need not form NRC. Constitution of committee of members, NRC people shall consist of 3 or more non-executive directors. Remember that. And 1/2 of the board shall be independent. People, in the case of audit committee, it was 3 directors, majority shall be independent. Here everyone should be non-executive, and they're telling you half of them should be independent. There it is majority. Remember the words. Chairman, silent. Role of NRC, nothing but nominate the directors, fix their remuneration, review their performance. All these things will come there. Frequency of meeting, silent. Quorum people, same thing. Whatever we saw in audit committee, as per AOA, if AOA is silent, SS1 will prevail. Remember, important. Next one, people, stakeholder relationship committee. What do I mean by stakeholder relationship committee? Section 178 speaks about it, and regulation 20. Stakeholder relationship committee means nothing but people. It is the responsibility of them to address if any discrepancies are there by any shareholders, debenture holders. If they face any issues, they should be able to reach out to someone, right? That someone is people, stakeholder relationship committee, something like grievance redressal. So who should appoint? The company which consists of more than 1,000 shareholders, debenture holders, deposit holders, and any other security holders at any time during a financial year shall constitute a stakeholder relationship committee. I can take it as an aggregate limit. Everything put together, 1,000 also people, SRC will be applicable. Listed company, don't check anything. Mandatorily applicable. Members, nothing prescribed. Chairperson, chairperson shall be a non-executive director, and the role of stakeholder relationship committee is nothing but grievance redressal. Remember, frequency does not describe. I mean, our what is that? Companies Act is silent on it. Next one, people, risk management committee. Companies Act as it is does not apply. Technically, we can skip also, but on the face of it, you see. Risk management committee, people, is covered under regulation 21. Risk management committee, who and all will have to comply with it. First of all, it is not applicable for unlisted company. For a listed company, top 1,000 listed companies, and recently they have added one more thing, people, high value listed debt. High value listed debt. Such companies also will have to mandatorily have a risk management committee. Now, what is the composition of risk management committee? It will consist of minimum 3 members. 3 members, not directors. Majority of them shall be directors, including at least one independent director. What do I mean by that, sir? Remember, people, even a non-director also can become a member of risk management committee. That is very important. In case of listed entity, if you have SR equity shares, at least two-thirds of the committee shall comprise of independent director. The chairperson of RMC shall always be a member of the board. The meeting or quorum, the risk management committee shall at least conduct 2 meetings in a year, and the quorum shall be either 2 or 1/3 of the member, whichever is higher, including always at least one member of the board shall be present. The quorum, sir, this has been now increased from 180 to 210 days. There shall be, the meeting shall be conducted in such a manner on a continuous basis, not more than 210 days shall elapse between 2 consecutive meetings. So we saw here, right, 2 times in a year, the gap between 2 meetings shall not be more than 210 days. Okay, basically what is the role, people? Risk management committee always, risk management committee will take care of any, imagine unforeseen events, business continuity plannings, all those things they will be trying to manage it. Okay, what is the role of audit committee? Before that, let us go directly to your, okay, guilds. We'll see guilds. Section 186. What is section 186? Whenever a company makes any loan, any investment, okay, let us do in our order only. If a company is giving any guarantee to someone, if a company is making any investment, if a company is making any loan, if a company is giving any security, section 186 will apply. Now, what if it is making any guarantee, investment, loan, security, sir? In such case, they're telling you, it stipulates that no company shall directly or indirectly give any loan to any person or body corporate, basically more than people. What is the maximum they can give? They cannot give people value of more than 60% of its paid up capital, free reserves and securities premium, or 100% of its free reserves and securities premium, whichever is higher. So what is the maximum guilds we can do? It has to be taken aggregate, everything put together. So my guarantee, investment, loan, security, everything put together should not be more than 60% of its paid up share capital, free reserve, securities premium, or 100% of free reserves and securities premium, whichever is higher. It should not go beyond that. Sir, what if we want to give beyond that? If you want to give beyond that, people, then you need to pass a special resolution. If it is within that limit, people, you need not take shareholders approval. If it is beyond that limit, people, you need to mandatorily take shareholders approval. That is, special resolution is mandatory. Next one, sir, you also have to disclose about this in the financial statements and prior approval of financial institutions. Should I take prior approval of financial institutions? The answer is yes. If at all you have any outstanding loan, but even this condition can be exempted, meaning I need not have to take any prior approval of financial institution. When is that, sir? If at all the prior approval is not required, when is it, people? If at all the total amount that you guys are doing, guilds, if it is not exceeding the limit prescribed, what is the limit? 60% of paid up free reserves securities premium, or your 100%? If it is not exceeding that limit, and I have not made any default in repayment of any of the installments, if both the conditions are satisfied, in such case I can do guilds. Even though I have outstanding loans, I need not have to take any approvals. Remember that. Next one, rate of interest on the loan. Always remember, whatever is the interest you charge, the rate of interest, it shall not be less than, people, whatever is the prevailing interest rate of any government securities closest to your tenure. Meaning, if a government security is there for 3 years, if your loan amount is also 3 years, the minimum interest shall not be less than whatever is the prevalent government yield rate. Yes, however, this condition shall not apply to a Section 8 company in which at least 26% or more paid up capital is held by government, and they are investing that money, they are giving that money as loan for funding industrial research and development projects. In such case, people, this condition will not apply to them. The rate of interest condition will not apply to them. So it can be even less than that as well. Remember this.
Hello.
Disqualification. A company which is in default in repayment of any deposits, they cannot make guilds easy. Maintenance of registers. Remember, all the entries that you have made, guilds, you have to maintain it in the form MBP2. Yes, and it shall be preserved in the company permanently, and all the entries shall be made within 7 days of making the guilds. Done. Non-applicability. Okay, this is the main point of your guilds. Remember that. Next one, sir, investments to be held in company's own name. Technically, all the investments you make, people, should always be held in company's own name. If at all, if there is any investments you make, if it is not held in your own name, you need to, what is that? You need to make an entry of all of that in the form MBP3. What is MBP3? All the investments made by the company which are not held in its own name. Remember that. Okay, let us go to the next important ones, that is related party transactions. What do I mean by related party, people? For a company, who and all is considered as related party? Now let us take from the example of Reliance Industries. They're telling you the director and the relative. Director, I'll take Mukesh Ambani. Mukesh Ambani and his wife are considered as relative. Next one, the CS, KMP, CFO, CEO, all of them are considered as related party. Not only them, also their relatives. Who is considered as related party to Reliance? A firm in which director, manager or his relative is a partner. What do I mean by that? For Reliance Industries, who is my director? Mukesh Ambani. Now Mukesh Ambani is also a partner. He is a partner in some partnership firm. They're telling you this partnership firm where my director is also a partner, this is considered as a related party. Next one, a private company in which Mukesh Ambani or Mukesh Ambani's relative is a member or a director. So in a private company, if that private company, in that my director is a shareholder or my director is a director, that private company is also considered as a related party. Next one, sir. A public company in which a director or manager is a director and holds along with his relatives more than 2% of paid up capital. For Reliance Industries, his director Mukesh Ambani, along with his wife, is a director and a shareholder in one public company. Let us imagine XYZ. In that XYZ, Mukesh Ambani and his wife are holding more than 2% of paid up share capital put together. That public company becomes a related party for me. Next one, any person on whose advice, directions or instructions a director or manager is accustomed to act. If Mukesh Ambani is listening to anyone's direction or advice, people, whoever is controlling Mukesh Ambani, they are considered as related parties. Next one, any body corporate which is a holding company, subsidiary of a holding company and an investment company or a venture company. Basically, people, my subsidiary company, my holding company and my associate company, and there is a company X. I am one subsidiary company. There is another subsidiary company of company X, company B. Any transactions between these two are also considered as related parties. Remember that. Sir, what if it's a related party transactions? Always remember, if it's a related party transactions, you need to mandatorily pass a board resolution. However, if related party transactions, if it is exceeding certain limits, what are the limits? See, these are the related party transaction. If at all you are selling or purchasing or supplying any goods or materials, if the value of which is 10% or more of the turnover of the company, it is not single, it can be one time or all the transactions put together in a year. If it is exceeding 10% or more of the turnover of the company, then people, if it is less than 10%, then people, only board resolution is sufficient. If it is 10 or more percentage, people, I need to also pass board resolution plus ordinary resolution. Selling or otherwise disposing of any property. If I am selling or disposing of property, what is the value? 10% or more of the net worth of the company, board plus ordinary. Leasing of property, board plus ordinary. Availing of any services with a related party, the value of which is 10% or more of the turnover of the company, board plus ordinary. Where the transaction or transactions to be entered into as a contract or arrangement is for appointment to any office or place of profit in the company, its subsidiary company or associate company at a monthly remuneration exceeding 2.5 lakh rupees as mentioned in clause F. So imagine you are appointing someone as a director. If they are entitled for more than 2.5 lakh as a remuneration, monthly remuneration, people, you need to take ordinary resolution. What do I mean by that? Imagine Mukesh Ambani's son is appointed as a director to a company. For a monthly remuneration of more than 2.5 lakh, they're telling you, you cannot do it without taking the shareholders' approval. Where the transaction or transaction to be entered is for remuneration for underwriting the subscription, underwriters. If you are paying them exceeding 1% of the net worth of the company, people, then ordinary resolution is mandatory. However, remember, people, whenever we are taking this, I have put everything in one shortcut. Remember this. If it is a related party transaction, however, it is your ordinary course of business and in your arm's length transaction. That means, now say for example, there is a company called as, say, Jio. In Jio, there is a director. Now, Jio's director may use Jio SIM card only by paying the required money. That's called as ordinary course. The SIM card is purchased by you, me, and also the director of Jio. Now, should I consider this as a related party transaction? They're telling you no, provided if it is ordinary course. That means everyday business of the company, and it should be at arm's length price. That means your cost and the whatever is the cost at which they have given you the SIM card, it should be the same for what they have given it to the director also. If the cost is same, in such case they are telling you board approval is also not required, shareholder approval is also not required, but however, audit committee approval you need to take. Hello? But remember, if it is not ordinary course or if it is not in the arm's length price, you need to take all the approvals. Remember this. And one more thing you need to remember is that, what is that? If at all there is any related party, no Mukesh Ambani, he cannot participate while he is voting for that related party transaction. He need to disclose it and he need to walk out. Correct? Hello? Remember that. Okay, okay. No voting by a related member. A member of the company who is related party shall not vote on the resolution. However, this provision shall not apply to a company in which 90% or more members in number, not value, they are all relatives or promoters, or they are all related parties. Then people, of course, you can continue. You just disclose the fact. You can continue. All these the restrictions will not apply. Where any director is interested in any contract or arrangement with the related party, such director shall not be present at the meeting during the discussion, which we already saw. Disclosure in the board's report, you need to disclose all the related party transaction in the form AOC2 in the director's report, along with the director's report. And people, consequences of related party transaction, people, we already seen in the previous chapter. First thing is, people, the directors will be disqualified for a period of, people, 5 years. That is one thing. Next one, more people. Whenever there is any loss that we have suffered and there is a, because of related party transaction, we can recover that loss from such employee or such director, as the case may be, whatever loss we have suffered. Next one, people, whatever the contracts we have entered, people, remember that will not bind the company, provided, if you still imagine related party transaction happened, we have not taken the approval, you can still make it valid. How? Within, what is that? See, without obtaining the consent of board or general meeting, if you have done the transaction, and if it is not ratified by the board, as the case may be, by the shareholders at a meeting within 3 months from the date on which such arrangements was entered, and such contract shall be void by the option of the board. What do you mean by this, sir? Remember, people, even on the date of entering into a contract, if I have not yet taken the board approval or the ordinary resolution, it's still okay. Within 3 months, I have to ratify it, meaning enter into a contract, call them, and then take approval. It will still be valid. Yeah. So related party transaction, the next thing that comes is, people, omnibus approval. What do I mean by omnibus? Okay. Now remember, people, whenever I need to take or whenever I need to do a related party transaction, I need to mandatorily take the approval of the audit committee. So now we will be doing so many related party transactions. Is it possible for me to take an omnibus, to take the audit committee's approval for every transaction? They're telling you do one thing. If at all the transaction you're doing with the related party, if it is repetitive in nature, then you can save time. How? By applying for something called as omnibus approval. What do I mean by omnibus approval, people? Omnibus approval means an approval where I would be giving an approval for all the transactions put together. So I'll give an approval at once, provided, remember, the omnibus approval. For me to give an omnibus approval, you need to give me a lot of disclosures. I'll be asking you what is the nature of transaction, who are the parties, how frequently this particular thing is going to happen. So I need to disclose all these details. And also I'll clearly say what is the maximum value per transaction. I'll disclose all of this. Sir, what if I'm not able to give you all these details? Then in that case, people, I will still be able to get an omnibus approval. We will still get it. Provided, in such case, if you can say that, 1 second. So I can still get the omnibus approval. It will clearly say, see, maximum value of the transactions in aggregate, which is going to happen in a year. The maximum value per transaction we are allowing. Extent and manner of disclosures to be made. Review of such intervals, we will review it basically every year. The transactions which cannot be subject to omnibus approval, everything we will disclose when we are giving you the omnibus approval. Meaning some some transactions cannot come under omnibus approval. So we will disclose all of that. However, people remember, omnibus approval should be valid for a period of 1 year. Now, remember, if I am not able to give all the details to the audit committee, they will still give me the omnibus approval, provided the value of transaction per transaction cannot be more than rupees 1 crore. They can still give me an omnibus approval. Here, okay, that is my related party transaction. Yes, sir. That's all. So more or less, these are all the important points that you can pick up from this particular chapter. So read this. If you guys want, you can go for a break and come, and we'll finish your next topic. Clear? Now let us start with your next unit, people. That is chapter 16. Now in chapter 16, you can expect two things, people. What you can expect, the board resolutions. I have also uploaded one video, people, how to draft resolutions and things like that. Pay some attention, watch that particular video. In that, I have clearly explained you on how to present your resolutions, and as the case may be, important from your exam point of view. Okay, the next chapter, people, meeting of board and its committees. Here, pay attention from your end on drafting of majorly resolutions. Next one, notices. Next one, they can ask you to draft agenda of a board meeting, as the case may be. So these things, try to pay some attention. Okay. So people, first thing, people, board meeting, section 173. What does it say? What is the frequency of board meeting? Board meetings, people. The first board meeting should be conducted within 30 days of incorporation. The subsequent, every year going forward, you need to conduct minimum 4 board meetings in a year, in such a way that the maximum gap between 2 board meetings should not exceed 120 days. There is an exception to this rule. In the case of OPC, small company, dormant company, a registered startup, there should be minimum 1 board meeting in each half of the calendar year, and in such a way that the gap between 2 meetings shall not be less than 90 days. So at least there should be a gap of 90 days. The same thing even applies for the section 8 company as well. At least in every 6 months there should be 1 board meeting, correct? Okay. When class starts only, someone will call. Okay, next one, sir. Sir, notice of board meeting, people. How many days notice should I give? You should give at least not less than 7 days. Remember, people, the difference between the general meeting and here, they have not mentioned a clear days notice and all. So I need not have to exclude the 2 days date of giving. All that rule will not apply here. Generally, it's a good practice to exclude a day of giving the notice. That's generally a good practice. But there is no clear day concept and all mentioned here. Sir, can I give shorter notice? Is it possible? Yes, it's possible. I can even give 1 day notice. Possible, provided what is the condition? At least 1 independent director should be present at the meeting. Sir, what if the independent director had some commitment and the independent director could not attend our meeting? In such a way that, in such case, what to do? If the independent director is not present, then the decision taken in that particular meeting. So conduct a meeting. Whatever is a decision you have taken, circulate that particular decision, meaning the resolution, circulate it to all the directors, and it will be final only if it is ratified at least by 1 independent director. What if the independent director does not agree? Then people, whatever is the resolution you passed on that day, it will be considered as invalid. Sir, I have a doubt. What? In my company, I do not have an independent director at all. Now, how do I conduct a meeting at a shorter notice? Then people, for you, if company does not have an independent director at all, then people, circulate it to all your directors. It will be final only after majority of the directors ratify. That's all. Sir, remember, you need to give the notice of a meeting even if the days of the notice is already given in your AOA. You're already conducting your board meeting on a pre-decided dates. Still, people, you need to give the notice of the board meeting, mandatory. What is the quorum of the board meeting, people? The quorum of the board meeting shall be 1/3 of the total number of directors or 2, whichever is higher. Remember, any fractions shall be rounded off as 1. Quorum, people, of, remember, recent amendment, of course, it's been a long time. The top 2000 listed companies, they shall have a quorum of 1/3 or 3, whichever is higher, and also including at least one independent director should be present in the meeting. Yeah, so earlier it was 1/3 or 2. Now you can imagine in the 2, it should be one independent director also should be present. So it will be 2 plus 1. Any fraction should always be rounded off as 1. Quorum always to be present throughout the meeting. Remember, in case of a Section 8 company, people, the quorum will be 8 members or 25% of the total strength of the board, whichever is less, subject to at least 2 people should be present in that particular meeting. That should be my quorum. Okay. Sir, when to conduct a meeting, people? Remember, the law says the original meeting can be conducted on any day, but an adjourned meeting cannot be conducted on a national holiday. If you dive deep into this and see, people, there is no logic as such, people. How can I not conduct a meeting on national day if it's an adjourned meeting? An original meeting can conduct on any day. If you ask me, it's a slip over, that's all. Yeah, that means what? My original meeting can be even conducted on a national holiday. The law is silent on it. Remember that. Yeah, if I go as per the words, then that's the answer. Now, if your question is what if it's asked in the exam, sir? This is the answer. Original can be conducted on any day. The adjourned meeting should be conducted on any day except a national holiday. Okay. Sir, interested director. What do I mean by that? When I'm counting the quorum, imagine if we are passing any resolution in which any director is interested, meaning that is somewhere related to me, or I'm getting some benefit out of it. In such case, people, they're telling you he shall not be present in that particular meeting, and hence he will not be counted for the purpose of quorum for that particular matter. After that matter is done, he can come back. However, there is an exception. This rule shall not apply to the directors of private company. That is, he can participate and he is also counted in the purpose of quorum. However, remember, sir, you're telling if there is an interested director, then he needs to leave the company is what you're saying. I mean, he should not be in that particular board meeting. Sir, what if, imagine we have 8 directors. Now, what is my quorum? Sir, 1/3 or, okay, let us imagine our directors are 9. Sir, what is my quorum? 1/3 or 2, whichever is higher, correct? Sir, 1/3 of 9 is 3. Sir, let us imagine 7 of my directors are interested. In such case, people, if interested directors exceed or equal to 2/3 of number of directors, then the number of non-interested directors not being less than 2, they only will be the quorum. Okay, 2 directors non-interested, no, it's okay. For that matter, those 2 people itself will be the quorum. They can conduct a meeting. I don't know why they have not tested this particular point in a practical way till date. It's a very good point, but they are not tested. Next ones are passing of resolution by circulation, section 175. What does this say, people? They are saying, sir, instead of conducting a board meeting, can we just conduct a meeting just by circulation? That means imagine by an email, or can I conduct it by post? Is it possible? They are telling you the matters covered in section 179 and rule 8 cannot be passed by circulation. That means what? Section 179 is nothing but people power of board. So the entire power, what we saw in our previous chapter, it has to be conducted only in a physically conducted meeting. It cannot be done by circulation. You need to conduct a meeting for that. You have to conduct a meeting for that. Okay. Next one. the resolution, that is draft, shall be circulated to all the directors. Now what happens once we decide that we are discussing this particular matter by circulation, we will circulate the draft resolution for all the directors for them to respond. We can send it by hand, meaning give it personal, by speed post, by courier, by electronic means. Now, the said resolution must be passed by the majority of the directors to be a valid resolution. So, if there is 9, 5 people agree, then it's a valid resolution. However, remember, 4 people, let us imagine, 5 people responded. Now, can I say the resolution is passed? Answer is no. Why? Because remember, if minimum 1/3 of total number of directors, if they want a physical meeting for this matter, we do not want it to be decided just on a paper. If 1/3 of them demand for a physical meeting, so in this 4 have not yet replied, 3 says no, we want a physical meeting, the company should conduct a physical meeting. The resolution passes through circulation shall be noted and forms part of the subsequent meeting. I need to prepare minutes, no? It shall be forming part of the minutes of the next meeting. So I need to note it. So that is what they are telling you. Clear? Okay. Quorum we did. Result. People, what if quorum is not present during the given time, people? Of course, the meeting shall be adjourned to the next week, same time, same place. If it's a national holiday, it will be the next day. However, if at all, even in the adjourned meeting, people, even if in the adjourned meeting, if no quorum is present, then meeting will stand dissolved. Then the meeting will come to an end. Remember that. So next one, the chairman may, unless dissented to or objected by the majority of directors present at a meeting at which a quorum is present, adjourn the meeting for any reason at any stage of the meeting. Very important. What is that? What? Can a chairman adjourn a meeting arbitrarily? Imagine a duly constituted meeting. The quorum is present. Can a chairman adjourn a meeting at his own discretion? Answer is no. If it is objected, people, no, you cannot. Yeah. Quorum should be present throughout. Place of vacant. An interest in case of private company, it's 1/3. Meaning of 174. Meeting of committees, same thing. You need to follow the same thing. Committee also. In case of equality of votes, what will happen, people? You will always have second or casting vote. Correct? Meeting of committees, that is your audit committee, nomination, remuneration committee, what is it telling you? A committee may elect a chairman of its meeting. What if a chairman is not present within 5 minutes? Then whoever are the other members, they can elect one amongst themselves to be the chairman. The meeting adjournment, a committee may meet and adjourn as it thinks fit, because I told you, company law, it says it's your choice. If at all there is a equality of vote, the chairman will have a casting vote, also called as second vote. Sir, all acts done by any meeting of the board or a committee shall, notwithstanding that it may afterwards discover that there was some defect in the appointment of any one or more auditor, whatever they have done, it will still deemed to be valid. What do I mean by that, sir? Imagine, people, we have conducted a board meeting. All of us agreed for a particular resolution. Later we got to know one of the director was not properly appointed. It will still not invalidate the resolutions passed. The resolution will still be considered as valid. That is what is given here. The attendance registers of the board meeting shall be preserved for a period of 3 years. And if it is in the form of loose leaf form, if you are maintaining it in the paper form, you need to bind it periodically. The periodically will be 3 years. The attendance register is open for inspection by the directors. This is very important. What is that? An attendance register can be checked by any director. Yes, any director. Sir, what if there is an attendance register of 2017 to 18? There was one director, he left. Now he wants to come and check whatever is attendance register of 2017 and 18. Can he check? Answer is yes. Even after a person ceases to be a director, he shall be entitled to inspect the attendance register of the meeting held during the period of his directorship, not everything. I hope this is clear. Next one. Sir, what about the directors participating through electronic means, video conferencing? Is it possible? Yes, a director can participate through video conferencing. Of course. Sir, now who will sign the attendance register on behalf of the person attending through video conferencing? Remember, it shall be signed by a company secretary. Sir, what if there is no company secretary? Then people, it shall be signed by the chairperson. Sir, what if the chairperson is also not available? Then people, it shall be signed by any other director present at the meeting if authorized by a chairperson. And the fact that participation is also recorded in the minutes, meaning if chairperson authorizes any other person present in the meeting, that is the board, he can go and sign on behalf of that person, and provided this fact also should be mentioned in that particular register. And remember, the attendance register should be preserved for a period of 8 years. Leave of absence will be given to those directors who are unable to attend the meeting. Remember, if you are not attending the meeting for a period of 12 months, you will be treated as disqualified. The chairman of the meeting, we saw. Minutes, people. Generally, whatever we have seen in general meeting, the same will hold good because it is section same, no? 118. I would have also told you there only about the signing of the minutes also. So, nothing to worry there. Chairman of this meeting or the chairman of the next meeting, passing of resolution by circulation. Okay. Duties of company secretary at the meeting, during the meeting, after the meeting. Before the meeting, notices. During the meeting, help with quorum, take all the declarations, help the chairman if at all any legal work required. MDP ones collect all the declarations given. Independence, if any directors are giving you independence declaration on their independence, collect it. After people will be all the any forms to be filed, file it with ROC, prepare the minutes, enter the minutes in the minutes book, finalize everything as the case may be. That's your minutes. Virtual meetings, people. What is virtual meetings, da? You wanted a virtual meetings, huh? Huh? Okay. There is nothing much here, people. Secretarial standards. What is SS1, SS2? SS1 is people basically secretarial standards of board meeting, and SS2 is secretarial standards of general meeting. Generally, in general, secretarial standards is not applicable to OPC and Section 8 company. But Section 8 company, a few parts of secretarial standards will be applicable with regards to the board meeting. That is what they are telling you. Sir, is OPC, do they have to follow SS1? If you have only one director, then no. If you have more than one director, then yes. That's all. Let's go to the last chapter, people. Last chapter is, people, KMP, the most easiest for you all. Yes, Let us concentrate as much as possible, people, for your KMP sections. Clear? Okay, yes, people. Now, what do you mean by KMP? Of course, we have a definition of what do you mean by KMP. Who is a KMP, people? After going around the world, we are coming for the definition of KMP. Who is considered as KMP? Who is considered as KMP? CEO, CFO, Managing Director, Manager, Whole-Time Director, CS, and one level, not more than one level below the board is considered as what? KMP. Agreed? Okay, fair enough. Now, what are they saying, people? Should every company appoint a KMP? They're telling you, as according to section 203 and read with rule 8, every company shall have a full-time KMP. Who are the full-time KMP? A company which is a public company having a paid up capital of 10 crore or more should have a mandatory managing director or CEO or manager, in their absence a whole-time director, and CS and CEO. They should be mandatorily appointed. If your paid up capital is, people, 10 crore or more in the case of public company. In the case of listed company, it is mandatory. Sir, what about private company? Private company, as per rule 8A, if your paid up capital is 10 crore or more, you need to have a mandatory full-time company secretary appointed in your company. That is section 203 done. Now go to next case. That next case is nothing but, sir, key points on KMP. What is that? One person can be a KMP of maximum one company. However, sir, let us imagine there is a holding company. In that, I am a CS. In a subsidiary company, can I also be a CS? Yes. The answer is, people, answer is yes. That is what is given here. You can be a KMP of more than one company, provided that company is your subsidiary company. Allowed. KMP can be a director in other company. Prior permission of the board is required. Meaning, sir, I am a CS in my company. Can I be a director in other company? Possible, provided, people, your board has to agree for it. Agreed. Next one. Can a person be a MD of two companies? Yes, possible. Maximum two companies, not beyond that. Provided appointment is approved by all the directors in a meeting. So whenever you are being appointed as a director in another company, now such approval first has to be consented by all your directors, and not even one vote you have to get against. So remember, vacancy in a KMP is always filled by the board. This is very important. Remember, appointment of KMP and reappointment both are done by, people, the board of directors only. Yes. Next one, return of appointment, people, form MR1 within 60 days of appointment. Of course, if you are a managing director, your appointment has to be also confirmed by shareholders. Whenever you appoint a KMP, you need to intimate people to ROC about such appointment in the form MR1. So these are some special points about your KMP. Now, sir, directly going to the appointment of KMP. Can we appoint? Yes. How? I need to follow section 196, read with schedule 5, which speaks about appointment, which is read with part 1. Now, what does it say? Whenever you want to appoint a managing director, whole-time director, and manager, then what are the conditions you need to satisfy? First one, the company shall not appoint a managing director and manager at the same time. Why, people? Because of conflict of interest. Both of them have a substantial interest in the company, so you cannot have both, because both cannot have highest power in the company. Then there will be a conflict. The tenure of these people shall be maximum 5 years. Can I reappoint them? Absolutely fine. There is nothing called cool off period and all. But the reappointment, people, cannot happen prior to 1 year of his expiry. So 4 years is done. Another 1 year is pending. Now you can reappoint. You cannot reappoint in the 3rd year only. That is not possible. Disqualification to be appointed as a MD, WTD manager when if at all you are below 21-year-old, that is if you are not 21-year-old, or people if you have attained 70 years old. In such case, people, I cannot appoint you as a managing director. However, there is one exception. What is that? People, let us remember, people, if you are 70-year-old, can I appoint you? Yes. Beyond 70, can I appoint you? The moment you are 70, you have to discharge, you have to disclose. I mean, you'll have to resign. But can I still continue his appointment? Yes, possible. How? You need to pass board resolution and you need to pass special resolution. Beyond 70 years, you can still appoint. Sir, what if I did not get special resolution? Then what did you get? Sir, I got ordinary resolution. Then okay. If at all you managed to get ordinary resolution, then do one thing, pass board plus pass ordinary plus you need to take central government approval, then you can still appoint a person who is more than 70-year-old on your company. Allowed. Sir, at any given point of time you have been adjudged as an insolvent, you cannot be an MD. Anytime if you have suspended any payment to the creditors or you have went and compromised with them, you cannot become an MD. Anytime if you have been convicted of an offense and if you have been imprisoned for more than 6 months, less than 6 months not disqualified, more than 6 months people, then they are telling you, you will not be appointed as a managing director. And sir, subject to the provision, appointment, what is this? Sir, I told you that you need to take the approval of central government. How will I take the approval of central government? I will take the approval of central government in the form MR2. That's the form I will file. Yeah. And what are all the forms that you file, people, when you are appointing a managing director? Always remember, when I'm appointing a managing director, I need to file these forms. According to section 117, whenever an MD is appointed, you need to mandatorily file form MGT 14. And managing director is also a director, hence I'll also file the form DIR 12. Managing director is also a KMP, hence I need to file form MR1. If at all I need to take the approval of central government, I need to file form MR2. Remember this, very important. Okay. Next one, additional conditions prescribed in Schedule 5 of Part 1. What is this, people? Always remember, in Companies Act 2013, there has been one schedule which is clearly given. When you want to appoint a managing director, there are two parts, people. One is called as Part 1, which speaks about appointment condition. Part 2 speaks about remuneration conditions. Now, what does that say? Now, see, there is Schedule 5. We have something called Part 1, Part 2. This Part 2 has been further classified into this 5 schedules. 5 sections. What does it say here? Part 1, conditions to be fulfilled for the appointment of a managing director without the approval of central government. Without approval, how to appoint? Yeah, so you should have not done any of this disqualification. If you are disqualified, then you need to take central government approval. Next one, Part 2, which speaks about remuneration. What is it? We will see when it comes. Okay. Now see, what does it say? You should have not been sentenced to imprisonment even for 1 day. Or you should have not been coming under fine exceeding 100,000 rupees under 19 acts. All your act is there, people. Your SEBI, Competition Commission of India, FEMA, every act is there. So even if you have made to pay a fine of any amount more than 1,000, so 1,001 rupees if you have been set to pay, then people, they are telling you that you are disqualified to become a managing director. So you cannot do it without central government's approval. Next one. If you have detained for any period, people, even 1 day, under conservation of foreign exchange and prevention of smuggling activities, coffee posa, even for 1 day if you are arrested, people, you cannot go for a managing director appointment. You should be a resident of India, and people, this condition will not apply to SCZ. Now that is my 196. If I satisfy these conditions, sir, and remember, what is it? If appointment of managing director, whole time director, manager, if it is not approved by the company in general meeting, any act done before such approval should not be deemed invalid. What do I mean by that? See, first the managing director, because he is a KMP, he will be appointed by the board. But only if you are a managing director, your approval will mean your appointment should also be approved by the general meeting, by the shareholders. Now imagine we appointed but they rejected. But for this general meeting to happen, let us imagine we took 1 month or 2 months. In the 2 months, whatever activities you did, it will still be binding on the company. That activities will not become invalid. Possible exam question, remember and go. Now people, let us come to the overall maximum managerial remuneration paid to the employees. That is your managing director. How much, sir? Now that is given people in section 197. Now what is the maximum overall remuneration that we can pay people? The maximum overall remuneration that we can pay depends upon whether we have profits or we don't have profits. Now let us imagine in our company we had enough profits during the year. We had money. We don't have any problem. If you have money people, then what is the maximum remuneration you can pay? See, first the director is entitled. For the managing director, manager, whole-time director, they are telling you the maximum remuneration we can pay people, all the employees put together, I cannot pay more than 11% of the net profits of the company for that financial year. Everyone put together. So the maximum managerial remuneration we can pay when we have profits, all the directors put together, executive and non-executive, everyone put together cannot be more than 11%. Sir, what if I want to pay more than 11%? Take shareholders approval. Sir, this is for all. What about one managing director, one whole-time director, one manager? Each of them can be paid up to maximum 5%, not beyond that. Sir, what if I want to pay? Pass special resolution, shareholders approval. So this is for one. So what if I have more than one managing director? So if I have one managing director and 3 whole-time directors, everyone put together cannot be more than 10%. That means what? If one director got 5%, the rest of the directors, everyone put together, you guys have to distribute 5%. So this will be probably for 3 people. Are you getting the point? Okay. Sir, I want to pay more than 10%, same thing, special resolution. Next one. Sir, what if I am not a whole-time director, managing director or manager? That means what? I am a non-executive director. Sir, in that case, how much will I get? They're telling you people, directors who are neither managing director nor whole-time director, then they're telling you, I will get 1% of the net profit of the company if we have a MD, whole-time director, manager. So the maximum we can pay is people 1% to the non-executive director. Sir, what if I want to pay more than that? Special resolution. Sir, what if we do not have, where there are no managing directors, whole-time directors or managers, there is no one. In such case, how much you will pay? You will pay us 3%. Is it per person, sir? 3% is everyone put together. That's the maximum we pay. Is this clear, all of you? Yeah. This also, directors who are neither, for them 1%, here it is 3%. I hope it is clear now. If I have to put everything in together, people, all the directors put together, I can put it like this. Executive director plus non-executive director will be 1%. If a company only has non-executive directors, everyone put together is 3%. If a company has executive directors only, the maximum you can pay is 10%. One executive director can be paid up to 5%. If a company has executive director and non-executive director, then everyone put together is 11%. But the bifurcation will be executive will take 10%, non-executive will take 1%. I hope this entire chain is clear. I can pay more than this provided I take special resolution. Done. Sir, this is when we have profits. What if we don't have profits? Whenever you don't have profits, people, then what we will do? See, now this is when we will go to this chart. See, remuneration payable by the company is having profits. This is what is given in section 1. Now, what if I don't have profits? If I don't have profits, people, I will pay as per section 2. Now, section 2 also is further classified into 2 parts. One is called as limit A, one is called as limit B. What is it? I'll tell you. Yeah. Now, when we don't have profits, what is the maximum remuneration I can pay you, people? The maximum remuneration I can pay you depends on my effective capital. What is effective capital? Effective capital, just pause for a while. This is the the formula for finding out my effective capital. So once you calculate this, you will get effective capital. Once I have my effective capital, now what is the maximum remuneration I can give? It depends upon who you are. Are you an executive director or a non-executive director? If you are an executive director, you will come here. If you are a non-executive director, you will come here. So when I don't have profits, then what is the maximum remuneration I can give? They're telling you if my effective capital is negative or less than 5 crores, less than, that is 4.9999. In such case, the maximum I can give per year, per person is 60 lakh rupees. Per year, per person. Sir, what if I am a non-executive director? If you are a non-executive director, then we will pay up to 12 lakh rupees. Next one, sir, 5 crore to 100 crore, 84 lakh, 17 lakh. 100 crore to 250 crore, 120 lakh and 24 lakh. Everything is here. 250 crore and above. They're telling you 120 lakh plus. So for the first 250 crore, you will give 120 lakh plus 0.01% of the effective capital in excess of 250 crore. That means what, people? Imagine our effective capital is coming to 300 crore. For first 250 crore, it is 120 lakh. For the rest of the 50 crore, I will calculate 0.01 percentage. Whatever comes, that will be my total remuneration I can pay to the directors. Sir, can I pay more than what is given here? Of course. Only condition is pass special resolution. That's all. Done? Yes. Sir, what if it's part of the year? If it is part of the year, take it pro rata. That means what? 60 lakh is for year. If it is per month, do divided by 12. What is the number you get? That is the number. Next one, sir. Sir, now you just said this is limit A. Okay, we limit A. So I hope you are understanding, people. Schedule 5 first has total 4 parts. Part 1 speaks about appointment. Part 2 speaks about remuneration. Part 2 are further classified into 5 sections. In that 5 sections, section 1 speaks about whenever you have remuneration, what is the maximum you can pay. That is 11 or 10 or 1 or 3 and all. Section 2 speaks about people when you do not have you do not have profits, what is the maximum remuneration you can give. Now that depends on people whether is it coming under limit A, limit B. Limit A is for your regular directors. Limit B are those directors who are appointed in a professional capacity, meaning they can be your doctors or they can be, imagine a company secretary. For his experience, he's been appointed as a director. Now for them, can we pay this salary? Is it allowed? Can we do it? They are telling you, people, you can pay them. It is allowed. How much can we pay them, sir? Remember, limit B does not again tell a new limit. Limit B says if at all he is a managerial person working in a professional capacity, then you can pay them remuneration as per limit A, provided they need to satisfy certain conditions. Now, what are the conditions that the person has to satisfy? The condition that the person has to satisfy is, now what is that? Okay, what does it say? See here, the managerial person functioning in the professional capacity, the remuneration can be paid as per limit A. When if that person is not having any interest in the capital of the company, holding subsidiary company, that means what, sir? Now imagine I have elected a person A to be paid as remuneration as per limit A. Now can I pay him? Yes, it's you can pay, provided what? He should not have any shareholding in our company. Sir, what if he has ESOPs? Okay, ESOPs are there up to 0.5% of the shareholding I will exempt. If he is having 1% in all, people, no, he is disqualified. He cannot come under this particular limit. Now, point 2. He is not having any interest or related to the directors or promoters of the company holding subsidiary during the last 2 years or after the date of appointment. You should not be related to any of my company or subsidiary or holding directors or promoters. You should not be related. So you should be a random outside person. Next one, you should have a graduate level at least qualification, because I'm paying you in professional capacity. Not only that, people, whichever is the industry that you are working in. Let us imagine if I'm working in the industry of, I don't know, now I'm a doctor. Specialized knowledge, meaning I can say I should have MBBS there. Specialized knowledge. If all these conditions are satisfied, I can pay that person under the professional capacity. I can pay as per the limit A. Clear? But remember, end of the day, whether you want to pay as per limit A or you want to pay as per limit B, you need to satisfy certain conditions or approvals. What is it, people? To pay a person as per limit A or B, such things has to be first approved by people, the board of directors and the nomination remuneration committee. The company has not committed any default in payment to the bank, PFI or non-convertible debentures or secured creditors. If at all there is any default, you need to take prior approval. What do you mean by that? For any financial institutions, you should have not committed any default. Say, you have not given the loans back, and if you are giving them salaries more, who would accept? So to give such salaries, people, you need to take prior approval. Next one, people, to pay anyone as per limit A, you need to pass ordinary resolution. Sir, if I have to pay anyone as per limit B, you need to pass special resolution. Remember that. That means a person working in professional capacity mandatorily requires a special resolution, and such resolution will be valid for a period not exceeding 3 years. Next one, all the details about such person should be disclosed in my explanatory statement. Calling them for a meeting. Shareholders I'll be calling. No, I have to disclose all these details. Remember and go. The next one, people, let us take section 3. What is section 3? Now go here. Remuneration payable by companies having no profit or inadequate profit in certain special circumstances. What do I mean by that? Again, here also there is no profit. Here also there is no profit. But still you can pay remuneration, it seems. Even when you do not have profits, you can still pay. When? Certain special scenarios. What are special scenarios? First one, such excess remuneration is paid by some other company, not my company. Which is that some other company? It can be a foreign company or it can be any other company, provided such a company has taken its shareholders' approval in general meeting, and that company has to treat this as a managerial remuneration as per their section 197. Sir, we didn't understand. Imagine, people, there is company A, company B. Can I have my director being appointed in my subsidiary company also? Possible? No. KMP can be a KMP in the subsidiary company. Possible. You can be an MD in 2 companies. Possible. Now imagine the salary is given to you by A, not B. Allowed. So if you are not, so if company B is in losses, it's okay. You pay. Company A can pay, provided they're telling you, now they have to treat this in their overall managerial remuneration of section 197. 11% limit and all, they should treat it. Allowed. Understood? Okay, next one. Sir, in the case of newly incorporated company, up to 7 years of the date of incorporation, if not, no one will join you. Allowed. In the case of sick companies, today's date, this and this will not exist anymore, people. But these were nothing but companies who are struggling to exist. Sir, if they are struggling to exist, then why are you allowing to pay directors' remuneration? Don't pay them. People, if they don't, if they are not there, then who will work for you? Who will make your company revive? So they should be there. You find ways to pay them, that's all. That is what they are telling you. So for a period of 5 years from the date of sanction, but today SIG company and BIFR and all almost does not exist. Today what exists? NCLT, IBC plan will exist. So if a company has been approved by a resolution plan, so under a insolvency and bankruptcy code, you can pay them, people, up to 5 years allowed. Is this clear? In addition to that, to pay the excess remuneration as mentioned above, remember, except in the case a managerial person should not be receiving remuneration in any other company, only in one company you have to be receiving, that is from here to here. This is an exception. The auditor or a CS or a PCS should certify that all the creditors and the lenders have given the approval for such payment. It should be filed in the form MR1. They shall also certify that there is no default on payment of creditors and deposit holders. So there is absolutely no default, we have to certify. Is this clear, all of you? Okay. Now go to section 197. What does appointment say? Let us see that section completely. Okay, 197.1, when you have profits, that percentages we saw. Okay, next one, 197.2, remuneration does not include sitting fees. Remember, whatever is the overall remuneration, that does not include sitting fee. What is the maximum sitting fees you can pay? The maximum sitting fees people cannot exceed 1 lakh per meeting. Next one, 197.3, in case of absence or inadequacy of profits, what to do? We just saw. That is a limit we are seeing as per Schedule 5 and Part 2, Section 2. Correct? Next one, sir, 197.4. We saw sitting fees is not included in the remuneration. No, what else is not included? Where is the insurance? Go to the insurance part. Any premium paid on the insurance. Remember, people, for the directors, people, we generally take D&O insurance. No, whatever is a premium paid, company will generally take the insurance. So they're telling you the premium amount will not be calculated in the director's salary. That is on the head of company only, it seems, provided if any director is caught, whatever is the insurance paid by the company on behalf of the director, that will also form part of their remuneration. Until you are not guilty, then it will not form part of your remuneration. So remember this and sitting fees. Next one, sir. Sitting fees we saw 1 lakh per board meeting. Remember, independent director, women director also should be given sitting fees. Mode of payment of remuneration, you can give it monthly as percentage of net profits, partly by both are allowed. Sir, if such director is paid excess remuneration without approval, can we pay? If you have paid by mistake, remember, such a director should hold it on behalf of the company in trust, and you need to repay such excess paid within 2 years time. Yeah, maximum is 2 years. Until such money is refunded, you need to hold that entire money in trust. Sir, what if we don't want to refund? He is not agreeing. Then can we waive it off? They're telling you, people, the waiver of excess money, it is possible provided you pass a special resolution. So if I have to connect one more point here, people, section 180, subsection 1, clause D. If at all you want to waive off any excess remuneration paid to the directors, you can waive off, provided you cannot do it only by a board approval. You need to also pass a special resolution that is required. Remember this. And remember, if at all you have taken any loans, and if you have made any defaults in the loans, people, remember you also have to take the approval from your banks, PFIs, creditors, as the case may be. 197.12, what does it say? Disclosure in your board report. Whatever we saw in our previous chapter, we also have to disclose about our majorly, people, our top paid remuneration employees. And has the company been wise enough when you are giving remuneration to your employees? That means what? Now imagine, people, in my company there are 100 employees. Arrange them in a lower to higher order in terms of salary. Imagine we have a employee who is getting 10,000 and we have an employee who is getting 5 lakh per month. Arrange them in the lower to higher number, ascending order. Now whoever is the mid, now let us imagine we have the 50th sum. Now what you need to do, you take the mid salary, that is only called as what, people, median remuneration. You need to give a comparison in your board's report. How much has our 50th employee salary increased, and how much has our managerial directors, our managerial person, how much has their salary increased? Give it in percentages, give a comparison, you give, that is something which you need to give, so that the shareholders understand when they are reading, has the company directors working wise, or their salaries are increasing 20% but their salaries are increasing 2%. Especially you would know, no, whenever there is a hike season and all. That is what they're telling you. See, the ratio of remuneration of each director to median remuneration, you have to give a comparison ratio. Percentage increase in the director, CEO, CFO, CS and the median person. Comparison of percentage increase. How much this increased, how much this increased. Board reports shall also include the names of top 10 employees in terms of remuneration who, if you are employed throughout the year, if you are getting a remuneration of 1 crore 2 lakhs, remember not 20, 1.02 per year. Sir, what if I'm not employed throughout the year? Then do divide it by 12. That is 8.5 lakh per month. If you're getting that salary, I need to disclose the details about such a employee. What you need to disclose? You will disclose all the designation, what are they doing, what was their previous employment, are they getting any shares also? I disclose everything. What else I disclose? Who drawn remuneration in excess of that drawn by MD holds along with spouse not less than 2% of the shares of the company. What do you mean by that? I'll also disclose the details about those employees who are drawing salaries more than managing director, whole-time director, manager, and people. They are also shareholders of at least 2% in that company. They have shares. Along with the relatives. You need to disclose the details of such particular employees also. Clear? Okay. Penalty, leave it, it's okay. And one more thing what we need to do is, let us do the section 202. Compensation for loss of office. What is compensation for loss of office? First we'll do a 199. Where is 199? What is 199 people? Whenever in a company, if at all, let us imagine, there is something called as restatement of financials, no? My is not coming, search is not working, array, no. Okay, recovery of managerial remuneration in certain cases. Let us imagine people, according to section 130 and section 131, what is this? Restatement of financial statements either by the order of the authorities or voluntarily. What happened people? In the year 24-25, we have paid our directors. Imagine one executive director was paid 5% of the average profits of the company. Now in the year 2028 people, we got to know that in 24-25 we had inflated our financial statements. So our profits were showing more number than what it was supposed to show. Now what happened? We have given our executive director 5% on the inflated profits. Now when it is revised, this will also go down, no? Now we have paid extra. What to do? They're telling you, you can recover that extra amount. Absolutely possible. That is what they're telling you. That is section 199. See, this section provides for recovery of remuneration, including stock options, if any, where the amount is given in excess, and the refund is happening because of restated financial statements. Is this clear? That's all. So you can take a refund of it. So next one's are compensation for loss of office. Section 202. Let us do of that one particular section. Section 202. So I'm just taking all the important aspects instead of just dumping. See, they have given the role of company secretary and all that you guys can manage. But this one, at least it is good for you to at least revise once. Okay, compensation for loss of office people. This condition is only and only applicable to a managing director, whole-time director, manager. What if I remove a company secretary? Will he get a compensation for loss of office? No. Will any other director, non-executive director, will he get? Answer is no. That is one place where they can question you. Next one, people. Compensation shall not be paid in the following cases. When the director resigns due to reconstruction or amalgamation, what happened, people? Imagine Vodafone Idea came together. The Vodafone Idea, the new entity, offered a role to you, but you denied. That is your headache. We offered you. So we have not removed. So I will not be entitled to give you any compensation. Next one. When director resigns from his office, you resigned. Why will I give? He is vacated as per 167. Disqualification. Because of that you are removing. Why should we give a compensation? Company is being wound up, and that too because of your negligence only. Why should we give? Director has been guilty of fraud or breach of trust or negligence or mismanagement in conduct of affairs of the company holding subsidiary. Basically, people, you have done fraud. Who will give the compensation to you? Director has instigated in termination of his office. Any other purpose, people, but the reason why you are leaving is because of your action, not because of mine. In such case, I am eligible to get a quantum of compensation. How much will I get, people? First, you need to counter for how long I have been appointed. I have appointed for 5 years. Okay. How many years is done? Let us imagine 1 year is done. 4 more years is there. Okay. What is the compensation I'll get? I'll get for 4 years or 3 years, people. Whichever is less. So I'll get compensation for 3 years. Okay, how much will I get? You will always get, people, your 3 years, last 3 years average salary multiplied by whatever is the duration. That means what, sir? Let us imagine, sir, I have completed 3 years. What is my remainder? 2 years. 2 or 3, whichever is less. Which is less? 2. For you have already completed 3 years remuneration. Take average. So that 3 years average multiplied by 2 years. That is what is the remuneration you are going to get. Next one, no compensation shall be paid if the company goes into winding up 12 months before or after the date of director ceases to hold office. That means, people, if the company itself is going to winding up, people, before or after, once you leave the company, why will we give compensation? We are only under a loss. Yeah. So this is your main essential thing under your audit and all. I think we did it there only in the past. So these are the main things, people, that you guys need to know with regards to KMPay. So I believe with this we have completed whatever is the maximum in detail marathon I can do. I have done, people. Now the ball is in your court. Please make use of it, and the only thing that matters is whether it helped and whether you're able to achieve what you guys want to achieve because of that. Do let me know if you guys want any additional help. Whatever is possible, I'll at least try, but I would know what you guys in specifically want. So do keep me informed on that. You can comment, you can let me know. I'll be more than happy to help you in those regards. Yeah. So, yep. Thank you so much. See you all. Wishing you guys the best. Let the best happen to you always. If you guys clear, do find a way to reach us out. Do let me know whether you are my student, you're not my student. A positive result will always put a good smile on us. Yeah. So we would also be that first people to celebrate your result along with your loved ones. So thank you so much. See you all, people. Bye bye. Take care.